Morning, everyone. Auditor General, you're still bound by your affirmation. You haven't got to take the affirmation again. Yes, Mr. Howard.
Thank you, Commissioner. Before we continue with the Auditor General's evidence, can I, for the transcript, just introduce the representation in the room? This morning we have, on behalf of the Attorney General and the elected ministers, the Solicitor General Joanne Williams-Roberts, and also Nikki Olympitis here from Withers BVI. Andrew Gilligan of Martin Kenny & Co. is present as an observer. The remaining participants, which are those represented by Silk Legal, are not represented either in person or online.
Thank you.
If I continue now, Ms. Webster, thank you for coming back. Yesterday we were going through a number of your specific reports. And if I may, I'd like to just take you to another one of those reports, which you will find in part 2 of the bundles at page 909. We looked yesterday, when we were towards the end of the day, at the audit report that you produced on the COVID-19 stimulus grants to farmers and fisherfolk. You have also, if we go to page 909, your office has produced a report dated the 21st of June 2021, and it's on COVID-19 stimulus grants to religious institutions, civic groups, private schools and daycares.
That's correct. Yes.
And can you just confirm that this is the final version of the report, finished, and in the form it's been submitted?
It is, sir.
Thank you. Just again, if I could ask you, you're very softly spoken, but if I could ask you just to speak up a little bit, it'd be very helpful. Thank you. Can I take you through some aspects of this report? If we go, please, to paragraph 1, which is at page 914. You set out at paragraph 1 the purpose of the audit, and you say the audit covers the activity related to religious organizations, schools and civics groups grant initiative undertaken by the government in response to the negative economic impact resulting from COVID-19 shutdowns. And then you go on in paragraph 2 to explain that the purpose of the audit was to provide independent information and advice on whether approved procedures were followed in the adoption and execution of this stimulus program, whether the objectives of the program were achieved, and whether the funds were applied with due regard to the principles of value for money. In doing that work, your office obtained documents and files from the Ministry of Finance, the Cabinet Office, the Ministry of Health and Social Development. You also obtained verification of payment activity through the Treasury system, and you conducted interviews with members of the assessment team. So are those public officers who were asked to assess applications for grants?
Yes, that's correct.
At paragraphs 5 and 6, under the heading restriction of scope, you say this, Auditor General: the Auditor General's office was unable to obtain the relevant files and information from the Premier's office pertaining to the COVID-19 stimulus grants, which were repeatedly requested by email and telephone. This includes access to databases, documents, reports, and other information relevant to policy development and implementation of the programs. The refusal to present this information is in direct contravention of the VI Constitution and the Audit Act, which provide for this office to have access to government documents and records. No public officer expending public funds has the authority to deny information requested for audit purposes. When we looked at the report in relation to farmers and fisherfolk, you made exactly the same point in that report. Were these two audits conducted in parallel?
They were, yes, sir.
And please add to this if you consider it will help the Commissioner. But in effect, did you encounter exactly the same resistance from the Premier's office as you had in relation to farmers and fisherfolk?
Yes, sir, exactly the same resistance.
And you used the word deliberate yesterday about the farmers and fisherfolk audit.
Yes, sir, I did. I used the word deliberate with respect to the audit of stimulus funds. And I explained why yesterday I used those words, used that word. And it related to a pattern that we saw with respect to not providing information. And basically, what I viewed as an attempt to delay the audit process or impede the audit process. I say this because the information that we requested didn't in any way, or could not in any way interfere or impede their work. And we always say this, when we request information, we do a job in a way that does not interfere with the department's processes. The department is working with a file and we need it, we would take the file for a couple of hours, sometimes a couple of days, but if they're using it, it would be a couple of hours. We would extract what we need and we would return that file. If the file is active, we may have an officer sit in the department and work with that file. We always try not to impede or get in the way of a process, a department doing its work. And that's consistently so. That has always been the case. And departments know this. If we take a file and they need it, they request it back and we return it. And there's documentation to show the transfer of documents, the transfer of files between my office and the various departments that we're working with. But at the very bottom of this, in order for us to do a job, we have to get information from the departments. And again, I would like to repeat that this is public information.
And was there, you say that you obtained documents and files from other ministries, including the Ministry of Finance and the Cabinet Office.
Yes, we did.
Did they experience any difficulty, those ministries that you list here at your paragraph 3, in providing you with information, documents and files?
No, no difficulty. No difficulty was reported. We received the information primarily electronically, which works for us because then we don't have to produce a lot of paper, go through a lot of paper, and more members of staff can use the same information at the same time if it's electronic. And we haven't gotten any complaints from those 2 offices or any other office that they were impeded by us having that information.
Was there any delay in those offices providing you with the information you requested?
The only delay would have been in compiling it and sending it over. But aside from that, we got no resistance from the Ministry of Finance. And I'm speaking to the recent request that we made for this particular audit. There was no resistance from the Ministry of Finance and there was no resistance from the Cabinet Office. It was simply forwarded for the request.
I mean, and the 3rd ministry you mentioned is the Ministry of Health and Social Development. So I assume there was no resistance from them either.
The Ministry of, there was no resistance from them, but the issue with that was that we were told that they were not involved in the process. And in fact, they were not involved in the issuing of the grants, but initially there was some involvement. And when we eventually got back to them and requested the information, it was forwarded.
You say that information from relevant files and information from the Premier's office were repeatedly requested by email and telephone. Were you given any reason as to why your requests could not be agreed to?
Initially, we were not given a reason, and subsequent to that, the permanent secretary sent a message, an email saying that the internal audit was working on it and working on the same areas, and that when they were through with their audit, then we would have access to the information. And as I mentioned yesterday, when we were told that, I simply said to her, well, first of all, I should say that we are used to work in conjunction or parallel sometimes with internal audit. And if they're working on an area, we allow them to do their work. And then if after we've seen their report, if we consider that we need to go in, we would also go in. In a case like this, where we're working on the same subjects, but for different reasons, we actually share information. They had at the time they had the Treasury vouchers in their office. So we would actually go there and get what we needed at that time that was relevant to what we were doing. So we share information. When we were told that internal audit is working on this, and when they're finished their report, we'll let you know when you can get the information, I simply said to her, well, okay, provide us with access to the databases, because that does not interfere with internal audit processes, and it does not interfere with your office processes. Access to the databases and access to the other information that they have, because what we're getting from the staff within the ministry is that they were instructed not to forward the information. So in other words, tell your staff that they can forward the information as required, as long as it doesn't provide a conflict with internal audit. That is a concession that I don't have to make. And
concession that you did make.
Yes.
So were you trying to find a pragmatic way through this?
Yes, we were trying to find a way to work with everyone involved. And still, we were not able to get anything out of that particular ministry. And I should mention before I go on, we are also, in terms of reviewing the stimulus grants, we're also looking at the grants that were issued to SMEs, businesses, and I mentioned this yesterday. And initially, we were given access, I think by the department, to look at the applications that came in, the application database. And that suddenly went blank. When we inquired with the department why it was no longer available.
What you make is that staff from the ministry were told that they've been instructed by the permanent secretary not to send you information. And that's the minute where you say the ministry there, that's the Premier's office.
That's the Premier's office. Well, that's the Premier's office and the department that fell beneath the Premier's office, which would be the Trade Department. What we were told, in fact, when the information was removed, the access was removed, is that we need to talk to the permanent secretary. And the permanent secretary's response is that internal audit is looking at this. And internal audit will speak for itself when it comes here, but I know that they had issues actually getting information from the Premier's office.
And you then spoke about a department where you had access to information and then it was shut off and they were told it was the permanent secretary to the Premier's office that had done that.
Yes.
Which department was that?
The Department of Trade.
And does that sit under the Premier's office?
It does, yes.
There is one linked matter to this that I should have asked you about yesterday, and that's just the process of producing these reports. So you will obviously do the audit.
Yes.
Is it right? You produce a draft report and then you give those who have an interest in the content of the report an opportunity to respond?
Those within government, and they are, if they are dealing with other individuals outside of government, it's their responsibility to get feedback from those individuals with respect to those areas. But yes, we send the draft report to the ministry or department that is that has been audited.
So this one, which is the Religious Institutions Audit Report and the Farmers and Fisherfolk Report, who did you send the draft to?
The draft was sent to the Premier's office. A copy of the draft was also sent to the Ministry of Education, Culture, and et al. A draft was sent to the Ministry of Finance. I think those were the three entities that received a draft of this report. Oh, I'm sorry. It was also sent to the Department of Agriculture, the Director of Agriculture and Fisheries.
And the recipients are then able to submit responses to you?
They are, yes.
And do you give them a set amount of time to do that?
Yes, we normally we give them 2 weeks to respond. And in this case, it was extended to 4 weeks.
So on these two reports that we've been looking at, they had a month to respond in.
On the Farmers and Fishermen's report, they had a month to respond. The second report that dealt with religious organizations and schools, it was more, I think, 2.5 weeks, close to 3 weeks, because that went out after. But with the extension, I asked that both reports, the responses for both reports come in at the same time.
if we look at, you don't need to turn it up, Auditor General, but the farmers and fisherfolk report has some appendices attached to it, but the actual report itself, if runs to just 15 pages, doesn't it? If you go to page 862. So that's the front cover of the report. If we go to 864, which is the contents list, there are obviously appendices, but they're all tables, but the actual text.
It starts at 869.
Yeah, so go to 864. That's your contents list for the Farmers and Fisherfolk report. And taking it down to, from the start, the executive summary through to recommendations, it's a 16-page report plus appendices. And your appendices are essentially tables. When we go to the stimulus grants to religious organizations and schools, that is a 8-page report, is that right?
That's correct.
So they're not very lengthy reports.
No, they're not lengthy reports.
So do you consider that you gave the relevant ministries and departments sufficient time to respond to your 2 reports?
4 weeks is more than sufficient time to respond to the Farmers and Fishermen report. The findings are pretty straightforward, and in terms of getting information to respond to these, it's all the information is in the Premier's office. She's in a position to actually look this up and respond to us. So from where we sit, 4 weeks is more than sufficient, and 4 weeks is what we normally would give to a department that has a substantial report that involves a broader topic. This is one topic, and a lot of times, most of the times, a report would have several topics in it. This is just farmers and fishermen, and from where I sit, 4 weeks is sufficient.
Let's go back, please, to page 914. And just to finish off this part of the questioning, but it's your position, isn't it? It's your understanding of the Audit Act that no public officer, and you've made this point, no public officer has any basis to refuse to give you any document or file that you seek. Is that right?
That is correct.
Thank you. If we go now to 915 and look at 8 and 9. In paragraphs 8 and 9, you set out the purpose of the stimulus program that was set up, and you say, to cushion the impact of closures, the government announced in May 2020 that it would be allotting funds to assist daycares, preschools, private schools, and religious organizations with the costs relating to reopening and compliance with health protocols. At the end of July, organizations interested in receiving assistance were asked to complete an online application survey to allow for an evaluation of their individual needs and that of the sector as a whole. Now, you go on in your paragraph 10 to explain that the initial proposed amount for the grant program was $1 million, which was increased via cabinet by an additional $1,392,818. So the total budget for the grant program came to $2,392,818. What you say, though, if you look at paragraph 13, is that a cabinet decision of 8th of July 2020 required that a committee be established with responsibility for structuring and administering the grant department. Now, Was this a committee of cabinet? Were you able to establish what kind of committee it was?
No, it was not a committee of cabinet. It was a committee of selected persons from the various departments who would come together and put together the policy and recommend how the program should be administered.
So was it a committee compiled of public officers rather than elected ministers?
Yes, it was a committee of public officers.
And did it include someone from the Premier's office, do you know?
It did, yes.
And you say that the committee produced a policy document which stated that the intention of the programme was to support the continued operation of the institutions and assist them with compliance with COVID-19 health and safety protocols for reopening, and also indicated that all institutions that had reopened after the COVID-19 shutdowns would qualify for some level of grant award. Now that's the context of the programme and the scope of your audit. Can we look at your findings, please, which start on the next page at paragraph 15. The first finding that you've made in your report is that the recommended grant awards were adjusted without any effort to maintain the apportionment within the available budget. So could you just clarify that a little for the Commissioner, and particularly by reference to the table that we have at 17. In what way were the recommended grant? Firstly, what were the recommended grant awards? And secondly, in what way were they adjusted?
Right. The committee would have reviewed the applications, and my recollection is that applications actually had information with respect to the entities and the expenditure and revenue and potential losses for the period. The committee would have looked at those and compiled the information and made recommendations as to what they thought the individual institutions should be awarded. And at the end of their process, they were able to come up with a table where the $1 million, which was the initial amount, $1 million was divided among the religious institutions and the schools and daycares and civic groups. What happened after that? That submission was actually then sent to the Premier's office, and the amounts were changed within the Premier's office. The committee, for instance, recommended that $185,000 would be awarded to religious institutions, and that was changed to $1.4 million in the Premier's office. They recommended that schools and daycares would get $788,000. That was changed to $907,000. Civic groups, they recommended $25,000, and it was adjusted to $0, but the actual amount that was paid to civic groups, notwithstanding, was $55,000. And the adjusted amounts that I have here are actually not the amounts that were paid, because these adjustments are what was sent to Cabinet. So we have the committee recommending $185,000. Cabinet was asked to approve $1.4 million, and the actual amount that was paid after Cabinet approved $1.4 million was actually $1.5 was paid. Again, the committee recommended $25,000 for the civic groups. Cabinet did not approve anything because nothing was submitted to them to approve for civic groups, but civic groups were paid $55,000. So the recommendation was $25,000, they were paid $55,000. Schools and daycares, the committee recommended $788,000. It was adjusted by the Premier's office to $907,000. And the actual payments was $892,000. And this is at the time we wrote the report.
And for your office, the information gap is between the recommendations made by the committee and what went to Cabinet. because that information sits in the Premier's office, and the Premier's office has not given you that information.
That's correct. We had no way to assess why they had changed the amounts and why they had been changed so drastically. 108 from 185,000 to 1.4 million dollars, for instance, for religious institutions.
So sitting here today, Auditor General, you're in no position to assist the Commissioner with what criteria may have been used in the Premier's office to reassess applications.
I am in no position to advise you as to what changes occurred in the Premier's office or what criteria was applied to this to effect these changes, Commissioner.
We may come back to that, but let's go to your second finding, which we see at paragraph 18. What you say in relation to religious institutions is that the grant award, and this is, I think you're breaking down the detail now. The grant award for religious institutions increased by 662% over the recommended amounts. No criteria was made available for this increase. 80% of the religious institutions did not apply for assistance. These were nonetheless approved to receive grants totaling $1,060,000?
Yes, that's correct, sir.
And so just to summarize it, religious institutions were able to make an application for grants.
That's correct, sir.
The committee set up by Cabinet assessed the grants and made a recommendation as to payment.
Assessed the applications.
Yeah, right. Thank you for the correction. That's very important. But so they assessed the application, made a recommendation. It then went to the Premier's office. What happened there, you can't say. But the result was that then Cabinet approved an increased sum, which included funds that went to religious organizations that had never made an application.
That's correct.
So that it went to organizations or religious institutions that were never considered by the committee set up by Cabinet.
They were considered by the committee set up by Cabinet.
It's perhaps, if you clarify for me, it's the finding that 80% of the religious institutions did not apply for assistance. And it does that.
Okay, the committee's process, in their process, they received information from the ministry, the relevant ministries on schools and daycares. So they had a list of all the schools and daycares, and which is why they're able to say 80% did not apply. And the policy was that whether or not, well, the policy was that all institutions, once you reopen, would qualify for a grant award. But what they did is schools and churches that did not apply were given a nominal amount to assist perhaps in the reopening expenditure. So because they hadn't expressed any real interest in being a part of the program, they were still awarded a nominal amount. Take this, you can buy hand sanitizer, you can set up a hand washing station, so that was the plan, that was the intent of providing that nominal amount. But when it went to the Premier's office, the amounts changed significantly.
I mean, what you say is that the grant, this is at your paragraph 27, you say, and this is, you describe it as the ministry's adjustments, and that's the Premier's office, but what the committee had recommended in relation to religious institutions and civic groups was a total grant of 211,000 odd dollars.
Right.
And then that increased sevenfold when it went to the Premier's office.
That's correct.
But and those were then forwarded to Cabinet for approval, but 15 institutions which were characterized as civic groups were not included on the list at all.
That is correct, yes.
So there were institutions that had been assessed for a sum that, following whatever happened at the Premier's office, got even more money, whilst there were others who had similarly been assessed as having a justifiable application that warranted public funds. After the Premier's office effectively were in a position where they weren't going to receive anything because it wasn't being sent to Cabinet for approval.
That's correct. And to illustrate what I just said about the non-applicant church actually receiving.
Are you looking at one of your appendices? Do you want to tell us which one it is?
Yes, it's on page 921.
For the transcript, this is Appendix 1, the religious institutions summary. Was there a particular one that you wanted to draw the Commissioner's attention to?
Right, at the top you see the applicants, these are the applicants, and then right underneath that, non-applicants. And it starts out with the first one was recommended by the committee to get $2,000 and they were awarded $15,000. The second one was, these are the non-applicants, was recommended to get $1,200. And that institution was awarded $20,000. And so this is what is meant when we said that the amounts were inflated without any kind of, without any reference to a criteria. And the churches that did not apply simply awarded some large sums without any kind of documentation to say whether they actually had suffered any, or what level of inconvenience they had suffered as a result of the shutdown.
And what level of financial reduction that they'd suffered as a result of the shutdown. And because all of this comes out of the paragraphs that you've set out, and no reference to the number of members of the church, because some of these churches were very small, with 8 members. One church had 8 members, and consequently the amount per member was a number of thousands of pounds.
That's correct, sir. Yes.
Yes, thank you very much.
And looking at your paragraph 28, Auditor General, what seems to have happened is that the increase in the award was in fixed amounts. So religious institutions got $20,000, $15,000, $10,000 and $7,000.
That's correct, sir.
But as the Commissioner points out, and as you've pointed out, particularly for those that were non-applicants, and when we look at your Appendix 1, the greater number of institutions are non-applicants, aren't they?
That is correct, yes.
There was no documentation on which to assess the needs of any of those institutions.
That is correct.
And so what you say, and this is at page 923,
and I'd like to say for the record that we, in doing this, we were very aware of the fact that the religious institutions had not applied for funding. And in fact, many of them did not expect to be receiving checks. And we didn't want to get them caught up in some sort of government issue. But the fact is that the money had been issued, and we needed to account for this. We needed to be able to speak to it. So we do understand that they didn't apply, they didn't expect to get money, and they didn't expect to be in the middle of a government inquiry. And I just want to put that on the record.
Yeah, I mean, no suggestion of impropriety on the part of any of these organisations. That
exactly.
that they were they were issued government money, and that was somebody else's decision, not theirs.
Exactly.
But to bring the point, I mean, looking at your Appendix 1, in terms of religious institutions summary, of those who made applications, Cabinet approved, and there's a difference between approval and what they actually received, but Cabinet approved $355,000. In terms of non-applicants, Cabinet approved $1,060,000. That's at your page 923. Have I understood the table correctly?
That is correct, yes.
And then the next step in the process was that once Cabinet had approved the sums to be paid out, it was for the Treasury Department to issue the checks. Is that right?
It was for the Ministry of the Premier's office to prepare the documentation for the Treasury to make the payments.
I see. So it goes from committee to Premier's office to Cabinet, back to the Premier's office. They prepare the documentation, and then the Treasury Department issues the check.
The Treasury Department generates the check, which I understand was collected by the Premier's office, and the institutions then had to go to the Premier's office to collect this check.
I see. And are they then more? It appears to be more than one gap in the information trail for you, because you don't know the basis on which the Premier's office increased the sums that Cabinet were to approve.
That's correct.
And is it right? You don't know the basis on which the Premier's office then decided that religious institutions should be paid more than the sum that Cabinet approved?
I do not know the basis of that decision.
But ultimately, the last stage in the process is the Premier's office is holding the check and the religious institution turns up to collect it.
We were told that there were some that did not.
Some did not.
Yes.
But
we were told we were not able to verify that.
But that's essentially the process.
That is the process.
Have we understood
yes.
it correctly? Could we turn to page 918, please, and what you say there about schools and daycares? This is at your paragraph 32, Auditor General. You say the grant award for schools and daycares increased by 15% over the recommended amounts in changes that appear ad hoc and without stated criteria. You point out that compared to religious organizations, or religious institutions, forgive me, the response from educational institutions to the stimulus grant program was more robust. And so 30 of the 32 schools in the ministry's database completed the application survey to be considered for stimulus funding. And where you say the ministry's database, which ministry are you referring to there?
The Ministry of Education, Culture.
But did it go through the same process in that the applications were submitted, they were assessed by the same committee set up by Cabinet?
Yes.
And then once the assessment was made, it then went to the Premier's office?
Yes, sir, it did go through the same process.
And the Premier's office essentially increased the total grant amount for educational institutions and daycares.
That is what happened.
If you look at your 36, what you say there was grant allotment for 11 centres were increased. 7 had an additional $20,000 added to the recommended amount. 3 others were rounded upwards to $34,500 each. One was rounded upwards to $20,000. And then you add that in addition, 4 centres had their recommended grant allotment reduced. And so, but for your audit purposes, you did not have the information which allows you to understand how the Premier's office decided to increase awards and also in relation to 4 centres, reduce them.
No, we did not have the information. We could only observe the changes based on the records that we had at the time during the audit. And these were records from the Treasury and from other institutions, other government offices.
What you summarize the position at your paragraph 38 in a table, and you make the point that there are obviously, at least when we're dealing with school educational institutions, that there is a substantially greater number of applicants. But in both instances, applicants and non-applicants, when the matter went to the Premier's office, the total grants to be awarded were increased in size. Is that right?
They were increased in total, yes.
Yes. So the total recommended by the committee was $788,754.33. The amount that it was adjusted upwards to by the Premier's office was $907,818. But in fact, as you say in the final part of the table, the amount that actually was paid out was less than had been adjusted. Is that right?
It was less, but I'd like to point out that the payments are only up to a certain date. And as the permanent secretary was constantly saying, there was, up until we did this audit, payments were still being made. And there's a possibility that the few that had not been paid will in fact be paid at a later date. I can't confirm that because we didn't get any information from the Premier's office to say that these individuals are not going to be paid. So we have to assume that since they were approved for payment, that payment is going to happen.
I see. So it could, I mean, the full amount, the full 900,000 could have been paid out, because I think the date that you took your figures up to is the 20th of May 2021, isn't it?
Yes, that's correct.
You also make the point, and this is at paragraph 39, that review of the recommended grants amounts submitted by the committee showed anomalies where some smaller institutions were recommended for more generous grant awards than their larger counterparts. And you give an example where a daycare with an enrollment of 10 was recommended by the committee for just under $35,000, whereas a multiple purpose institution, daycare, primary and pre-primary, with an enrollment of 138 students was recommended for just $9,500. And so does that mean that you're identifying that you've identified an issue with the way that the committee, which is the first stage of the process, was approaching its assessment of applications?
That's correct, yes.
And in paragraph 41, you say the anomaly in the grant awards appears to be caused by 2 factors. The absence of a weighing element to factor in the size of the institutions, i.e. number of members, and the committee's acceptance of the costs per member submitted by the entities, some of which could have been followed up and adjusted within reason, which accounted for 60% of the weighing. Could you just add a little bit more detail to those 2 points, please, if you can, or if you want, just to explain for the to the Commissioner, just why these 2 factors are of particular importance to you as the Auditor General?
The committee had, I'm trying to remember, some stated criteria through which they did their assessments. One of the criteria was institution, and they weighed this a department, I'm sorry, an institution, for instance, would be assessed on whether it was a church, daycare, a school, daycare, church, and I'm thinking institution would be primary school, daycare, church, and I'm thinking there's another factor. I don't have that information from it, so I'm just going through this from my memory. So for institution, there were 5 factors. And what we found is that a church that has a school, that has a daycare, could weigh higher than a daycare. Well, a church that has a school, a daycare, with only 5 members, a daycare with 5 members, would weigh higher than a daycare that had 200 members. So I think the intention was for that particular factor to accommodate the size, but because of how the churches and daycares are structured, you can have a very small church that has a preschool with 2 people in it, and a daycare with 2, and maybe a pre-primary with 1 person, and that would weigh higher on that scale than an institution that has 200 members. And because a small church has all those institutions together, it was awarded a greater sum. What they didn't take into consideration was the fact that they didn't take directly into consideration the fact that some schools, even though it was a single institution, would have substantially more attendees than a church that has several affiliates to it with only a small number. I don't know if I'm making this clear, but essentially, the criteria that they had to assess size wasn't effective. And it would have been better if they had had a direct criteria to weigh the size on the number of participants, the number of students, the number of attendees to the church, for instance, rather than having it on the institutions. I can come back to that when I have a little bit more information, because I don't have the criteria right here in front of me.
That's fair enough. I mean, does it sort of come down to this, that the approach was on how many elements there were to an applicant? So if an applicant was a church, had a daycare, had a preschool, that would weigh more heavily in favor. Whereas what wasn't given sufficient attention was the number of participants and an institution was actually supporting.
That's pretty much sums it up. The other factor with respect to the applicants is each entity was required to state an estimate of what their losses were. And for instance, we would have a church that has 100 members stating that their losses was $6,000, and a church that has five members stating that their losses were $20,000. And because those amounts were accepted and put in the database and adjudged, the church that has 5 members claiming that their losses was $20,000, I think one of them claimed that theirs was over $100,000. They would rank higher as an institution in need, as opposed to the church with 100 members that says, well, my losses were, we have, our losses were $20,000 or $5,000 or $100 and something thousand dollars. And I don't think the report actually has a schedule that actually speaks to this, but we do have schedules in the office that where we looked at the assessment and realized that there were flaws in how these were done.
And in terms of the intended process, Cabinet sets up a committee to consider the applications. That's a committee of public officers, so they can only recommend an award. Was the intention at the beginning of this, or was it your understanding that the intention was that if the committee made a recommendation, it would go to Cabinet for approval? Or was it that if the committee made a recommendation, that would be accepted?
Well, the intention has always been that if the committee makes a recommendation, it would go to the Premier's office. And unless there's something that was drastically out of place, then the recommendation would be accepted. In this case, where we noticed that there were anomalies in the amounts, then it was for the information to be sent back to the committee and have them to relook the criteria. And I just mentioned that the criteria was a little bit off, but at the same time, it was set up in such a way that the amounts that were allotted would come back within the budget. So we have $1 million to work with. We set in our criteria and allow that to compute what each institution will get based on the submitted information. And with that, it came back within the budget. So basically what I'm saying is that, yes, there was an issue with the criteria and that needed to be adjusted, and it should have been adjusted. And the committee should have been allowed to make corrections to those grant awards and allowed it to go through within the budget that had been approved.
Could we just go to your conclusion, please? And if I just go through this with you, what you say this in the report. The committee established to develop the policy and procedures for administration of the programme, produce recommendations for grant awards within the approved budgets. The awards were changed in the Premier's office without regard to the available budget, resulting in a need for substantial additional funding. You then say private educational institutions and daycares suffered immediate decline in activity as the territory hastened to mitigate and address its COVID-19 threats. This was compounded by public health COVID-19 precautionary protocols, requiring new spending for reopening and operations. The funding provided served to alleviate some of the costs associated with the COVID-19 fallout. You continue, no clear objectives were provided with respect to the grants awarded to civic groups. These payments were not approved by Cabinet and appear gratuitous as they do not address any urgent public health requirements. I'm going to pause there, and is the issue, just so that we're clear, is that because grants to civic groups, whether they were in the sums that the committee intended or not, did not go before Cabinet for approval. So the decision to award a civic group a particular sum of money just lay with the Premier's office.
That is correct.
If I go to the final conclusion that you make, you say this: religious institutions were affected by the restrictions, but with fewer overheads, appeared more resilient in the reported operational activity. The amounts allotted to religious institutions appear outside of reason, especially as many of the entities did not request funding, and the awards were done without information to perform an assessment of needs, if any. Religious institutions perform important social and cultural roles, which the government should support in appropriate ways. The application of public funds in the manner seen in this programme, with extravagant and unsupported increases in the COVID-19 stimulus grant awards, create the impression of an inappropriate turn to influence these institutions' political independence. Have I understood that correctly as in terms of your final conclusion?
I believe that is clear in terms of my final conclusion, yes.
Is there anything you want to add to that final conclusion?
No, there's nothing I'd like to add to that conclusion.
You again made a number of recommendations. And appreciate that they're obviously, as they were with farmers and fisherfolk, very recent. I just wanted to ask you, just to clarify a couple of points in relation to your recommendations. In the first one, you say the practice of issuing public funds to entities that have not applied or indicated a need for assistance should cease. There should always be an assessment and needs justification in issuing public grants. Now, it may be a very obvious question, but the point about that there needs to be an assessment and needs justification, is that something as an approach that you would say is embedded in the work of the public service?
It is something that should be embedded in the work of the public service. Especially when applying, always when applying public funds.
You then says your second recommendations, government programs should be undertaken by the oversight ministry. This allows for better long-term monitoring and better outcomes. In this case, who was the oversight ministry?
The Ministry of Education for schools and daycare, and the Ministry of Health and Social Development for religious institutions.
And if we take that recommendation across to the farmers and fisher folk, would it be the ministry? It's the agriculture and fisheries component of the ministry.
Right, and the Department of Agriculture and Fisheries, both together.
Your third recommendation is budgets are intended to guide public spending. Every effort should be made to ensure that these are observed in the planning and application of public funds. Where additional funding is required for a programme, this should be adequately supported and the amounts justified within reason. Now that's a recommendation you make in principle, because of course you don't have any of the information and you've not been given any of the information that would allow you to understand how the budget changed so drastically.
That's correct.
Your fourth recommendation is in no instance should public spending compromise or appear to undermine the political independence or impartiality of non-government institutions. As you know, Auditor General, the Commissioner is interested in governance, and taking it back to your role in governance, would you accept this, that impressions matter in terms of the public's perception and public's confidence in the institutions of governance?
Absolutely, sir. I agree with that.
And an approach that creates the impression of an inappropriate turn that affects the political independence or impartiality of non-government institutions is one that should be avoided, isn't it?
At all costs, it should be avoided. Agreed.
Commissioner, I want to move on to another topic. I just want to ask if the Auditor General is happy to carry on, or whether she'd like a short break, but I leave it to her.
Yes, before you respond to that, Auditor General, Solicitor General, yesterday I indicated that all of the reports that were referred to in this open hearing, I propose to publish on the Commission of Inquiry website. Both the Farmers and Fisher Folk report that was dealt with yesterday and the Religious Institutions report that has been dealt with today were circulated to all of the participants. None of them raised any objection with regard to them being referred to in public, which they have. And so I assume that there is no objection to them being published on the COI website. Their final reports, they've been submitted to the Governor. They haven't yet been placed on the table in the House of Assembly.
Commissioner, if I may, I would respond on or return from the break. It will give me a moment to look at it.
At 1:30, yes, certainly, thank you.
Sorry, when we return from the break, the present break.
Oh, certainly, yes. No, that's fine. So shall we have a break now, and then the Solicitor General can respond to that. 5 minutes, yes. Thank you very much. Good. I think we're ready to start again. Solicitor General.
Thank you, Mr. Commissioner. We have had an opportunity, or I have had the opportunity to look at the report briefly. And I am not content at this moment to concede or consent to the report being made public. I've looked at the procedures that will be required to lay the document before the House of Assembly. And I'm uncomfortable with the fact that the document has not been laid as yet. And also I am uncomfortable with the level of personal data.
In which report, Solicitor General?
In the report, at page, for example, 871. So even within the report, their names associated with.
Yes, those are personal data. Those will obviously have to be redacted.
Yes, Mr. Commissioner. So I am uncomfortable with the report being made public, with the amount of personal data in the reports themselves and also in the appendices.
But if those personal data are redacted, no problem?
Well, I do have a problem, particularly where the report should be laid in the House of Assembly and hasn't been laid as yet.
But it has been referred to and quoted from quite
yes,
liberally during the hearing.
Yes, I'm uncomfortable with that. I am uncomfortable, however, at this moment with the report itself being made public, given the level of personal data in there and given the fact that it hasn't been laid on the House of Assembly's table. So while the reports have been referred to, I don't think the personal information has been referred to.
No, of course not, because it's personal information. We've been careful not to refer to it.
Yes.
And if we publish the report, then we'd obviously exclude the personal data. That's not an issue. The only issue is that although it's a final report, it hasn't been laid before the House of Assembly yet.
Yes, Commissioner, I agree. It hasn't been laid, and I believe we may misstep if we preempt the House in the manner in which it's going to be laid, and given the fact that it should be laid. I am concerned that we may misstep if we do publish the information prior to it being laid on the House of Assembly's table. So for those reasons, Commissioner, it would be my recommendation that the Commission of Inquiry, although the report has been mentioned, it would perhaps be beneficial if those steps can be taken in terms of redaction or a proper consideration for redaction, because I would not be able to say, just sitting here, if just, mentioning or redacting the names alone would allow persons not to know who the references are. I would have to read the entire paragraph to see if the paragraph actually make reference to a person, that persons can know who it is, even if the name is redacted. So redactions, one, yes, I think should happen, but more importantly, I think that it would be proper if the reports are laid as well to the House of Assembly table. So for those reasons, I could not consent to them being made public at the moment, at this particular day.
Thank you, Solicitor General. Because I'm anxious to get on with the remaining evidence of the Auditor General, is the best thing to put this over, Mr. Rawat?
Yes, I mean, if I can just carry on with the Auditor General, and then there are some points I can make later on during the day.
Yes, and then we'll deal with this point, but it won't be published in the meantime.
Thank you so much.
On the basis of the objection of the ministers.
Grateful, Mr. Commissioner.
Yes, Mr. Rawat.
Thank you. Auditor General, welcome back. And can I take you now, we're slightly, going back a little bit in time to a report from your office of January 2013. We'll find that at page 619, please. This is the port development project. And
I'm sorry, but if I may, before we move on to the next audit, I just wanted to clarify the point that we addressed earlier on page 919 when you inquired about the weigh-in, and I have before me.
Oh yes, yes.
Right, 919, paragraph 41. I have before me the criteria that was used for schools, for instance. There were five different weigh-ins for schools, institutions, and there were daycare, preschool, primary school, secondary, and church. So the point that I was trying to make is that a small entity, a church that had a daycare of 2, a preschool with 3 people, and a primary school with maybe 5 would weigh higher than a daycare, for instance, that had 200. And because of that, the smaller institution, the church that had multiple layers on it, was awarded a greater grant, even though it had fewer participants, fewer members to attend to. And that was the flaw within that system. And what was being suggested in 41 is that a more direct weighing should have been applied to the actual numbers of students or actual numbers of members within a church institution, rather than trying to use this, because this was not an effective measure. And that was the point that was being made in 41.
No, thank you very much. Thank you.
Thank you. Let's go to the 2013 report, please. Page 619. It's a report that relates to the development of the cruise pier at Wickham's Quay 1. If you just look at paragraphs 1 and 2 on page 621, please. You explain there that the purpose of the audit, which was an assessment of the processes employed in procuring and assessing options for the development of the port facilities. And you explained that it focused on the compliance and regularity of the processes as they relate to public procurement and transparency, and make the point that the purpose of the audit was not to assess or examine the merits or otherwise of the contents of the proposals or the submissions received for development. That was the role of a different team, not yours. So you were looking at the processes that were adopted to procure the development.
That's correct.
If we just, for the transcript, give a little bit of background, and we'll find that at paragraphs 4 and 5. And to summarize that, the cruise ship pier on Wickham's Quay was officially opened in November 1994. You explained that in 1999 it was extended from 555 feet to 746 feet, with 2 mooring dolphins being used to give a total mooring facility of 1,013 feet. It then subsequently became clear that the pier was too small to adequately service increasingly larger cruise ships. And that led, and you summarized this in the report, to a set of proposals and agreements that went from 2007 to 2013 and beyond for a range of different options for the further development of the quay. And so if we look at, for example, at paragraph 7, in 2007, the BVI Port Authority engaged engineers known as called CH2M Hill to recommend options for expansion of the pier. And they produced an evaluation which went to Cabinet, and Cabinet in April 2008 approved an option to lengthen the pier by 194.6 feet at a cost not to exceed $7 million. What then happened was that the project was put out to tender by the BVI Port Authority, and the lowest bid that came in was from Mizner Marine Construction Incorporated of Florida, and they had a bid for just over $12 million. which was to extend the pier and perform related works. Now that bid was then submitted to Cabinet in September 2008. And what it was doing was, the plan was to extend the pier by 84 feet, but then use 2 mooring dolphins. So that would mean that the pier would actually be extended by 207 feet. But the proposal was rejected by Cabinet. It seems from your report on the basis that Cabinet understood the proposal to be one extending the pier by 84 feet when it was in fact intended to extend it by 207. So the result was that was obviously a pause. And then when we go to 2009, you had pressure from carriers about the facility. And so proposals were made by both Royal Caribbean and Disney for the expansion of the pier. And there was in 2011 a proposal from Disney which stipulated a $12 million loan facility to be amortized over a 10-year period at an interest rate of 6%, which would then be used to construct a 2-span pier extension and a welcome center. I think the plan, as you write there, was that it would be the work would be carried out by Misner Marine Construction Incorporated, with CH2M Hill as the project manager, and the work would then run from July 2011 to November 2012. Disney were then to be given preferential berthing privileges at one of the 2 berths for 15 years, and the proposal reached the point where heads of terms were signed on the 11th of October 2011 between representatives from Disney, the Premier, and the Managing Director of the BVI Port Authority. But then the agreement was terminated, and it was terminated, I think, from your report, because there was at this point a change in government. Is that correct?
That is correct, yes.
So if we move through to paragraph 20, what then happened, the report explains, was that following the change in government, which is in 2011, a consultant was engaged by the Ministry of Communication and Works to liaise with the Port Authority and advise on port-related matters. And you say that in the report, through a process that has not been adequately explained, 3 proposals were received by the ministry. And these came from Carib Invest, Trident Development Enterprise LLC, and Tortola Port Partners. I'll call them TPP from now on. But these proposals went to the ministry, did they, rather than to the Port Authority?
That's correct, yes.
The ministry decided to accept the proposal of Tortola Port Authority Partners, which detailed a $57 million investment.
I'm sorry, Tortola Port Partners.
Yes, sorry. So I'll correct that for the transcript. So to recap, there were 3 proposals received by the ministry. The ministry took a decision to accept the proposal from Tortola Port Partners, which was, as a proposal, involved a $57 million investment, which would cover not only the pier expansion, but development of what's described as the upland, so part of the land around the cruise pier. And that would be on a 49-year marine and land lease arrangement. If we go to paragraph 23, the report says this: despite the magnitude of the newly proposed development, examinations of the record do not indicate any comprehensive planning or revised needs analysis to redefine the scope of the project and development of the upland. The provisions of the public finance management regulations with respect to public procurement were largely ignored. The protocols for effective financial management that were executed on 23rd of April 2012 between the Government of the Virgin Islands and the UK Minister for Overseas Territories were not in place during the early part of the project. The provisions of this document, however, echo general good practice with respect to major project planning and financing that should have been considered and observed in the development of the project. Now, just pausing there, why was it significant that the public finance management regulations with respect to public procurement were largely ignored?
Because these relate to transparency of process, and it also relates to the government. It ties into the government getting value for money on major projects, any projects, in fact. So by ignoring those processes, we don't know whether there were better options available, whether there were more cost-effective options available. And we frankly don't know how these proposals were arrived at. That all three of those proposals, there's nothing to indicate how those were arrived at.
Now, if you look at paragraph 26, a point that's made in the report is that significantly, the Town and Country Planning Department, which is the government's primary advisor on development ideas, concepts and planning issues, was notably absent from the cross-agency consultations solicited for this major development. Why was that? Firstly, do you consider that to be a significant failure in the way the project was approached?
Absolutely. When you consider that this is property in the middle of town, this is prime property in the middle of town, and there would have been other discussions with other agencies on how this would be used, potentially on how this would be used. And the Town and Country Planning Department may have had other ideas on how the area that plan might be developed. And the project was being moved forward without their input. The Town and Country Planning would also have processes, guidelines on how property within the town area can be developed in terms of density, in terms of what type of buildings can go where. And because there was skipped from this process, the benefit of that analysis was not received for this project.
You say at paragraph 27, Auditor General, and I say you, I'm using that interchangeably with the Audit Office.
That's
but
fine.
The report says that the process of securing stakeholder consultations to better define the project and gain support for the development commenced after heads of understandings were executed with the developer, and that's TPP. This should have taken place before tendering or otherwise securing a contract. Why was it important that this process take place before tendering?
It should have taken place before tendering to involve all the stakeholders and to get a better understanding of what was required for the port, what was needed, what was required, as opposed to what happened was, what resulted is that we got something that came out of one individual, or maybe two, I'm not even sure, because there was no documentation to show how this was developed in the early stage. We got a proposal that came from one individual as opposed to a wide consultation with all the stakeholders, including the government departments, including the Port Authority, which has responsibility for this particular project. And as a result, there was no way of knowing at the time this was signed, there was no way of knowing that this was actually the best option for the Port Authority, the best option for the cruise ship pair, but it was something that we had already signed on to.
You make the point, or the report makes the point, that the process had resulted in some significant amendments to the proposal. So in particular, there was an increase in the proposed investment from 57 million to $70,400,000. with an additional 18,400,000 being allocated to community investments.
That's correct.
And then picking up on the point that you made about the Port Authority, if we go to paragraphs 31 onwards, the point that is made in the report is that the project was controlled by the Ministry of Communication and Works to the exclusion of the Port Authority and its board, which in fact was the body that had responsibility.
That's correct, yes.
And so the body that had responsibility, the board of the BVI Port Authority, was in reality reduced just to endorsing the decisions made by the ministry.
They were, that is correct, yes.
And from an Auditor General point of view, why was that a concern?
Well, it was a major circumvention of the rules in that the Port Authority is the governing body for any kind of development activity with respect to the ports. The board is the decision-making body. They should be the ones who are to decide whether the port needs to be expanded, how much it should be expanded, how much money they're willing to put into this or they can put into this, and when this activity should happen. But all those decisions were being made by the ministry and without consultation of the board. The board was then, after the decisions were made, the board was then instructed to pass the required resolutions so that it could be moved forward, so the project could move forward as planned by the ministry. And that was the information that was received from the files and from the board during the examination.
And it's the board that carries the risk, isn't it?
It is the board that carries the risk.
Another point, and we picked this up at paragraph 42 and 43 of your of the report, under the heading of independent legal review. You make the point that the Attorney General's Chambers was consulted throughout the process for legal advice in respect to the government's interests. But in June 2012, the Financial Secretary sought an independent review from Baker McKenzie, specialists in the field of public-private partnerships. And they, Baker and McKenzie, looked at the documents, all of which, I think you noted, had actually been drafted by the developer. Now, what your report points out, and this is at paragraph 14, that the Baker-McKenzie review raised a number of concerns with respect to the government's position in the partnership, including that the allocation of risks was drafted in a manner to heavily favour the developers, that there was an absence of performance standards, that there was an absence of a positive obligation on the developer to carry out an environmental assessment and abide by its conclusions. There was a failure of agreements to give the authority approval rights for the initial design and any change. There was an absence of a provision stipulating ownership of the pier. There was an absence of safeguards preventing the developer from transferring shares at least until after the works were complete. That's not the entirety of it, but those are some of the concerns that were raised by the Baker-McKenzie review. You also raise at 44 and 45 in the report other concerns, which was firstly one over a need for, other points this was raised by Baker McKenzie, was need for insurance provisions to be revised by an insurance advisor to ensure adequate coverage. And then at 45, the report says this: the initial process which was being expedited contained several shortcomings which could function to the detriment of the government and the Port Authority. Efforts to secure independent expert knowledge on the format, structure, and provisions of PPP agreements was sought only after steps were in the advanced stages for drafting the terms of the parties' legal relationship. So is the point at 45 being made there that in effect the government was playing catch up? It was taking steps that it should have done before it started entering into a legal relationship.
Exactly.
So that it had a proper understanding of what it was going into.
Yes, that is the point being made at 45.
If you go to 47, and I'll pick it up at 46, what the report, then this is your audit report, explains was that the process was discontinued and the project put to public tender in an expedited process which may have limited the number of possible responses. So up until this point, effectively this had been run by the Ministry of Communication, of Works and Communications. And then what we see in 2012 is that the Ministry of Finance takes over. Is that right?
That is correct.
And so what the Ministry of Finance did was to publish on its website a request for expressions of interest, and that was on the 31st of July 2012. And what those came to was that the requirements were or included a cruise pier which must at minimum accommodate vessels with a minimum length of 1,300 feet, development of approximately 4 acres of vacant reclaimed land in the immediate vicinity of the cruise pier. I think that's the upland that we referred to earlier, and a construction schedule that allowed for readiness for use by January 2014. The other point that was made was that the use of local partners was strongly encouraged. The initial or the period for submission, and this is at 51 in the report, was 2 weeks, but it was then extended to 12th of September 2012. And if we go to your paragraph 52, what you say is the publication and the expressions of interest were published in, the expression of interest was published in local newspapers, and then in a publication called Daily Commercial News, which was Canadian based. So it appeared in the BVI Beacon, the Island Sun on 2 occasions, a Standpoint, another local publication, and then in one overseas publication which was Canadian based. You make the point at 52 that the publications above, those I've just set out, provided a submission period of less than 2 weeks for a project envisioned to cost between $50 million and $75 million. The extended submission date of 12th of September 2012 was not found in any of the publications examined. In addition, no evidence was found to support assertions that the tender was also advertised in the Wall Street Journal. So it follows, doesn't it, from this part of the audit report, was that such a short time period was utterly inadequate for a project of this magnitude.
That's correct.
In effect, there was inadequate notice, not just of the expression of interest, there was inadequate publication of it.
That was what the audit found at the time, yes. That was the finding.
What that expression of interest did result in was 3 proposals, which were from GLF Construction Corporation, Tortola Port Partners, and Royal Caribbean Cruises Limited, stroke Deco. So all of these were considered by a committee. They were all invited to submit tenders, and only 2 of them submitted tenders. And the committee was comprised of the Deputy Financial Secretary and representatives from the Ministry of Natural Resources and Labour, Ministry of Communication and Works, and the Public Works Department. So on that committee that considered the submissions, there wasn't anybody from the BVI Port Authority.
No, there was not.
Only 2 tenders were received.
I should mention, though, that the financial secretary is a member of the board of the Port Authority.
I think we should clarify, actually, because I think my question was wrongly put, because what you say is that
but the board was not invited to be a part of this. The financial secretary sits on the board of the Port Authority as government's representative. So strictly speaking, there should have been another member there to represent the board properly.
But the tenders were then examined by a separate committee to negotiate a PPP contract, and that committee did have the chairman of the BVI Port Authority on it, didn't it? If you look at 55.
Yes, that's correct. That's what.
But at the time of the audit, which is obviously January 2013, that process of assessing the tenders and negotiating was still ongoing, wasn't it?
It was, yes.
What you say, though, at paragraph 57 is the intention was to have the process expedited to accommodate an early construction schedule. However, the provisions in the invitation for expression of interest mirrored the previously accepted proposal from Tortola Port Partners to a considerable extent, which may have created an unfair advantage. This opens the door whereby the impartiality of the process could be challenged. In particular, the requirements that the developer be partnered with a cruise line, commitment from said cruise liner to have the BVI as a medium to long-term destination, requirement that the successful tenderer provide training, etc. And so, on one view, the risk was that the government could face a challenge that they hadn't by putting this out to tender. Transparent process.
Basically, yes, that's what this is saying, that by putting this out to tender and using the criteria or the information that they already had received from one of the tenderers, they were creating a situation where they could potentially be sued, a situation where the process could appear to be unfairly biased towards that particular company.
If you look at paragraph 58, you say the tying together of the dock expansion to the development of the upland without making allowance for the possibility of separate submissions and assessment limited the government's ability to achieve value for money and precluded other parties that might have been qualified to perform one or the other engagement, in particular local developers and investors. Is there anything you could add to that, just to put it into context?
No, I think that pretty much speaks for itself.
And the point is that by tying dock expansion to development of the land, you were shutting out local developers and investors, weren't you?
That's correct. By tying the two together, what you are basically saying is that we would only consider major contractors that possibly the BVI didn't have the expertise to, for instance, to do both the dock and the upland. And one of the requirements was the encouragement of local partnerships, which potentially could address this. But it's really, by not having the upland separate, that shut out the local contractors who might be able to actually present a proposal independent of having to rely on an external partner to actually participate in this really significant project. And this is what this was saying.
At paragraph 59, the report makes the point that an additional requirement was that there should be an opportunity of at least 20% of local ownership in the venture, forgive me, which you you say may have been in response to local criticism regarding the absence of local investment in the previous proposal. No details were incorporated as to the format in which this should take place, however, and at what point in the process. But the report continues, in satisfying this requirement, the Royal Caribbean Cruise Line's proposal partnered with the local firm Ramasco, which has maintained an interest in the development before it became active. The subsequent submission by Tortola Port Partners named the BVI Investment Club as its local partners. The point that you made was that the involvement of BVI Investment Club raises potential issues of conflict of interest in the following respect. The principal of PFK BVI Limited, the firm engaged to prepare a business case for the initial Tortola Port Partner BVI Government Public-Private Partnership, is also a president of and public figure for the BVI Investment Club. And second, the declarations of interest for election candidates published and gazetted on 10th of October 2011 show more than one elected member with shareholding interests in subsidiary companies owned by the BVI Investment Club. Now, that's again a point, aside from being a point of substance, it's also a point of impression, isn't it? Because there is a clear conflict of interest if you are an elected member and you have a shareholding linked to BVI Investment Club, and that club is involved in a major publicly funded project.
That is true. What I'd like to point out with this, though, is that the information was taken from declarations of interest for election candidates. And what we were unable to ascertain, get any independent information on, is whether or not these individuals were still actually members of the BVI Investment Club at the time of the audit. In particular, our office contacted the Registrar of Interest, who should have this information. And her position was that, well, you know, the only people who can see this registrar is the members themselves. And I had a discussion with the Attorney General, who was not willing to commit one way or the other with respect to whether or not we should have access to this, this information. And I think the point was made a few days ago that without access, the registrar is really limited in its use. And I think this is something that should be changed.
But from the perspective of the Commissioner has heard evidence already in relation to the register of interest, and witnesses have given different views about whether the any register of interest should be public and the extent to which it should be public. But from the perspective of an Auditor General, a public officer under the Constitution, would it be your view that your office should be entitled to see information and to receive information held by the Registrar of Interest, even if that information cannot otherwise be made public?
Absolutely.
Can I just take you to your conclusion on here? And this is obviously a conclusion in relation to a report made, the conclusion in a report made in 2013. But you say this: the process of addressing the pier expansion needs commenced in 2007 with a professional project assessment and competitive tendering for a project which should have cost just over $12 million. This ended in inaction due to insufficient information being provided to the Cabinet. The project was subsequently allowed to evolve into an undefined large-scale development which bypassed much of the planning and preliminary approval processes required for prudent and transparent management of public projects. Subsequent tendering of the works was performed to satisfy PFMR provisions, that's Public Finance Management Regulations provisions on procurement, but in a fashion which did not allow for broad-scale participation of other qualifying developers. The highly specific nature of the project requirements created an advantage in favour of the previously selected developer, TPP. And at the time that this report was prepared, the project was being overseen by the Ministry of Finance.
That is correct, yes.
Was it still a concern for you as Auditor General that the BVI Port Authority, as the body corporate responsible for this area, was still being shut out of the process?
It was a concern, yes.
I'm not going to read out the 3 recommendations that you made, but can you remember whether or not, or what response you received to those 3 recommendations?
My recollection is that we did not receive a response to these 3 recommendations.
Could I move now to a different report? And what we were looking at was, I think, a money for value report, a Section 12 report. But I want to take you just to page 748, if I may. We're now, sorry, if I, give me a moment, please. 784, I'm sorry.
784.
784. This is the report dated the 24th of August 2018, and it's titled Special Report Elmore Stout High School Perimeter Wall. Can I, again, just to try and set the scene, take you to please to paragraph 4, of which is on 789. This is a detailed report, Auditor General, so I probably will need your help to try and translate it as we go along. But in terms of background, you set out background in paragraphs 4 and 6, and if I summarize that, in late 2014, the principal of the Elmore Stout High School wrote to the ministry, and that's the ministry, what was then the Ministry of Education and Culture.
That's correct.
And that was headed at that time by the Honourable Myron Walwyn, wasn't it?
That's correct, yes.
And what Miss Underhill did was to request that the security of the western perimeter of the school be urgently addressed. And it was a request that was supported by a report from the Commissioner of Police. So in response, the ministry obtained an estimate from SA Architect in October 2014. And that was for the design and erection of a block wall around the school with a total cost, as you record at paragraph 5, of just over $828,000. Is that right?
That is correct, yes.
And what you say at 6 and 7 was that the work was done in 2 phases. Phase 1 was undertaken in December 2014, and that was intended to address the more problematic areas. And then in 2015, you had phase 2. Now, you were asked to audit phase 2, but as you say in your report, for completeness, you also carried out an audit in relation to phase 1.
That is correct.
Now, if we deal with your findings in relation to phase 1, first of all, if you go to paragraph 89, please, in the report, that's at page 801. Phase 1 was undertaken in December 2014. It used funds from the secondary school budget of that year. A plan was submitted to the Town and Country Planning Department for phase 1. And what it stipulated was that there would be 180 feet block wall with a cost estimate of just over $156,000. Now, what you say there is that in accordance with the public finance management regulations, there should either have been a tendering process or a cabinet waiver. And in this case, neither was pursued. I appreciate it's a bit of time later, but were you able, as part of the audit, to find out why neither option was pursued?
No, we were not.
What you did find, and you record it in these paragraphs, but I will summarize, was that the work to be done in phase one was scaled back from 180 feet to 120 feet. That work orders were issued to 11 contractors for the works. So it wasn't even done as a petty contract. It was done as work orders.
That is correct, yes.
And I think, correct me if I'm wrong, but for work orders, they go up to $10,000.
Yes, they do. They go up to $10,000 and they do not require any kind of competitive submission.
And 6 contractors got $9,989.65 each for wall construction. 5 contractors received work orders for rail installation and painting, and that was for $7,357.90 each. And you make the point that a 6th rail paint contract was not issued. And what you make the point, and you'll see this at your paragraph 1A, if you want to look at it, was that the effect of, it's paragraph 100A, sorry, the total work orders came to $96,727.40, which was just below the $100,000 ceiling, which would have required a major contract procurement process.
That is correct, yes.
And so was the way of avoiding that by scaling down the works from 180 feet to 120, and by not issuing that final 6th rail paint contract?
That was the appearance of this particular aspect of the project. By not issuing that final contract, they stayed within or beneath the major contract threshold.
And if you look at your paragraph 92, there were excavation costs of $4,400 that were not paid until 2015. Did the effect of not doing that mean that that kept the amount of money spent in 2014 below the $100,000 threshold?
Yes, it did.
So that was a way of also avoiding the need to go and use a major contract procurement process.
And to get a waiver, yes.
And what you make the point in relation to phase one, and you say this at paragraph 94, was that at the time the project was stopped, the works on this section of the project was incomplete as none of the wall sections had been painted.
That is correct, yes.
If we go to phase two and we go back to your paragraph 11, which you'll find at page 790, 791, please. And again, I'm going to try and summarize some of this, Ms. Webster, but if I go too quickly or I miss something out that you think is important, please do stop me. In relation to phase two, there was a planning aspect. And what happened was that on the 4th of February 2015, the Minister of Education and Culture submitted a funding request to Cabinet for $824,000 to complete phase 2, and a request for a waiver of the tender process to expedite execution. You note in the report, and this is at paragraph 12, the application for the waiver premised that a tender process would be lengthy and likely to result in more expensive estimates, but no information was provided in the business case in support of this, nor was there any cost analysis or implementation plan. Now, when you refer to a business case, what in particular are you referring to?
The protocols for effective management actually require a business case for major contracts, major projects. And the business case should have details of all that is mentioned here. Alternatives that were considered, the impact of the project, and certain other details. And in examining the business case, none of this was actually considered, none of this was actually discussed. What we had was a document that was headed business case, simply, I think, for the intent of meeting the requirement that a business case should be submitted. But the detailed amount of work that should have been put into to actually putting that together and explaining the projects and its cost benefit analysis and the impact and other effects was not done, and which is why we found that the business case was insufficient to support the premise that this should be treated as a waiver. It should be subject to a waiver.
And what you mentioned it, what requires a business case to be put forward for waiver of tender purposes?
I think it's the protocols for effective management.
Yes, thank you.
I need to go back and check that.
What then happened was that the tender process was indeed waived. Funding was approved, and contracts and work orders were issued so that the work could start from the 1st of March 2015. You say that at your paragraph 14. If we look at 15, the point that the audit report makes at 15 going on is that the project was planned and managed in its entirety by the Ministry of Education and Culture. And so it did not draw upon the expertise of the Public Works Department, which, as you note, is equipped to provide architectural, quantity surveying, contracting, and project management services. And the Public Works Department were not involved at all in the management or the oversight of the project.
That is correct.
And what was all?
I should add, though, that the Public Works Department at some stage reviewed some preliminary plans for the redevelopment of the perimeter. I think that was an early, it preceded this. And it's not, this project, as it moved forward, did not refer to that, but I'm aware that Public Works Department did, in fact, look at some preliminary plans some years prior that dealt with the perimeter and how it would be redesigned.
But certainly from the point of view when phase 2 started, or they weren't involved from then on.
No, they were not. This part of it.
And you've made the point that the second point you make is that expertise in the Ministry of Finance project management unit was not engaged, notwithstanding that Cabinet had made it a requirement that the ministry should involve this unit with the management of the project.
That's correct.
And we see that if we look, in fact, at this is just for your note, Commissioner. It's also referred to paragraph 78, but I don't need to take the Auditor General to it. So Public Works Department is not bought in, neither is the Ministry of Finance Project Management Unit. I think what then happens is that SA Architect then takes on responsibility for overseeing the works, and they report to the ministry on progress. SA Architect signs payment requests to certify that the contractors had completed their work and were entitled to be paid.
That's correct.
You note, and if we look at this, it's paragraph 21. There was no segregation of duties or secondary checks. This allowed for incongruences in the bill of quantities to go uncorrected and contractors to be paid for unfinished work, resulting in a project that was incomplete and overcosted. So if we go back to your 20, what you've said is that the arrangement was that SA Architect was overseeing everything.
Yes, that is
and was
correct.
then reporting back to the ministry. When you say that segregation of duties or secondary checks were absent, what would you have expected to see if this was being properly managed?
I would have expected for Public Works to at least have a role in this. And I would have also expected that Public Works would have reviewed the bill of quantities that were developed for this project. And they would have picked up, possibly picked up that there were some issues with those bill of quantities. But that did not happen. I also would have expected that the Ministry of Finance might have been consulted as was required by the cabinet decision, and that did not happen.
If we go through to look at paragraph 22, and I'm again going to try and summarize this, is paragraphs 22 to 30 that I'm going to summarize. You begin paragraph 22, and this is part 2 of your report, which is headed execution. You say the project was sectioned and costed to allow for multiple contractors. And so the way that was done was that the work was divided into sections. So there was division 1 was perimeter sections, division 2 were wall sections, which included columns and railings. And then division 3 was the contracting sections, which effectively meant subdividing into 3 job types, which was wall construction, rail installation and wall painting, and other works. If we look at 31 now, the report, your report then explains that 70 independent contractors were engaged by the Ministry of Education and Culture, using 15 petty contracts and 64 work orders to complete a wall that was 1,562 feet long. And the system, you say, made it possible to have 2 different contractors working on the same segment of wall. Is that right?
That is correct.
So what one contractor could be coming along, having been given the work order to build the wall, whilst there was another contractor there responsible for installing the rails and painting both sides of the wall.
And that is correct, yes.
If we look at 37 now, and that's looking through to 51. Again, I'll try and summarize, and these are findings that the audit report made in relation to the costings of the work. The first one was that the approved estimate for constructing the walls and the columns was just under $195,000. But
sorry, could you?
Perhaps you can help me with this. I mean, if you look at paragraph 41, please. What you did as part of the audit was to examine the bill of quantities. And the point you make at paragraph 41 is that the approved amount was, and I'll give the correct figure, $194,920.
Yes, that is correct.
But actually the costing for, and this is for constructing the wall and columns, the costing was actually $502,423.50.
Yes, that is correct.
The next point to draw out, perhaps, if we see at paragraph 37. And again, it's a disconnect that your report identifies between the approved estimate and the amounts issued to contractors. So the approved estimate was $828,000, just a little bit over, $4 over. Do you have that? That's in the table. But the actual payments made out was $985,690. So again, there was an excess of just over $157,000.
That is correct.
So it's what you've described as a disconnect, Auditor General, between the two. If we go to 49.
I should point out that the actual payments was $985,000. The approved estimate was $828,000 for the entire thing to complete the project. The actual payments was $985,000 with a substantial amount of work still outstanding, which means that the government would have to put more money into to complete the project.
Yes, because the table says that the rail installation and wall painting was only 40% complete.
That's correct, yes.
And so what you have is not only that it had overrun its cost, but even having overrun its cost, it still hadn't completed the work.
That is true, yes.
And we can pick that up at, if we go to paragraph 64 on page 798. If we look at paragraph 64, what was estimated by the ministry was that an amount of $251,000 was now needed to complete the entire perimeter wall project.
That is correct, yes.
I'm sorry to make you jump around the report, but can we go back to paragraph 43? If I've understood the report correctly, what your team did as part of the audit was, when assessing the rates and quantities used in the bill of quantities, you conducted a comparative analysis with 4 similar projects for reinforced block walls that have been costed and supervised by the Public Works Department in 2015 petty contracts.
Yes, that is correct.
And I think you make the point that on that analysis, the construction costs estimated by the Public Works Department varied from $175 to $236 per square yard, with an average cost therefore of just over $201 per square yard.
Yes, that is correct.
Now, you then you took the highest rate, the PWD rate, and you applied that to this project, and that gave a contract cost per wall segment of $3,828, when, as you then record, the actual cost issued in the contracts was $9,461. So just about 2.5 times more.
Right, and this is applying to the wall segment and does not include the rails or the painting. This is just construction of the block wall. The cost then based on the PWD's, the benchmarks that we used from PWD came up, the highest one came up to 3,000, that each of those contracts that were issued for $9,000 should really have been closer to $3,828, about $4,000, which is more than twice what the contracts issued were, more than twice what they should have been, almost 3 times.
And it's a point you make at paragraph 45A, that the rates applied for the wall at the high school were in general greater than those used by the Public Works Department. In some cases, it was doubled. You also at B noted inconsistencies in the bill of quantities for the wall construction, and you give examples. So the bill of quantities used for a 22-foot segment of wall, the bill of quantities used 44 square yards for rendering, but 80 square yards for painting, whereas the actual area was, you say, 32.4 square yards.
That is correct.
The railings, which were 10 foot by 3 foot, were costed, so that the railings were 10 foot by 3 foot, giving you 30 square feet. That was costed for 70 square feet. And then the bars per set of railings were 6.6 square yards on both sides, but were costed for 33 square yards. So putting it in sort of layman's terms, the effect was that there was no correlation between the wall segment and what was needed and the figures in the bill of quantities.
That is correct, yes.
If you go to 796 and point C, you say this: a loss of economies of scale was incurred in splitting the contract. So this is perhaps goes back to a point that we were canvassing yesterday about from your annual reports about the approach of splitting contracts. And you've given an example, but could you add anything to just why splitting contract creates that loss of economies of scale?
We could see it here in this example that we looked at. Normally for a project such as this, you may need, I don't know, maybe 20 truck-in, 20, 30. For projects such as this, to clean up afterwards, to pick up debris as you go to clean up afterwards, I would say max, and being generous, 100. And in this case, we paid for 405 trucks for this project, the trucking fees for that. And I haven't seen any public work contract that dealt with a wall of this size or even bigger, paying for 405 trucking excursions. And that's what happens when you split up the contract. Every piece has its own specific costs, and you don't benefit from buying large scale or doing things all at the same time, because all the contractors are going to claim for the same activity that should really be shared. Even if they had agreed that we would have one trucking company that would assist with the project, 1 or 2, and we called them when needed, it would not be 405. And that's just an example of how the cost was escalated in one area specific to trucking, but there would be others.
If I take you just, Auditor General, just look at paragraph 65, please, which is on 798. And this is about, it's headed inconsistencies in the executions of the works and damage. And the point that you make there is that there were throughout the project inconsistencies noted. For example, in the length and height of the wall. So some wall segments were between 8 to 9 feet, and not 10 feet, as was specified. Some railings were of irregular height. You also, you say at 66, noted inconsistencies in the rendering of the wall. So in some areas, the block wall was visible through the unpainted plaster. So stepping back from that, does that suggest that there was a failure of this goes back to the secondary checkpoint, that there was no one there checking the quality of the work that was done?
It points to inadequate quality control on the project. And I can't speak to how much the project manager, how frequently the project manager was there or what he was doing while he was there. I don't know. But the fact that there were inconsistencies in the height of the wall, in the rendering of the plaster, and in other areas, the rail, for instance, indicates that there wasn't sufficient oversight. And, you know, these are, in some cases, these are things that could be easily fixed so that you would have a more professional looking finished wall or finished product when the project was done.
So it's, again, stepping back from it, what there was just a significant inflation of the costs, wasn't there? That's what it comes down to.
That is what it comes down to, yes.
And did you identify as part of the audit any reason for why that happened?
Well, the main reason why that happened was because the contract was split into several parts, and you had to accommodate a profit for each contractor, and there were the losses in economies of scale. Those are the main reasons, the fact that it was split into several parts.
Could you go to 69, which is at 799, please? It's a section of the report, part 3, headed procedural issues and irregularities. Before I continue as well, I think your voice is dropping a little, Auditor General, so you, by all means, pull the microphone closer, but if you could remember just to speak up. What you say in these sections, and there's, the first bit is under contractors. You say that Regulation 181 of the Public Finance Management Regulation requires government offices to obtain a list of pre-qualified contractors from the Ministry of Finance for procurement services and construction works where there has been no tender process.
That is correct.
In this case, what you note is that there was no consultation with the Ministry of Finance Project Management Unit or the Public Works Department on the selection or eligibility of contractors. The contractors that were used and the work orders assigned was entirely down to the Minister of Education and Culture. Is that right?
That is right.
I think it's helpful if I just actually read out what you say at paragraph 71. The contractors used on the project were selected by the Minister of Education and Culture. The Assistant Secretary who provided project liaison services within the ministry advised that the contracts and work orders sections and amounts were assigned to individuals based only on instructions received from the Minister. And so where you say the Assistant Secretary advised, that's a public officer in the Ministry of Education and Culture speaking directly to the audit teams.
Yes, that is correct.
You then say that of the 70 contractors used on the project, 40 did not have construction trade licenses. And as I understand it, this is at paragraph 74, those aren't required for work orders.
They are required for any contractor. What is not required for a work order is for a government office who's doing a project using a work order. They don't have to ask for it. But any contractor that's doing work in the BVI should have a trade license.
I see. So, but if you're paid under a work order, you don't have to produce your trade license.
You don't have to produce it to the government. The government doesn't have to ask for it.
But again,
that's actually a policy rather than a regulation.
But again, not asking for the trade license brings risk, doesn't it? Because
it does, yes.
As your paragraph 72 shows, the majority of those contractors who worked on the project did not have trade licenses.
The bottom line is that the work orders are really intended for small jobs that can be done and shouldn't require a whole lot of bureaucracy. So if you need to have the front of the government's department cleaned, you can hire somebody on a work order to get that done, for instance. It's not intended for major contractual work or detailed contractual work. It's intended for small jobs, which is why it's kept simple. The requirements are kept simple.
I mean, did you, having done your audit, consider this to be a major contract project?
I consider it to be, well, it is in terms of the amount, the fact that it exceeds $100,000, it's a major contract project. In terms of what we are discussing now with respect to work orders, it's something that requires more than just picking someone up and saying, well, you do this. The petty contract requires that you meet certain criteria for a reason. And the petty contract is intended to facilitate small jobs such as this. And there are scales moving upwards from the work order to the petty contract to the major contract. Each has a separate requirement. And the bottom line is that work orders are actually not intended for this type of work. When that was developed, it was intended for small jobs that the government might have to do, and without incurring a whole lot of bureaucracy to get that done. And what we're seeing is an evolution of the work orders becoming more significant because they're easy and they don't have a lot of requirements. And I think there's a danger that brings in, a risk that brings in as well. And it should be curtailed.
And the point you made that in this project, what Cabinet approved was the project to be split up for the purpose of issuing petty contracts.
Cabinet specified that the project should be done via petty contracts. Yes.
And Cabinet waived the need for a tender process. But the point you make is that Cabinet didn't allow for the project to cover implementation by work orders.
That is correct, yes.
You've already, and this is at 75, that you've already confirmed that work orders can be used for construction work or services not exceeding $10,000. What you say is that Public Finance Management Regulation 189 prohibits the issuing of multiple work orders on the same job. So it prohibits, you can't use work orders to avoid the need to have a petty contract. Is that what it comes to?
Well, you should not use work orders to avoid doing a petty contract. That's pretty much what it comes down to. So it's basically splitting a petty contract into smaller parts so that you can issue work orders. And I see I have heard that work orders can be used for construction work or services not exceeding 10,000. But it doesn't take away from the fact that any construction, any person who puts himself up as a contractor to do construction work, independent of any other agency, should have a trade license.
If you go over leave to 77, please. What your report also says is that there was no process to ensure that social security and payroll tax obligations are met from work order contracts, resulting in payments that are gratuitous and contrary to government regulations. So would you have expected to see a process if this project was being run in the way it should have been?
A process for the deduction of payroll tax?
Yeah.
That's the process that's used for petty contracts. And because work orders were used, it was not employed in this particular instance.
I see. So if you use work orders, you don't need to have a process in place.
If you use work orders, strictly speaking, you should be deducting the Social Security and payroll tax. If you use work orders and then you're claiming that they don't have to be a contractor, they don't have to have a trade license, then in effect you are employing them as laborers, and you should be deducting the PAYE and Social Security from the payments that you give them.
If we look at the section of the report which is headed project management, you say that Cabinet's approval stipulated that the Ministry of Finance Project Management Unit would assist with the management of this project. As you've already said, it did not happen in this case, but rather management was outsourced by the ministry to an independent contractor in 2014 without competitive solicitation or vetting by any of the two government agencies that you name, which is the Ministry of Finance Project Management Unit on the Public Works Department. That project manager, and I take that's SA Architect, that project manager was paid, you note, by the BVI government a total of $265,110 in 2016 for this and other projects under the Ministry of Education and Culture. The $265,000 was not just for the school wall project, it was for other projects.
It was for the school and other projects, yes, on the different petty contracts.
And am I right to say, is this a reference to SA Architect as the project manager?
That is correct, yes.
Do you remember when we were looking at the your annual reports, and I asked you about one of the general points you made about ministers going beyond their portfolios?
Yes.
Would you consider here, where you have, despite Cabinet stipulation, the project management unit disregarded, the Public Works Department not consulted, but rather you have the Ministry of Education and Culture and engaging an independent project manager? Would this be an example of a ministry going beyond the portfolio?
What we're seeing is an evolution of what's happening within the ministries. And I think the excuses that's been used a lot is that Public Works is not adequately resourced. We now have project managers in, I know we have one in health, we have in education, and I'm not sure whether we have one right now in natural resources and labor, but we have the ministries now doing their own project management per se. And this ministry, building a wall around a school, I think that would fall, fairly within their portfolio. But the task of managing that process really should involve the agencies that are skilled in doing that, which would be Public Works Department, and the Ministry of Finance now has a project unit, especially since those have been mentioned. The project does fall within the ministry, but what normally happens, or what should have happened, is that they should have brought in the agencies to be a part of the process and to make sure that it's run properly.
If you look now, please, at your 81 and 82, where you deal with budget and payments. You say that the project in its entirety was estimated to cost just over $828,000. Despite this, no request was made to the Ministry of Finance for an independent sub-ledger to facilitate prudent management of the funds, which were instead added to the school rehabilitation subhead. And you say this meant that there were no controls to limit the total spending to the approved amount or to alert the ministry when spending limits were being reached. As a result, payments were made over the authorised amount, possibly without the ministry being aware of the excess. Just again, in layman's terms, Auditor General, what should the ministry have done in terms of handling this budget?
Well, basically, the ministry was given a budget of just over $800,000. And what should have happened is that a separate account should have been set up with limits up to that amount, that budgeted amount, where the ministry could spend from, and which would allow them to monitor where they are in terms of their funding and what areas possibly that they were overspending. And that wasn't done. What actually happened was the funds were just treated as part of the ministry's development account, and that would have been lumped in with some other things. And in spending more than was of what was allotted, the likelihood is that they also use funds that should have been used for a different project. So that's the effect of the overspending, actually using the funds that should have been spent on something else. So without that separate account, there wasn't any easy way to actually manage what was happening in terms of spending and in terms of where they were with the budget, that particular budget.
And another point that you have noted in your report is under the heading payment discrepancies. And if I take you to paragraph 85, you say, Auditor General, that in some cases payments were made where the work was incomplete. And this was especially apparent in what you've called the 2014 focus area. That's the first phase of the project. And contractors were being paid in full for work that was incomplete or not done. Is that right?
That is correct, yes.
And can I just ask you about planning approval? Both in relation to what I've called phase 1, which was in December 2014, and in relation to phase 2. Do I understand the report correctly? What you're saying is that there was a requirement to submit plans and get authority from the planning authority, but it wasn't done until after the work had been done.
Yes, that is correct.
And so you make the point at 88 that the process of getting approval after the fact rendered the process irrelevant. There was no purpose really in doing it, and no value in doing it if it's after the event. Is that right?
That is right, yes.
Could I take you to your conclusions? And I'm just going to take you through them, and I'll start at paragraph 100. You say the project's manner of execution and its outcome underscore why procurement rules are required. The project gives an experience of an agency, sorry, I'm going to read that again. The project gives an appearance of an agency that sought to avoid the procurement requirements that have been established to secure value for money on government projects. This can be seen in A, the scaling down of the 2014 works from 180 feet to 120 feet, and non-issuing of the final rail contract to avoid major contract regulations that would come into play with the project reaching $100,000 ceiling. B, waiver of the tender process to avoid competitive submissions. C, wide-scale use of work orders that are intended to be used for small one-off jobs. D, use of unvetted contractors. E, micro-splitting of the project. F, exclusion of other government agencies. Going to pause there. By micro-splitting of the project, are you referring to the approach of separating it into essentially, as we went through, perimeter sections, job types, etc.?
By separation, by having 70 contractors to build a very small wall, reasonably small wall. And yes, by having multiple contractors doing work on a small segment of work, which, you know, was completely unnecessary.
At your paragraph 101, you continue, significant discrepancies in the costings of the section, in particular the per unit measurements used to derive itemized costs, resulted in overpriced contracts. 102, this is your paragraph 102. Failure to involve pertinent government agencies eliminated checks that may have identified overcosting on the bill of quantities and result in more efficient and economical execution. That's the failure to involve the project management unit and the public works department. Is that right?
That is correct, yes.
Then you go on at paragraph 103, division of the project into multiple parts eliminated possible economies of scale and further escalated the cost to government. You go on to say, use of unlicensed contractors constitute a breach of trade license regulations by the individuals and by the government. It may also have facilitated breaches of the inland revenue and social security requirements. Your next conclusion is that there was insufficient ministerial oversight on this project. Some of this is demonstrated by A, payments were made in full on contract segments that were incomplete. B, bill of quantities were adopted and used for contracting purpose costs when a mathematical cross-check of these could have ascertained that they were incompatible with the authorized costs. C, the ministry attributing the excess project expenditure to the variation for the bus pickup area without undertaking an active examination of why the project costs were overrun. I'm going to pause there. Could you just explain, if you can, a little bit more about that point C, because it's not something I've taken you through into if it's elsewhere in the report.
Right, in making an application for additional funding, actually ran out of money and it was stopped by the Ministry of Finance. In making the application to get additional funding, the ministry stated that the over expenditure was caused by a modification that was made to amend the wall to allow for buses to drop off the kids at the back of the perimeter. When in fact that was not the real reason why the project had been overspent. And to be fair, the ministry at the time when they made that representation might have actually believed it, but if they had looked at it closely, they would have realized that, well, the project was actually overcosted, and that was the reason why we had excess expenditure on the project.
Now, I'll want to ask you just one thing about that paragraph 105. You say insufficient ministerial oversight on this project. It may be suggested that it's not the job of a minister to conduct any such oversight.
I'm sorry, where are we looking?
If you go, it's page 1803, and you look at paragraph 105. You say,
well, actually, that's probably the wrong term that was used. In that sense, it means the ministry as opposed to the minister.
And so is the point that if a ministry has decided to embark on a project of this sort in the way that it did, the use of an independent project manager, not using the PMU or the PWD, etc., points you've made, then it needs to make sure that it does maintain oversight on the project.
That is correct, yes.
And from what you found and what we've gone through, your conclusion is that there was a failure to do that.
That is correct.
If we go just to 106 rather, paragraph 106, you continue in terms of your conclusions. The subjective manner with which contractors were selected and assigned introduces issues of inappropriate political influence into the procurement process. Does that link back to what the Assistant Secretary told you?
Yes, it does. It does.
You then go on to say, no evidence was presented to show that this was open, impartial, on merit, or in keeping with the public finance management regulations. If there was, as was done in this case, a process where multiple contractors were going to be engaged, what evidence would you have wanted to see to show that there was an open and impartial process?
Well, the process is outlined by the public finance management regulations, where you have to contact the Ministry of Finance and get a list of approved contractors to do the work. And from that list, you determine who would be sourced for the project. The other option would be to fill in that. The alternative would be to contact Public Works and get from them a list of potential contractors to do the work, and use that as a basis for proceeding.
You then say this process is contrary to best practices and contributes to a culture where contractors expect gratuitous public contracts from political representatives without due regard to fairness, transparency, and proficiency in the selection process. And you conclude, it also compromises the government's ability to achieve fair value on money spent, both in terms of the monetary cost to the public and the quality of the work rendered. I'm not going to read out the recommendations that you made, Auditor General. This report, as the Commissioner has indicated, will be put on our website, and others can, if they wish, look at those recommendations. Briefly, I want to go to one matter that may be linked to the recommendations, but overall, what was the response to your recommendations?
The response to the report and the recommendation basically was that the Auditor General should not be. Well, let me just cut it short and say the response was not a positive one.
It was such, and this I hope you'll find this. It's probably just nestling under your computer, but you issued a press release on the 17th of December 2018, and I just wanted to look at that with you. It's not in the bundle, but it is on the table, probably just sitting underneath the computer. Won't be in that pack. I can see it from where I am, but I don't think you'll be able to.
Oh, is this it?
And the next document that's there.
Okay, thank you. Sorry.
This was a press release that you issued, Auditor General, on the 17th of December 2018. And I want to go through it with you in fairness to you. But first, how often do you have to issue press releases?
Not often, not very often at all.
What I'm going to do is just go through it first of all, and then there's an addendum to it. But you say, I'm pleased that the audit report on the Elmore Stout High School perimeter wall has now been properly made public and is available for all to examine and consider. I'm concerned, firstly, that government projects are allowed to be managed with so little regard for public resources, but more acutely, because the response coming out of the ministry does nothing to convey confidence that steps will be taken to secure improvements in the implementation and management of future public projects. The reports of this office go through several vetting processes to ensure that they are factual and supported. When the institutions that support public transparency and good governance are attacked and undermined at will, and government regulations and parliamentary procedures are deliberately disregarded, We risk becoming a society where the rules that affect democracy and fairness are eroded and rewritten in plain sight, and public servants accede to questionable activity for fear of political reprisals. This is a dangerous place to be and cannot be the society that we want the BVI to descend into. Government officers and members of the general public must continue to ask for accountability in government and insist on better management of public funds regardless of political affiliation. To do otherwise is to consent to the wasting of limited public resources and the erosion of national integrity, both of which are essential for the development of the territory and prosperity of future generations. The Office of the Auditor General is pleased to present the report on the Elmore Stout High School perimeter wall to the public, and we will continue to do our part in ensuring that accountability is pursued and democracy is sustained. And you signed this press release. Now, before I turn to the annex to the press release, when you refer to parliamentary procedures being deliberately disregarded, did you have anything specific in mind?
Yes, the report was actually taken into the public before it was tabled by the minister.
Did you find out who took it into the public?
The minister took it out into the public and he had a press release about it. It wasn't something that was secretive. It was taken into the public.
So the way the process should have worked is the report, your final report goes to I think in this case it's a Section 20 report, so it goes to the governor. It then has to be laid before the House of Assembly. After that process, it becomes public.
That is correct.
And in this instance, before that process had been concluded, the minister decided to take it to the public.
Yes.
And with a press release.
With not a press release, but an open press discussion. It was taken into the public, and he basically had not a press release, a press briefing, a press conference, so to speak. Yes, thank you, Commissioner. On the subject, while arrangements were made to have the document tabled, and there was no warning. We just suddenly saw that it was in the press, and statements were being made about it.
And so you issued this press statement in response?
I issued this press statement after the document was tabled. The document was tabled, I think, shortly thereafter. I'm not sure whether it was the following week. So taking it into public preempted that process, and we waited until it was tabled so that I could make the statement and present the report so that in a proper way.
And the minister concerned was the Minister for Education and Culture at the time?
That is correct, yes.
So that was the Honourable Myron Walwyn.
Correct, yes.
Now, what you did, and I think again, we Commissioner, if it's all right, I'd like to take the Auditor General through the additional points she made.
Yes.
Auditor General, your press statement carried with it a document that was headed fact check.
An attachment, yes.
What I'd like to do is to put to you, there's a column which is headed Minister's Assertions as presented in his statement and as reported in 284 News interview. The second column's finding, and then the third column is the Auditor General's response. What I'll do is go through the first two and perhaps allow you to deal with the response side, if I may. The first assertion that was made by the Minister was that the Public Works Department was not consulted during the audit process. And you have responded that that was false. Please just set out for the Commissioner why the basis of that response.
Yes, the assertion was false because not only did we consult with Public Works, we did so on a number of occasions. The auditor who worked on this project visited Public Works on multiple occasions and met with both the Public Works director who was there at the time and the one who preceded him. And he met with both of them together in person. We also at one stage requested Public Works to do a costing because we went through the figures and we thought that, this doesn't look right. We should get Public Works, the government specialists to look at this. So we asked them to do a costing for the project. And basically, the individual we spoke to do the costing agreed, and then afterwards came back because the Director of Public Works informed us that his office was not involved in this project and he does not want to, at this stage, become involved in the project. So the project was completed without that particular costing that was requested. But getting back to the main assertion that Public Works was not consulted, this is actually false and false and misinformed.
The second assertion that in your press statement you say that the minister made was that the audit report valued the wall at $372,000, and you say that was false. Again, can you just explain why to the Commissioner, please?
Yes, Commissioner, and this actually took us by surprise since there was no valuation, no audit valuation of the wall in our report at all, and we realized afterwards what the minister was referring to. Starting point is that there's no valuation, absolutely none within the audit report that we did. We did a benchmark against Public Works rates and compared those to the rates that were used on this project, and found that the rates that were used were significantly greater. In any event, what we learned in reviewing the minister's comments was that he had taken some information from the report that referred directly to the wall, building of the wall only, and extrapolated that to over the entire project and came up with a figure that would relate only to building the wall. It does not include, for instance, the rails, putting in the rails and painting the walls, both sides, or even the excavation work. So he basically used incomplete information to come up with a figure and then attributed that figure to the audit department, which was completely false.
The third assertion that's in your fact check list is ministry's procedures satisfied government requirements for payments, and you've marked that as false. Can you explain your response as you set it out there?
Right. The government process has a great deal of steps that you have to go through in order to get a payment made. For projects such as this, there must be a certification that the work was done. And what we found, and I marked this false because what we found is that the ministry actually prepared certificates claiming that the work was completed in certain areas when in fact it was not done. And this is actually a circumvention. Well, this is a breach of public finance management regulations to do this, and it might go beyond that. So in that sense, to say that the ministry's procedures satisfied government requirements was false. And I think the minister took it a little bit further because he implied that the Treasury would not have paid if he hadn't met the requirements. And I have here that the Treasury can't go out and check to see whether or not his certificates are actually accurate or representative. The Treasury has to rely on the certificates, has to rely on the individuals who prepare these to actually be able to do their jobs. And that's what they did in this particular case. And it turns out that the certificate that was presented for payment was actually false, was incorrect.
Your fourth point is that there are no quantity surveyors in the Auditor General office, and you've marked that as true. And I think what you say, and I'll deal with this, so you say the audit office does not provide quantity surveying services, nor does it claim to.
That is correct.
At 5, the minister's assertion was recorded as the Auditor General has requested more resources for staff and training. and you've said true to that. Again, please explain a little more to the Commissioner your response.
Of course, Commissioner. And I think I alluded to this yesterday, that and the minister could make this comment because I have made it in standing finance, and I've made it in standing finance more than once. And I may have made a comment elsewhere as well. The office is understaffed. And as I said to you yesterday, we are at this particular moment, we are probably at about 50% of what our authorized numbers should be. And I also said yesterday that I'm hoping to build, firstly, our BFM section back to what it needs to be, and then address the needs of a financial section, which is, I think, a little bit better off right now than the BFM section. So I would agree that the office is understaffed, and when we can get more individuals, more suitable, qualified individuals within the office, I'm hoping that we can do more of these types of audits, actually, more VFM audits, and keep on top of our requirements for the financial audits that we need to be doing as well.
I'm sorry, but did the lack of staff stroke training undermine the validity of this report?
No, of course
That's
not.
the suggestion.
No, definitely not.
And the sixth point is attached to the audit report should have been a Public Works Department valuation. And you've said to that is false. And I'll read your answer. Your response is the minister does not determine what goes into or is attached to an audit report. I should have said that going on with the press statement, you can have a conclusion to the press statement, which is on the last page and reads as follows. The statements made by the minister in the interview on 284 News and elsewhere in the press are both incorrect and misleading. The contents of the report are clear. As Auditor General, I stand behind the contents of the report and I fully support the members of my staff who work on the public's behalf to promote improved public accountability and transparency. Commissioner, I've reached a natural break. There's one more report that I need to go through with the Auditor General, but I'm sure she is probably very keen to have some lunch now. I think is very keen to have a break. So can I suggest that could we break for lunch perhaps for half an hour?
Shall we try and come back about 1:45?
Thank you.
Yes, 1:45. Thank you very much. Good, thank you. I think we're ready to recommence. Just to make it clear and just so that it's not forgotten, I still have to deal with the issue of the publication of the two COVID reports that the Auditor General has produced, and I'll deal with submissions on that at the end of the evidence today. I don't want to keep any of the witnesses waiting. Thank you. Yes.
Thank you, Commissioner. Auditor General, could I take you please to page 817 in the bundle? This is the first page of a report published or issued by your office on the 27th of January 2020, and it is the report into the government's financing of BVI Airways direct flights to Miami. Again, if I'd like with your assistance just to go through some of the details set out in this report, but it is of course one of those that will be published on the COI's website. No issue has been taken with this. To give some background, first of all, if we start with at 823, please, and look at paragraphs 1 and 2, where you set out the objective of the audit. You say it covered the activity related to the BVI government's financing of BVI Airways et al.'s proposal to introduce direct commercial flights between the Terence B. Lettsome International Airport and Miami International Airport as approved by Cabinet on 23rd September 2015. That's where we're looking at. We need to give that a little bit of background, and we can take that again from your report. But if you go to paragraph 10, you deal with your report in 6 stages, Auditor General, and I'll deal with each stage in turn. But part 1 is the proposal. And at paragraph 10, you give some background, which if I try to summarize, is as follows. And that is in November 2013, the BVI government's long-standing legal counsel in Washington, D.C., Lester Hyman, introduced Bruce Bradley, who was a Washington, D.C. based real estate developer, to the then Premier of the BVI, Dr. the Honourable Orlando Smith. Mr. Bradley was seeking financing and support from the Premier to establish a direct commercial air service between the BVI and Miami using British Aerospace Avro jets. To further this, Mr. Bradley entered into a partnership with Jerry Willoughby of BVI Airways and Scott Wiseman of Colchester Aviation. What then happened was that, and you deal with this at paragraph 14, on the 5th of June 2014, the government signed a memorandum of understanding with Bruce Bradley's company, Castleton Holdings LLC, to allow for an exploration of the viability of the project. And this is at paragraph 15, there were obligations set out under the MOU, both obligations for Castleton and obligations for the government, but it included requiring the commissioning of a feasibility study and marketing plan for the project from 6L Consulting Group Incorporated, and also the commissioning of a pavement condition study, which was a study to look at the Terence B. Lettsome Airport runway. You note in your report, and this is at paragraph 17, that both studies, the cost of both studies were to be shared equally between the government and Castleton. That's Bruce Bradley's company. If we move on, then what happened at paragraph, and this is at paragraph 16, was that 6L Consulting Group issued a report in September 2014, sorry, paragraph 19 this is, And it was, I won't set it out, but it was a positive report in that it said that the program offered a low cost and execution risk solution. It provided the BVI with a significant opportunity to increase its penetration of the annual air market. It would potentially stimulate BVI air passenger traffic from new markets, and it would produce a good return in terms of cash flow. What then happened, however, was that on the 14th of December 2014, the Premier rejected the proposal, and that was because of concerns over the cost commitment and scepticism about the growth assumptions being put forward in the 6L proposal. And there were a number of key areas that were identified. Now, if I take you to paragraph 33, that's the point we had reached in by 14th December 2014, and that was that the project had been refused. But then you say, and this is at your paragraph 34, following the government's rejection of the proposal in December 2014, the Premier was contacted by the government's US legal counsel and lobbyist, Lester Hyman, in an emotive missive, which sought to arrange an urgent meeting in January 2015. This, Mr. Hyman suggested, would allow the parties to meet in isolation with a view to ironing out the issues of interline arrangements and capping the government's financial exposure, so the parties could enter into a definitive agreement as contemplated by the MOU within 2 weeks. Now, interline arrangements, as I understand it, are arrangements where airlines carry out services on behalf of other airlines.
Yes, it makes air travel easier.
And so the question I wanted to ask you about paragraph 34 was the use of the phrase emotive missive. Where does that come from, if you can remember?
It comes from the tone of the email that we reviewed. Essentially, it appealed to his emotional senses rather than to his business senses. And this is where we put emotional, and in fact it's a trend that we noted in Mr. Hyman's correspondence quite often when addressing the Honorable Premier. That was somewhat inappropriate.
The next step that happened was that the government then engaged a local accounting firm, BDO, in January 2015 to assess the merits of the proposal. And BDO's study concluded that the proposal, and this is the proposal outlined in the MOU, I haven't given the detail of that, but that it was inequitable because it required the government to bear the costs and risks while the operator parties were guaranteed the returns. And the report identified a number of operational concerns around the aircraft, and that advised that these needed to be addressed, and that the financial terms needed to be renegotiated to more appropriately apportion risk and reward. If I take you to paragraph 36, what then happened was that on the 26th of August 2015, the government and what you've called the operator parties, and that's the group of people I mentioned at the beginning, which was Mr. Hyman, Mr. Bradley with Castleton, BVI Airways and Colchester Aviation. The government and those parties arrived at a basic position, which then led to a decision paper being submitted to Cabinet, and Cabinet approving a number of conditions to pave the way for an agreement between the parties. Now, the conditions included at 2 that, if we take 1 and 2 together, that the government would support BVI Airways in providing a direct flight between BVI and Miami for a 3-year period. And that support would take the form of financial input of $7 million distributed in annual installments. There would be full disclosure of financials by BVI Airways. The government would have a seat on the BVI Airways board. At least 10% of the shares in the new venture would be made available for local investors. The financial model would be vigorously scrutinized by the Ministry of Finance and consultants and the Attorney General's chambers would vet the agreement prior to it being signed. What you say also is that, firstly, that the conditions were all approved by Cabinet. Secondly, that information provided to Cabinet also stated that Castleton, the company owned by Bruce Bradley, would be investing in excess of $6 million into the venture. But you also note, and this is at paragraph 39, that the BDO financial assessment report that recommended changes for a more equitable arrangement was not included among the papers presented to Cabinet.
That's correct.
In any event, the project continued, and the next step was the signing of a framework agreement, which was signed on the 7th of December 2015, which adopted the terms of the MOU, the Memorandum of Understanding. You set out the detail of that in your report, and it runs across 1 and a bit pages, but it includes that BVI Airways would launch a commercial air service by 31st of October 2016, that the operator parties had the right to immediately terminate if the BVI government failed to provide a letter of credit for $7 million by the 19th of January 2016. The government had the right to terminate with 30 days notice if the service was not commenced by the 31st of December 2016. And the government was to reimburse BVI Airways for startup costs, operating losses during the initial 3 years, up to a total of $7 million. The government was also to guarantee BVI Airways an annual return on investment of at least 20%. And what you note, and this is at paragraph 41, was that although there was an initial proposal to share in, for the government to share in the profits, that wasn't included in the framework agreement. Is that right?
That is correct, yes.
What the government's return would be, and their only return, and this was on the $7 million investment, would be repayment of the guaranteed amount, but that was contingent on available funds being available after other provisions were satisfied.
Yes, that's correct.
So again, in layman's terms, the repayment of the government's monies was not top of the list.
No, it was not top of the list.
The next part of your report deals with implementation. Now, under the framework agreement, the amount the government was going to put into the venture was to be paid in installments. Is that right?
That is correct, yes.
But the problem that the government experienced was that it could not secure the letter of credit that was required under the framework agreement.
That is correct.
And so what government did was to make various early payments to BVI Airways. And by May 2016, it had remitted to the airline $5 million. Looking at your paragraph 47.
Yes, that is correct.
And on the payment schedule that was under the framework agreement, the BVI government was only required to pay 2.9 million at that point.
Yes, that is correct.
Now, the final 2 million under the framework agreement was only due after the air service was successfully launched. But what followed was an addendum to the framework agreement, and that was intended to remedy the breach that was caused by the government's failure to obtain the letter of credit. And what that required the government to do was to deposit the remaining $2 million in an escrow account for the benefit of BVI Airways, but also to make an additional payment of $200,000. Have I understood your report correctly?
Yes, you have.
And so what we have is that even before the airline is successfully launched, 5 million has gone to BVI Airways, 2 million is sitting in an escrow account, and on top of making that up for 7 million, but on top of that, the BVI government is now giving additional funds $200,000 to BVI Airways.
Yes, that is correct.
If you look at 53, there was an agreement in relation to the escrow funds that of the 2 million, 1.2 million was going to be paid on the 30th of May 2017, and 800,000 was going to be paid on the 30th of November 2017, and that was to Colchester Aviation LLC, which was a major shareholder in BVI Airways. There was, you note, no requirement for performance included. But what then happened was that the then financial secretary terminated that arrangement and authorized release of the funds to the operator parties on the 11th of January. So that was before the payment dates had arisen. The remainder of the funds was paid across to BVI Airways.
That is correct, yes.
Now, you say at 54, no authorization from Cabinet was obtained for this early release. Now, is authorization required if you're a financial secretary?
It is, yes.
If we look at 55, you then make the point in the report that there was a protracted approval process. And by that, you mean that there had to be an approval process with UK and US regulatory authorities for flights between the BVI and Miami. And that process lasted for more than a year and a half.
Yes, it did.
And what you say at 64 was that flights to Miami were, under the agreement, scheduled to commence by October 2016. The date was subsequently extended by 8 months, taking us to June 2017. But apart from regular announcements and promises of service, no steps were taken to commence flights either regionally or as planned internationally into the US after the approval process was complete. So as far as you could ascertain from the information provided to you, Auditor General, there was no steps taken to actually get in place an ability to commence flights?
There were no steps taken to actually commence flights from the BVI to any destination.
What you say, and this is at 66, if we go there. So if I can have a moment, please. Two and a half months after approval was obtained, the airline took an inaugural flight, and that was a charter to transport the BVI National Athletics team to Mexico.
Curacao.
Sorry, yes, for the Carifta Games.
That's correct, yes.
And then BVI Airways then actually commenced a leasing arrangement with one of the aircrafts to an airline operating between Haiti and Cuba.
Yes.
So was the effect that they effectively reduced the complement of planes that they had to do a flight between BVI and Miami?
We showed that they had ability to do flights, they just were not doing it between the BVI and any other destination. They had a crew and they had the airlines, but no flights commenced between the BVI and Miami or anywhere else in the Caribbean.
There was an announcement by the Miami Airport director in June 2017 that BVI Airways would be commencing its route in July 2017. But what you note in your report is that it was immediately countered in the press by BVI Airways, asserting that the director of Miami Airport had jumped the gun. And then 4 weeks later, BVI Airways suspended operations, citing lack of funding. And that's when the project effectively came to an end.
That is correct, yes.
And you remember that one of the things that Cabinet was told was that Castleton would put $6 million into the venture. This is your paragraph 72. You note that that never materialized. Is that so? You couldn't see that sum being put into this venture at all?
That money never actually got into the venture, and we actually questioned the individual about it and didn't get a satisfactory answer. I think there's a comment in here.
So in terms of what monies went in to finance the venture, was it the 7 million from the BVI government?
Only the 7 million from the BVI government, to my knowledge. I don't know of any other amount that went in.
If I take you to paragraph 80, please. This is a section headed depleted operational funds, pre-operational financial statements. And you say, the expenditure reported in pre-operational financial statements submitted by the airline to the BVI government are unsupported and inconsistent with other records, rendering them unreliable. What you note, and this is at your paragraph 81, was that the BVI Airways submitted just one set of financial statements, which were unaudited and covered the period from the beginning of January 2016 to 31st of March 2017. And that was the extent of the financial records they provided to the BVI government?
That is correct, yes.
You highlight a number of matters of concern, but what you say, and this is at the bottom of 82, you say the financial statements show that the company received zero income, but incurred $4.25 million in expenses, of which $3.07 million was allegedly paid in salaries and professional services.
That is correct.
And in terms of the airline had an accountant in the BVI who submitted payroll information and financial statements to the Inland Revenue Department here in the BVI. And if I understand the report correctly, your team conducted a verification exercise on the salary amounts put in. Is that right?
Yes, that's correct.
And what you found was that the amounts in the pre-operational financial statements were either substantially overstated or the payroll taxes submitted to the government were severely underreported. So you couldn't match the two across.
The two were not nowhere close, actually. There was a significant difference between the two.
What you also found was that although the operators were asserting they'd invested over 2 million into the venture, other than the government financing, there was nothing to show that BVI Airways received any other kind of investment or loan financing.
That's correct. Based on the statements they submitted, there was no evidence that they had actually invested anything into the company.
And what you also concluded was that in 2017, Colchester Aviation LLC spent 3.3 million in undefined expenses. And your conclusion at 90 was that an audit must be performed by a firm of independent accountants for both companies in order to provide accurate information on their expenditure activity and afford assurance on how the government's monies were applied. That's an audit of BVI Airways and Colchester Aviation, is that right?
That is correct, yes.
What power would the government have to sort of compel an audit of that sort?
The government cannot compel an audit of that sort. It's the most it can do is request that these agencies actually do commission such an audit. And I think only a court of law can actually make them to do this. Outside of actually having an audit done on this, the records that were submitted are not reliable.
The next point you make in your report is that as this was all going on, and in anticipation of this service commencing, the BVI Airport Authority undertook various upgrades to facilities, which came to costs of $735,000, which the authority then sought reimbursement from the government for. Now, obviously, because BVI Airways didn't actually operate, those upgraded facilities were never used by that airline, were they?
No, they were not used by BVI Airways.
Do you know whether the government did reimburse the airport authority?
At the time we did this exercise, they had not been reimbursed.
If I go to paragraph 96, under the heading Government Oversight Imbalance, you say there were inadequate government checks and balances in the oversight of the venture, leading to unilateral decisions being made on significant matters. Now, one of the points you pick up in the report is the position of the financial secretary, because you make the point that the financial secretary was assigned the role of the government's official liaison with the project, which allowed the operators to have ongoing high-level access and support from within the government, but as you say, created foreseeable issues. So what issues, in your opinion, were foreseeable?
What is said here is that it created a conflict whereby the financial secretary's obligation to ensure the successful launching of the project may have obscured his public duty as a primary custodian of government's finances. In other words, he had the authority to do certain things as financial secretary, and perhaps the obligation, as he saw it, to assist the airline in achieving its goal might have caused a blur in those obligations, both the conflict, and I think things might have happened that could have been prevented if there was adequate separation of duties.
In effect, he was trying to wear two hats. He was trying to do whatever he was placed in a position where, as the official liaison, he had to do whatever he could to ensure the success of the venture.
Exactly.
But as financial secretary, he also had to act with prudence and with regard to the public purse. And a short while ago, we were looking at an earlier part of the report. I drew attention to two things: the fact that payments were made in advance of the letter of credit and not according to the installment payment plan in the framework agreement. And secondly, the decision to release the escrow payments. Do you see those two decisions as examples where that line is blurred?
Yes, absolutely, sir.
What you also say, and this is a paragraph 100, is that the position of the Attorney General, who was vetting the legal documents, and the Accountant General, who was making the repayments, was that they were making periodic objections, and that there were the Attorney General made amendments to draft agreements, and these agreements had all been initially drafted by the operators. I understand it.
That is correct, yes.
And so the Attorney General was making amendments to these draft agreements intended to protect the government's interests. But none of these were adopted, is that right?
I wouldn't say none of them were adopted. A significant number of them were not adopted. And in particular, one of the objections the Attorney General was made repeatedly was commercially, I'm trying to remember the term that was used. It basically didn't hold the operators fully liable to actually get this done. To use the commercially best efforts, I think it was. That was a part of the agreement, and the Attorney General would repeatedly delete that phrase from the documents, and it would go back in.
And in terms of
just one moment.
I'd like to adjust.
No, please, yes. It's all right. It's sometimes just a small adjustment helps with the recording, Miss Webster. Yes, thank you very much.
The next part of your report covers government compliance and due diligence, and that's at page 839. And you made a number of findings in respect of compliance and diligence. And the first one was that the report that was done by 6L Consulting was, you say, the government's answers to the requirement of the protocols for effective financial management for a business case. But you point out that the report focused on only one solution and did not consider alternatives. And you say that the analysis appeared optimistic in its break-even projections. Just so, if an entity wants to produce a business case that fits in with the protocols for effective financial management, is a prerequisite that you do consider and set out alternatives.
Yes.
You make the point also that none of the recommendations made in the BDO report were adopted. So that report, which was much more cautious than the 6L study, none of that didn't find its way into the framework agreement at all. Is that right?
That is correct.
And at paragraph 111, you say that both the protocols and the public finance management regulations require that projects undergo a tendering process. But there was no invitation for competitive submissions, nor was there any comprehensive examination of alternatives, such as cost of improving the ferry system or pursuing an established airline to undertake the route. This venture, you say, was unsolicited and unplanned. And so was there a complete bypassing of the tendering process?
Yes, there was a complete bypassing of the tendering process. And at no stage during the discussions were any steps actually taken to initiate that process.
And what you also point out, again, in terms of compliance, was that there were a number of decisions that were made or conditions that Cabinet set, which in effect were disregarded. So Cabinet had authorized a maximum of $7 million to be paid in even installments over 3 years, but that wasn't mirrored in the payment schedule in the framework agreement.
That is correct.
Cabinet required that the agreement be contingent on the completion of interline agreements with major airlines, and also that the Ministry of Finance subject the financial model to scrutiny. That was ignored.
That was not complied with, yes.
How does it work? I mean, if you take the framework agreement as an example, if Cabinet has authorized a particular payment plan and that is varied, does it then have to come back to Cabinet? Is that how it should work?
It should come back to Cabinet. And in fact, when the draft documents were vetted again by the Attorney General Chambers, it was brought to their attention that the plan that was in the document did not match what Cabinet had approved.
And who was the lead ministry on this project?
Lead ministry would have been the Premier's office.
What you've also set out, and we see this at, if we go to paragraph 119, and you've detailed this. I don't need to go through the detail of it, but those parties who were, or you say who spearheaded the proposal in 2013, bought promises and a proposal, but no experience in establishing or operating an airline. So what you've done in your report is you've looked at the particular parties that approached the BVI government and looked at their background and history. And it's evident from what you set out in your report, Auditor General, that they had no particular experience in operating an airline. Their backgrounds were in law, investment, real estate, and banking. Is that right?
That is correct.
If we go now to paragraph A,
With one exception, Jerry Willoughby actually had some background as an aviation practitioner. He was the only individual that could speak to it. But not as, I haven't seen anything where he was involved in setting up and running.
and on the government side, did the government have anybody to advise them in terms of setting up an airline? Was there anybody on this side to be able to assist the government?
No, there was nobody from the industry per se to assist the government in setting up an airline. I think most of the advice related to this project came from the Attorney General Chambers, who was very good at cautioning the government with respect to what he was saying at the time. But someone from the industry, no.
If you go to page 845, please. This is part of the report where you, it's headed contentions. And in effect, perhaps it could also be described as disputes, because it sets out perhaps the breakdown of relationships between the two sides. And what you make the point, which you alluded to earlier, Auditor General, is that the operator parties engaged in emotive and urgent communications with the government to secure support for their project. Towards the end, the operator parties' tone shifted to accusatory and uncooperative, even as they solicited additional public funding from the government. The accusations and contentions arose around issues related to airport development, exclusivity, financing, and confidentiality. So just the one bit I would want to focus on is just the subject of exclusivity. You say at paragraph 151, from the beginning, the subject of exclusivity was continuously raised by the operator parties and repeatedly rejected by the government, which viewed the suggestion as impractical and unsustainable. Could you just explain exclusivity, please?
Exclusivity meant that the airline would be given the sole rights to fly between the BVI and Miami, and none of the other airlines, larger airlines that might come on board after the extension of the airport, the extension of the runway, none of these would be allowed to partake in that, and certainly not without the approval of this particular airline. And the government thought that was not a workable position, especially if it was going to invest in a substantial amount of money in extending the runway and developing the airport. So every time this subject was brought up, it was rejected by the government. And at no time during the discussions was there any leeway in terms of exclusivity, because it was simply not a workable solution for developing territory.
If you go to 156, or so let's take it at 155, which is at page 846. There, you take us to July 2016, by which time the full 7 million had been paid over under the framework agreement, plus an additional 200,000 by the government to BVI Airways. But then you say that nonetheless, by February 2017, the operator parties had again approached the government for further financial support. This request failed to garner sufficient support amongst legislators who were adverse to investing more public funds into an operation that had yet to deliver. So from that point, after the 200,000, was it the government's position that they were not going to be putting any more funds into this venture?
That was a position. They wanted to see some results before they could even consider open a discussion into the possibility of assisting further. And I think at that stage too, there was a lot of public response to what was going on, and the government was taking note of that and didn't want to run further afoul with this particular project.
But what then happened, obviously, was the correspondence continued with the operator parties seeking more public funding from the government, and that continued for some time.
It did, yes.
In terms of the government being able to obtain information about the financial position of BVI Airways, if you go to 172, please. 171, let's look at that. That's at page 849. A law firm of Conyers, Dillon, Pearman was engaged by the government in 2017 to assist with resolving issues relating to the general non-performance of the venture. Conyers made repeated requests, but no information was provided to them by the operator parties other than the unsupported financial statements that you were able to look at. So that was all that Conyers were able to get out of them. What you say at 172 was that under the framework agreement, BVI Airways were required to submit quarterly financial statements. And that would show the progression of the activity for the airline, provide management information of the company's operations. And you say the quarterly statements were never provided. Who were they expected to provide quarterly statements to?
To the government, to the BVI government.
Was it any particular ministry? Was it to the Premier's office or to the?
This would have been to the Premier's office, since they were that was the office that was responsible, that was guiding this entire process. And the financial secretary was actually the person who was acting on behalf of the government. So I would imagine that it would have been done through him.
So what you note is that there was a set of financial statements, which is the ones that you've looked at from BVI Airways. Financial statements in summary form were received from Colchester Aviation, which was a major shareholder in BVI Airways. But the statements you say for both companies were unaudited and unsupported. And then other information, such as the current register of directors and beneficials, owners of the operator companies, and the evidence of ownership of the aircraft was not forwarded.
That is correct.
Again, Auditor General, just it's sort of in layman's term, you have a situation where the government has paid across 7 million to an airline, and is the position that, and we're looking at sort of sometime in 2017, that at that point, the government would not have had an even complete picture of the financial position of BVI Airways and its major shareholders.
That is correct, yes.
And the government would not have even been able to say who owned the aircraft that were due to fly between BVI and Miami.
Also correct, sir.
You then deal, but I don't think I need to do it, but you set out in your report the termination of the system. And in fact, you say matters came to a head when the Premier, matters came to a head in May 2017 when information reached the government alluding to plans by the operator parties to sell or lease the planes that had been acquired for the flights. And the Premier then issued a letter before action. And ultimately, the venture was shut down. That was announced on the 18th of July 2012, which was on the cusp of BVI Airways receiving final authorization to commence mandated flights. And then the ultimate result was that on the 1st of October 2018, the government engaged Martin Kenny & Co. to undertake a cross-border investigation with a view to obtaining evidence to facilitate recovery of 7.2 million that had been advanced to BVI Airways. What you say, and this is your conclusion, section, and it's at 193. You concluded that the manner in which the project was introduced and progressed suggests that the operator parties were attempting to take advantage of the territory's existing airlift issues by providing a solution that would guarantee them above market returns without the financial risk. This conclusion is consistent with the observations made in the BDO report and is borne out by the fact that despite initial promises of $5 million to $6 million investment, the summary pre-operational financial statements show very little investment input by the operator parties. You then say, and you've headed that risk-free investment, as the position was that the government bore all the risk.
That is correct, yes.
And under anti-competitive requests, you say, the framework agreement was crafted by the operator parties and heavily favoured their interests. Despite this, they continue to expect and insist on additional preferential treatment from the government in the form of continued financial support and concessions to secure their profitability, even if this meant compromising the interests of territory. This was demonstrated by their insistence that the government should postpone the airport runway expansion and their repeated requests for exclusivity to eliminate any possible competition that would impact their profitability. When their requests were not accommodated, the operator parties, having not invested any of their own resources, opted to abandon the venture. You point again to the fact that, and this is there was no accurate accounting of how the amounts that the government had put into the venture were applied. And you've noted a number of project implementation failings where you say the government erred in many respects in the implementation of this project. Some of these were in contracting an airlift agreement with parties who lacked relevant industry experience and operational contacts, agreeing to a joint engagement of technical experts to examine feasibility of the project. That's the fact the 6L study and the pavement condition study were jointly commissioned, failing to adopt the BDO advice, allowing emotive and urgent pushing from the operator parties to dictate government's involvement in the venture. I'm going to pause there. I mean, we saw that term was used at the beginning. Across the correspondence that you saw, was that tone reflective of the approach that the government?
It was reflective of the approach that one individual in particular took, and that was I'm trying to remember his name.
Lester Hyman, I think.
Lester Hyman. It was reflected of his approach, and normally the correspondence would be touching on business and then a whole lot on the personal relationship that existed between the Premier and himself. And this is a term that I don't use in my reports, and this is the only report that you would see emotive correspondence being mentioned, because it played such an important part in pushing the project forward, appealing to the emotional side and the good nature of an individual. And that's what initially drove the project, and at the end, when it was falling apart, this is what was used to try to keep the government involved and try to keep the government given in terms of the financial support.
You then go on to say, failing to adopt the amendments made by the Attorney General in the draft agreements, failing to secure a written commitment from the operator parties of their financial input into the venture, and to ensure that this obligation was incorporated into the terms of the framework agreement. Just to clarify that one. So on your audit, that the operator parties would also be investing in the venture did not make its way into the framework agreement.
It did not, no.
So that was that just sort of extraneous documentation that was put in front of Cabinet, but ultimately just didn't get incorporated into a contract.
It completely fell out of the discussion.
Effectively, the next point you make is effectively removing the performance requirement from the agreement that required BVI Airways to commence flights before receiving the final $2 million government advance. And then the last one you say is assigning the individual in charge of the government's finances serve as the primary facilitator to implementation. There was no higher financial authority to question or prevent his decision to make early and complete payments to BVI Airways, which were contrary to cabinet authorizations. You've made, again, Auditor General, a number of recommendations. I won't read them out, but save for one, that you say senior public managers or the government's gatekeepers should not assume roles that can create a conflict with their public fiduciary duties. But in terms of the response to your recommendations, can you assist the Commissioner with what response you received to those recommendations?
Well, basically justifications on what the response was dealing with the matters that arose, and justifications on why they were handled that way. That was it.
Just give me a moment, please. Commissioner, I think I've reached the end of my planned questions. Maybe, I don't know whether just to invite the Auditor General if there's any other matters that she wishes to add based on the questions that I've put to her, if she wants to make those points to you at this stage, it might be helpful.
Ms. Webster, two things. Could I just ask one question, a small question about procedure? When you have produced your report and you've explained how that's done, the relevant ministry, etc., has an opportunity to have their input into what is effectively a draft report before the final report is produced. You produce the final report and then you report to whomever is appropriate in a Section 20 case to the Governor. And then the report is then sent to the House of Assembly to be tabled. Then I think they have a debate or a discussion about the report. But once your report is finalised and it's sent to the Governor and then it's sent to the House of Assembly and then published, the report, I assume, doesn't change.
No, it doesn't change.
So, I mean, it goes to the Governor, it goes to the House of Assembly, and it is discussed, but it doesn't change before publication.
No, it doesn't.
No, thank you very much. Is there anything else, Auditor General, that you want to add to all of the evidence you've so helpfully given over the last couple of days?
Just to hear that. The report wouldn't change.
I'm sorry, could you put the microphone closer to you, please?
I'm sorry, could you draw the microphone a bit closer? Because the stenographer just needs to capture what you say.
Okay. I was saying that the report doesn't change, but if there's a significant something that we might have missed somewhere, we would put an addendum at a later report, and that would be close to the front of the report so that it's noticed as it's.
I understand. Yeah. I understand. That's helpful. Thank you. Anything else to add, Auditor General, to the evidence you've given?
I can say that I've been Auditor General for almost 30 years. And that would not be an exaggeration. I certainly have served in the audit office for almost 30 years. And what I've seen over that period of time is a willingness in public offices to basically bypass the rules and make excuses for having bypassed the rules. And the concern is that with that, over a period of time, it's becoming the culture within the government that it's acceptable to disregard the procurement requirements, to disregard certain processes that have to be done. And I think there needs to be an understanding that those rules are put in place to protect the government. They're put in place to protect transparency. They're put in place to protect this territory, because without them, it's a slippery slope. And my concern is that we are becoming used to what is happening. And if it doesn't stop, it's going to be a very costly exercise for the territory in the long run.
Thank you very much.
Thank you. May I ask just one question that comes from the Commissioner's last question? I've taken you to a number of reports, Auditor General, and those are the reports that will be published on the COI's website. In relation to those reports, they obviously span a number of years, but in no case did you have to add an addendum.
No, we have not.
Thank you very much. The only final thing I'd like to say, Commissioner, is first of all to thank the Auditor General for the evidence that she's given today and yesterday. Secondly, to thank her for her patience in dealing with the COI and the time that she's given to assisting us over the last 2 days. And finally, to thank her very much for the way in which she has given her evidence.
Can I echo that, Ms. Webster? Thank you for your time, which is quite a bit of time, but it's been very valuable for me. And thank you for the clear and forthright way you've given your evidence. It's much appreciated.
Could I ask you to rise briefly, Commissioner, whilst we reset the room for the next bit?
Yes, thank you. Good. I think we're ready to resume. Mr. Dennis, I think the first point is your application to assist in representing Dr. Orlando Smith whilst he gives his evidence. I've seen your application, thank you very much. And let me say at the outset, I propose to let you assist him. But subject to any other submissions you make, not under section 12. Section 12 would make him a participant in the COI, which would mean that at least prima facie, he would be entitled to have sent to him all of the documents on any topic in the COI, which I suspect neither he nor you would want, because there is a lot of information. But I can, under the COI rules, allow you to be with him during the time he gives his evidence. And if there are any other witnesses where you want to sit in, effectively as an observer, but if you want to take part in respect of any of the other witnesses, then please let us know, and we'll almost certainly accommodate that. So substantively, yes, but not quite under the provision that you applied under.
Yes,
not your fault.
yes. Well, thank you very much for that indication, Commissioner. And I believe that that is an eminently reasonable approach with which we are quite happy.
Good. Thank you very much, Mr. Rawat.
Thank you, Commissioner. Can I, before I begin, just for the record, just record the representation that's in the room this afternoon?
Yes.
We have, as we had this morning, the Solicitor General, Joanne Williams-Roberts, who is here on behalf of the Attorney General and the elected ministers, and that is together with Lauren Peaty of Withers BVI. As you've indicated, Mr. Paul B. Dennis QC is here on behalf of Dr. Orlando Smith, who is going to be our next witness. There is no representation either in person or remotely from Silk Legal, who represent a number of members of the House of Assembly.
Yes, thank you.
Our next witness is Dr. Daniel Orlando Smith. Dr. Smith has previously given evidence to you, Commissioner, so there's no need for him to be sworn again.
No, thank you very much.
Dr. Smith, thank you for returning to give evidence to the Commission. I won't go through perhaps the long preamble that I did on the last occasion with witnesses, but safe to say that there are a number of bundles you'll see in front of you on the desk. We won't need to go through every single page, but I will take you to one or two documents, if I may, as we go through your evidence.
Thank you.
Can I also ask, as I do every witness, please do remember to keep your voice up and to speak slowly. The microphone that you'll see in front of you will record your voice, but it won't amplify it. And so it's very important that everyone hears what you have to say and that your answers are recorded accurately. Could I take you, you should have a bundle that's labeled Part 2 there. It's one of the bigger lever arch files. On the side, it should be labeled Part 2.
I think it's one of these here.
One of the bigger ones.
Dr. Smith. It'll be one of those.
And if you're at that, the first page should be 517. It's in the bottom right-hand corner. If you go through, please, to page 817. If I've taken you to the right page, Dr. Smith, you should have the Auditor General's report on the government's financing of BVI Airways direct flights to Miami.
That's correct.
And that's what I'd like to ask you some questions about this afternoon. I appreciate that this is going to be a subject with which you're familiar. And so hopefully I won't have to read out chunks of this report to you. I'm sure it's a report that you're also aware of from when it was issued. And so But if you do need me to take you to any part of it to assist your memory, please do ask me. We've just gone through with the Auditor General the detail of this report, and in her report she sets out the background which really led to the BVI government entering into a framework agreement ultimately with BVI Airways. And the first event that the Auditor General's report points to is in November 2013, Lester Hyman, who was the BVI's US legal counsel and lobbyist and had been in that role for some 26 years, introduced Bruce Bradley, who was a prospective investor and realtor, to you. Prior to that meeting, had you had any contact with Mr. Bradley at all?
No, I had no contact with Mr. Bradley before that.
A point that the Auditor General makes is that this was a sort of unsolicited and unplanned approach. Is that your recollection of what happened?
Mr. Hyman, who was a legal representative or lawyer in the United States, was aware that we were interested in improving the airlift situation, particularly to Miami. So I think he was on the lookout for any opportunity that he thought would interest the BVI government.
I see. And did Mr. Hyman was he eventually an investor in BVI Airways?
No, no.
So he merely facilitated the introduction?
Yes.
That introduction and meeting ultimately led, and you can see that at page 824 if you need reminding, Dr. Smith, it led to a memorandum of understanding in June 2014 between the BVI government, of which you were then Premier, and Bruce Bradley, specifically with Bruce Bradley's company, Castleton Holdings. I'll let you go to the page if you want. It's 824.
824.
The memorandum of understanding stipulated that Castleton would undertake certain steps and that the government would have certain obligations under the memorandum of understanding. One of the steps that was required was Castleton to commission a feasibility study, and that was done by 6Cell Consulting Group. And there was also the commissioning of a pavement condition study concerning the runway at the airport here in the Virgin Islands. The cost of both studies is recorded as being shared equally by the government and by Castleton.
That's correct.
Now, one of the points that the Auditor General has made, or I suppose one of the questions she's raised, was the fact that these studies were jointly financed. Why was that considered a better option for the government than commissioning your own independent studies?
It was decided that we needed a study to be able to identify that this project was feasible. And this study would benefit both Mr. Bradley and the government. And this is why we decided to do it as a joint study. We both paid for the study. If I go back a little bit, if I may, to the first question. When we were first approached by Mr. Bradley with Mr. Hyman, one of the reasons why we were interested is because at that time, as Minister of Finance, Minister of Economic Development, I was very concerned about the economic development of the BVI as far as the financial services and tourism is concerned. As you would probably recall, financial services has been under quite severe strictures over the past number of years. And very much in mind, we knew that we had to concentrate more on developing our tourism product. In order to develop a tourism product, we long thought, I was convinced as well, that a direct flight from Miami to the BVI was important. Hence, we got into this. We had flights before that. Flights came via St. Thomas, via Puerto Rico, via St. Martin. But they all entailed delays and inconvenience for passengers who could easily stop off in St. Thomas or St. Martin or Puerto Rico without having to come all the way to Tortola. And so we were convinced that this would help develop the economy of the BVI, along with other things such as getting more hospitality establishments and so on.
You say, Dr. Smith, that this had been a long-held view. Your view or view of other members of the cabinet as well?
Members of the cabinet, yes.
Prior to this approach in November 2013, and you've told the commissioner that Mr. Hyman was aware of that this was something that the government was considering. But prior to that approach, had the government taken any steps itself to investigate the feasibility of this option?
We had before a relationship with American Airlines between Puerto Rico and St. Thomas, which we gave them guarantees for seats, etc. But after some time, the American Airlines pulled out of the territory, and there was no appetite for them to get back in simply from Puerto Rico to Tortola, or even from Miami to Tortola. And American Airlines was the main airline in the Caribbean in those days.
But had you, for example, approached any other established airlines to see if there was interest in them putting in place a flight from BVI to Miami?
I personally had not. I think Mr. Hyman was on the lookout for such an opportunity for us.
Mr. Hyman had acted for the BVI government for 26 years.
That is correct.
So I think if my maths is right, from taking it back to the time when you gave evidence about the register of interest, he'd been acting for the BVI government even before you came into politics.
That is correct.
What was the nature of your relationship with Mr. Hyman?
I met him after he came to the BVI, and we became acquaintances, so, and we'd maybe have breakfast together sometimes or visit his home for functions, just as would occur with any other person in the BVI.
Was he more than an acquaintance? Would you describe him as a friend?
A friend, yes.
So did you develop, in your time as Premier and Minister of Finance, had you developed a personal relationship with Mr. Hyman?
He was a friend. I would not say that he developed a very close personal relationship. No, I don't do that.
If you look at 827, the next step in the sequence of events, taking it shortly, was that after the memorandum of understanding and the obtaining of the 6-cell consulting report, ultimately on the 14th of December 2014, you as Premier rejected the proposal. And what this is at paragraph 32, if you want to look at it, sir. But what the Auditor General records was that you rejected the proposal to become involved in the venture, citing concerns about the cost commitment and skepticism with the growth assumptions put forth in the proposal. Now that seems to be the proposal in the 6-cell consulting report. Can you assist the Commissioner further with just what particular concerns did you have as of December 2014?
We were concerned that the cost of the government was too high. What we were entering into was an arrangement which most Caribbean countries will have with airlines, that is, they do give seat guarantees. So it was that similar kind of arrangement that we went into, but we were concerned that the cost for the government was too high. We also further got company BDO to do an assessment of that project for us. And they also agreed that the cost was too high.
I see.
They gave that report, and the final decision not to continue into the relationship at that particular point happened in January 2015.
Can I come back to that in a moment, the BDO report? Because what I wanted to draw your attention to is paragraph 34 of the Auditor General report, because after you as Premier had rejected the proposal, the Auditor General records that you were contacted by Lester Hyman in an emotive missive which sought to arrange an urgent meeting in January 2015. The Auditor General's evidence today, I think bringing it together, was that at times the correspondence that the BVI government and yourself as the Premier of the BVI government received from what she calls in her report the operator parties, those running BVI Airways, was emotive, that it crossed the line and that its tone wasn't appropriate at times. Did you consider that, and we are talking obviously of a process that spanned years, did you consider that the correspondence to you was emotive?
On occasion, yes. My responses have always been calm and.
But did you see that as an attempt to take advantage of a personal relationship?
Not necessarily. When Mr. Hyman spoke with me or wrote, he was referring to the development of the service, which he thought was key to the continuing development of the tourism product in BVI. That was my understanding. And he would be naturally very supportive of that. That was my understanding at that time. Yes.
Stepping back from this, this project spanned 2013 through to 2017 when it came to an end. We're now in 2021. I mean, who was Mr. Hyman acting for ultimately? Do you think that he was acting in the interests of the BVI government, or do you think he was acting in the interests of those who invested in BVI Airways?
Could I ask a question before I continue?
Yes.
Yeah. There was a representative from Martin Kenny and Company.
He's here.
He's here.
Okay, good, fine. Okay, good. Yeah. And initially, during the course of the discussion, he was always represented himself as government's legal representative. It was after all that has been over and we engaged Martin Kenny and Company that we recognized that there was some conflict.
Prior to that, prior to the engagement of Martin Kenny and Company, had it occurred to you as Premier that there might be a conflict?
No, there did not seem to be a conflict. I think my impression is that he was concerned, as I was, about getting the airlift that was necessary for the territory.
You've mentioned already, Dr. Smith, the BDO report, and it's mentioned at paragraph 35. So BDO, a local accounting firm, engaged in January 2015 to carry out a financial analysis of the proposal, of the merits of the proposal. And I think if you turn to page 839, the Auditor General helpfully summarizes the points made in the BDO report as follows: that the 20% interest rate contemplated under the MOU is far too aggressive given the lack of risk borne by Castleton. And BDO recommended in this interest rate between 5% and 8%. The reference to 20% was in relation to financial support being given by the BVI government. The second point that the Auditor General draws from the BDO report was that government should not proceed unless interline agreements are completed. The third is that the government will be taking on a significant liability risk by signing a revenue guarantee contract with parties that apparently lacked relevant operational experience. And last, the age of the aircraft would likely lead to greater maintenance costs. More modern aircraft should be considered, even though they may be more expensive to lease. Now, I think what can be said about BDO's advice, it was not as optimistic as 6Cell's advice had been. And in fact, it was quite the opposite, wasn't it?
Correct. Yes.
Did it give you pause for thought?
It was partly, largely as a result of that advice by BDO that we stopped the project. That was what I termed the 2014 project. That was when we asked BDO to come in and review that proposal.
And so what then happened was that there was further discussion nonetheless. And on the 26th of August 2015, the BVI government and operator parties arrived at what the Auditor General says was a basic position for an agreement. And there was a meeting in August 2015, which then led to a decision paper being submitted to Cabinet.
Let me just, thank you.
Please.
Let me just emphasize that there were two different agreements. The agreement we were pursuing in 2014 ended with after the BDO report. The report was on that agreement, and that agreement was we terminated that. And after that, in the following year, in August, I think, that's when we had a different proposal from the operator parties.
And was that again a proposal facilitated by Mr. Hyman?
Yes.
The decision, the Cabinet gave approval to, at a meeting on the 25th of September, to a number of conditions that have been set out in the position paper.
That's correct.
I won't read them all out, but they are listed if you need them in the Auditor General's report. But one of the points she makes is that the BDO report was not included amongst the papers presented to Cabinet. Can you explain why that wasn't done?
The BDO report was not on the project that we presented to Cabinet. The BDO report was on the 2014 project, which we discontinued.
Well, you've got two projects, your 2014 project and now a 2015 project.
Correct, yes.
Can you tell the Commissioner what were the substantial differences between the two projects?
In the 2014 project, we were subsidizing, having a seat subsidy on an ongoing basis. In the 2015 project, the government had decided that our contribution would be no more than $7 million. In the 2014 project, it would have been up to $10 million. We decided to scrap that and go with a different arrangement. And the government's contribution would be put in earlier and not on an annual basis, depending on the seat arrangements.
So in terms of taking that proposal to cabinet,
Yes.
you couldn't rely on your evidence on the BDO report because that related to a different proposal. What independent advice had you taken at that time?
The advice, we considered the report, the BDO report, when we were looking at the new arrangement, right? For example, that is one reason why we decided that the amount of government intervention must be capped at $7 million, whereas in the former arrangement it was up to $10 million. So there were aspects of the BDO report which informed us how to negotiate about the other one, the 215 project.
But you didn't then get anybody else to come in, a consultant or anything to say, right, well, this is our proposal. Because the proposal you put to cabinet, as I understand it, was a proposal that had been developed following further meetings between yourselves and the operator parties. And who conducted those meetings from the BVI government side?
They were, the persons at the meeting were three. There was the financial secretary, there was the head of the tourism board, and there was another individual from the airport authority.
And were you yourself involved in those meetings?
I was not at that meeting, no.
See, so there was sort of delegation from the BVI government that took it forward.
Correct.
But what you didn't get was, so you, if you like, came to an agreement with the operator parties, a new agreement, the 2015 proposal, which you took to cabinet.
Correct, yeah.
But you didn't get an independent expert to come in and say, well, this is what we propose to cabinet. Tell us whether it's a viable option or not. You didn't ask that question.
We did not get an independent expert for several reasons. First of all, we did have the video report, which referred to the flight between Miami and BVI, and it would have had references which would have been useful in the other report which we used. That is why, as I said before, we were decided to cap our investment by 7 to 7 million as opposed to 10, which was in the 2014 project. As well as that, the person from the tourist board, he was well versed in matters of tourism, and there was a gentleman who was from the airport authority who was well versed in the operations of the airport authority.
Dr. Smith, although I understand that in 2015, the maximum exposure of the government was reduced from $10 million to $7 million because the revenue stream was taken away. Understand that, and that's obviously to the advantage of the BVI government. But in terms of the other points raised by BDO, which are referred to in this report, because this report refers to that cap, in 2015. The interest rate it referred to being 20%, which was far too aggressive, it said, that interline agreements must be completed, it said. Age of the aircraft would lead to greater maintenance costs, it says. And the parties with whom you were contracting apparently lacked relevant operational experience. But all of those points apply to the 2015 agreement, didn't they?
No, but I can address those right now. Right. First of all, let's take the interline agreement. We had many discussions on the interline agreement with various airlines, but what we understood is that you cannot have an interline agreement until you're flying. So once the airline got off the ground, then you'll be able to negotiate to get interline agreements with other airlines.
So the BDO point that well, the BDO point, as it's set out in this report, is that you shouldn't proceed unless they've been completed. So you accepted that interline agreements were necessary, but you considered that they couldn't be put in place until the main agreement was up and running.
Until the planes were flying.
Yes.
And could you remind me of the other point?
Certainly, the interest rate of 20%.
Well, that was changed with the new.
That was changed with the new agreement. The other parties apparently lack relevant operational experience.
Yeah. There were, let me answer that. There were 3 people involved. There was Mr. Bradley and Mr.
Willoughby. Is Willoughby another one?
and Wiseman.
And why?
Mr. Bradley and Mr. Wiseman. There were 2 successful business people. And Mr. Wiseman was a banker and an investment manager person. And then Mr. Bradley was a serious investment, had some serious investments going with it and very successful. So they had the acumen, or the business acumen, to be able to do this. Mr. Willoughby, he was a pilot. He retired from the US Air Force as a general, and he was also as an instructor with the US Air Force. So he had the knowledge about planes and management and so. And they also brought in with them a senior pilot who could assist with the operations.
Thank you.
But to go back to the interline agreement, that seems to have been one of the conditions that Cabinet put on the agreement, because what the Auditor General's report records is that the agreement would be contingent on the completion of interline agreements with major air carriers operating via Miami International Airport. And so it seemed to be that, well, although you've said that your understanding was that these could not be put in place until flights had commenced, Cabinet's position seemed to be that unless you had interline agreements, and this is at page 828, unless you had interline agreements in place, the agreement could not proceed.
But after we explored the reality of interline agreements, our cabinet colleague, my cabinet colleagues understood the situation.
But did the framework agreement ever come back to Cabinet for reappraisal?
Not on that, no, not on that matter.
From that point. One of the other points that's made was that Cabinet was told that Castleton, which is Bruce Bradley's company, would be investing $6 million into the venture. Does that accord with your recollection? Were you told that as well?
Yes.
Was that commitment ever obtained in writing?
No, that commitment was not obtained in writing.
And it didn't form part of the framework agreement ultimately, did it?
No, but the financial secretary, the Ministry of Finance carried out their due diligence on the individuals involved and determined that they were, satisfactory in order to carry out this enterprise. What we were arranging with the operator parties was a service, and this is what the framework spoke about. We were getting a service from them, that is flights between Miami and BVI, and we were contributing a certain amount, up to $7 million to this service.
I suppose that the ultimate problem was that the government got to contribute the 7 million, but it never got the service.
Well, we can get to that. Yeah.
Mm-hmm. What Cabinet also required in terms of the agreement that it approved was that the financial model would be vigorously scrutinized by the Ministry of Finance and consultants to verify the anticipated payouts by the government. Now, according to the Auditor General's report, that requirement was disregarded by the government. Can you explain why that didn't happen?
We had an agreement with in the framework after the cabinet passed, we had an agreement to give certain amounts of money at certain times, which was determined by cabinet, and this is what we were being guided with when we started the operations.
But aside from the agreement, and that's an agreement to pay 7 million in specific installments, isn't it?
Yes, that is the agreement to pay that, and the agreement on their side was to provide a service.
Yeah. But what cabinet had asked for was that the financial model be scrutinized by the Ministry of Finance. So what I take from that was that the Ministry of Finance would undertake an assessment of the financial position of BVI Airways, the financial position of the investors, the financial viability of the project. And what the Auditor General's report effectively says is that that scrutiny did not happen in this case. My question, Dr. Smith, is just why didn't it happen?
But what I can tell you is that the Ministry of Finance, they did do a search on the operator parties to determine their financial capacity to undertake this operation, and they were satisfied that they could.
You were Minister of Finance at that point. That's your ministry undertaking a search.
That is correct.
Were you satisfied about the extent of the due diligence that was done?
I was satisfied with what my financial secretary informed me.
And did your financial secretary, which is Neil Smith at that time, did he take the result of that scrutiny to cabinet?
No, that was not taken to cabinet. There was no requirement to take it back to cabinet. Cabinet gave the ministry, the premier, an agreement to go forward and develop this airline with. And so that is what we were doing.
So who was going to assess or decide that the degree of scrutiny undertaken by the Ministry of Finance was sufficient?
The Ministry of Finance, in all previous arrangements of any business arrangements, they always carried out the due diligence in these matters.
But what we're talking about, Dr. Smith, is, I'm sorry, I'll let you finish.
And it depends on what you're, what business you're progressing. In this case, we were actually having a service and providing a seat guarantee, but ahead of the flights. And they determined that the persons involved had the capacity, the financial capacity to be able to support that.
So just so that we can understand your evidence, and this is you as Minister of Finance, you were satisfied from what you were told by your financial secretary that this was a justified use of $7 million of public money.
Yes.
You were satisfied from your financial secretary that the individuals who were the operator parties, which is Mr. Bradley, Mr. Willoughby, and Mr. Wiseman, were capable of running an airline that would fly people from the BVI to Miami and back.
I was, yes.
And you were satisfied that those individuals had the financial viability themselves to invest in an airline.
I was satisfied.
But did you see documents? Was it just, were you just told, we've done a check, we've done our due diligence, it's all okay? Or did you say, well, show me the report, show me some evidence?
No, I didn't say show me the evidence. My financial secretary, he did the work as he would have done in most other cases like this.
One of the other conditions that, or the terms that Cabinet approved, was that the Attorney General's chambers would vet the agreement prior to being signed. And a point, and if I can take you to it, but it's at paragraph 100 of her, say page 838, please, Dr. Smith. The Auditor General records that throughout the venture, this is paragraph 100, there were periodic objections from the Attorney General who vetted the legal documents, all of which originated from the operating parties, and the Accountant General who was tasked with making the payments. Significantly, several of the amendments made to the draft agreements by the Attorney General that were intended to protect government's interests and import balance and certainty into the agreements were reversed by the operator parties and subsequently not adopted. Were you aware that the Attorney General was raising concerns about the agreements?
I was aware that was the Attorney General made comments and they were discussed and a position was arrived at, which we went forward with.
The conclusion of the Auditor General is that significant amendments that the Attorney General advised should be made to the draft agreement were not implemented. Why was that the case?
Many of the common recommendations that he made were adopted, some were not, because there was continued discussion between myself and the ministry and Mr. Hyman, the other attorney involved, and we saw that the ones were adopted were the ones that we should adopt.
And so you were satisfied that these agreements, both as Minister of Finance and Premier, that these agreements were appropriate for the BVI government to enter into?
I was satisfied at that time, yes.
Were you not concerned with 2015 that the government was entering into a position where it was carrying the risks whilst the operator parties were going to enjoy the profit?
What we were, as I said before, what we were doing is negotiating for a service between the BVI and Miami. And we were giving a seat guarantee, which was, put at the front of this whole agreement. And so once we got the service that we wanted, the cost would have been justified.
And the service you wanted was just someone to fly people from Miami to the BVI?
The service we wanted was an operation to fly people between Miami and BVI.
Do you consider now that the BVI government did go into this transaction with full awareness of the risks?
We did go into it with all the considerations that we were just discussing.
Yes. It is a significant amount of public money. I take your evidence, Dr. Smith, about the fact that this was an issue, especially after American Airlines pulled out, that the government wanted to address. But if you wanted to put such a scheme in place, if you wanted to have flights, direct flights operating into the BVI from Miami, why did you not seek competitive submissions? Why not put it out to tender and see what you could get, rather than entering into an arrangement with 3 investors that was negotiated, it seemed, by a long-standing lobbyist and lawyer to the BVI government?
When we considered the options, as I said to you, the American Airlines, which flew to BVI from Puerto Rico, discontinued their engagement. And there were no other airlines who were flying in that arena at the time. There were 2 local airlines in the BVI, but they were not expanding at that point to be able to satisfy those needs.
But with respect, it may be me the way I've put the question, but if you wanted to get an airline to consider this proposal, why not go and go to the market and see if there was interest? What seems to have happened in this case is that Mr. Hyman approached you in 2013 and the discussions then continued, and the government at no point stepped out of those discussions and said, let's go and talk to somebody else and see if they can do us a better deal. That was the position, wasn't it?
And that is true, but as I said earlier, Mr. Hyman was essentially also interested in having us BVI have this service, not necessarily from the operating parties that we engaged with, but before that. And we followed this lead and went with these operating parties. As you said, we could have negotiated with American Airlines or some other airline, but American Airlines actually pulled out of that area and weren't interested, and they were the main carrier.
But other than American Airlines, is your evidence that there were no other established airlines that the government could have spoken to about taking this route on?
We could have spoken to Liat, for example, but given the way Liat was operating, they were not interested in that time flying between Miami and BVI. Well, earlier, about maybe 2 years before, we had a discussion with another company group, but we weren't satisfied with that discussion either.
But once you were, so we can understand it, once from 2013, when that first approach was made by Mr. Hyman, the government did not at any point after that go and speak to any other airlines about taking over the route.
Not after that, no.
Nor did the government say, well, here we are, we have 3 men who've appeared on the horizon and want to do this route. Let's go and see if there's anybody else who also wants to take it on.
At that point, we did not.
But basically up until July 2017, when it shut down, you hadn't had any discussions with anybody else, had you?
No, we continued the engagement with this group.
And the point is, isn't it, Dr. Smith? I mean, I know we're all operating with hindsight, but from November 2013, although the terms changed, as you've explained, there was a 2014 agreement and a 2015 one, but throughout it all, the government was negotiating and contracting with the same individuals.
That is correct. Yeah.
And in between the government and those individuals was Lester Hyman.
That is correct.
And you considered Mr. Hyman to be acting on behalf of the BVI government.
That is correct.
But, and you did not see the potential conflict of interest, that he was effectively not just acting on your behalf, but he was a middleman at best between yourselves and the operator parties.
No, we did not see the conflict at that time, no. I could also point out to the fact that many years before, there was a gentleman, Mr. Cripps, a United Kingdom person, who came to the BVI and built a hotel called Prospect Reef. And he started an airline as well. And he selected one of our local persons to manage it. And it performed very well until it went out of business many years later. So we have a history. There's a history of individuals engaging starting services for the BVI, between BVI, Puerto Rico, St. Thomas, and other places.
I fully accept that there is that history, and obviously, as you've explained, there is good reason why the government, giving tourism, the importance of tourism to the territory, would want a direct flight. But my questions are directed to how $7 million of public money ended up going in one direction, and you didn't actually get the service that you contracted for, because that was the outcome, wasn't it?
That is true.
Could I just take you, please, to paragraph 41, which you'll find on page 830.
Could you repeat it?
830, please, Dr. Smith. What the Auditor General's report does is it sets out the, and I'll take you back to 828, please, at paragraph 40. Because what the Auditor General concludes is a framework agreement between the parties was signed on the 7th of December 2015 to commence the project. And she then says, this adopted the terms of the MOU, of the Memorandum of Understanding, and included, and then she sets out a lot of detail. But the Memorandum of Understanding predated the decision, the end of the 2014 arrangement. So what appears to have happened is that there weren't just two discrete proposals. You didn't just have a 2014 and a 2015, but when you signed the framework agreement, imported into it were details from a memorandum of understanding that dated from the very beginning. Do you see the point I'm making?
No, I think there was a separate memorandum of understanding. That memorandum of understanding had been dated for 2014, that ended with 2014.
If you look, please, at 40. In terms of timeline and termination provisions, one of the points that the Auditor General has made in her evidence this afternoon was to the reference to 2, because it says BVI Airways was to use its commercially reasonable efforts to launch and operate a commercial air service by 31st of October 2016. And the Auditor General pointed to that phrase, commercially reasonable efforts, as one of those terms that the Attorney General sought to have taken out of the agreement because it didn't favour the government's interests. Do you remember the Attorney General arguing against the use of commercially reasonable efforts?
There was a discussion about that point.
And why did the Attorney General's advice not hold sway?
The Attorney General was giving advice and we were listening. We were also receiving advice from our other attorney who was represented BVI for many years.
And who was that?
That was Mr. Hyman. And we were looking at advice from the persons operating the airport in BVI. And when we considered the investment and what the government was investing, we saw no reason why they could not. And given the fact that they were going to put in, as Mr. Bradley said, 6 million, we saw no reason why they could not perform what they were asked to perform and operate that flight.
The problem for the government, however, was that the offer to put in 6 million didn't find its way into the framework agreement, did it?
Yeah, because the offer to inject 6 million, that was on the operator's party's part to do what they had to do with the flights and the crew and all that. And what was in the agreement was that what the government was going to do to get a flight to the BVI, which would, of course, involve having the proper airport personnel and the pilots and the stewardesses and all that.
if I looking at the framework agreement, the detail of which is in the auditor's report, it places obligations not just on the government, but also on BVI Airways. And that's the point the Auditor General makes, that, you know, that there is an obligation on BVI, on the BVI government to get a letter of credit for 7 million.
That's true.
And that's an obligation on the government. There's an obligation on the government to appoint a special liaison to ensure timely responses and resolution of issues, to facilitate approvals and provide assistance with respect to facilities. So the government has an obligation to reimburse BVI Airways for startup costs and operating losses up to a total of 7 million. But also BVI Airways had an obligation to launch and operate a commercial service. And the 2 points that I would welcome your assistance on are, firstly, slightly returning to it, but what was left in that framework agreement was, against the Attorney General's advice, the term commercially reasonable efforts. And so BVI Airways did not have an absolute obligation to get an airline in place by the 31st of October. They just had to use best efforts, basically, Dr. Smith.
No, commercially reasonable. They had an obligation to do that based on the money that were being put in by the government of the British Virgin Islands.
And what the government didn't get back in this framework agreement, in writing in the agreement, was a commitment from the operator parties to put $6 million into the venture.
No, because, as I said, we had, and the agreement said that they would provide a flight between BVI and Miami. They were supposed to do whatever had to be done to provide that flight and maintain it. For example, they were supposed to have flight crews. They were supposed to get permission to fly from the United Kingdom government, supposed to get permission to fly from the United States government. They're supposed to maintain the aircraft and all the other things that they had to do.
If you look, please, at 829. Under financing provisions, what is said there is that the government to guarantee to BVI Airways an annual return on investment of at least 20%. Now, that's one of the points that was made in the BDO report. The BDO report said the 20% interest rate contemplated under the Memorandum of Understanding was far too aggressive, given the lack of risk, and recommended an interest rate between 5 and 8%. So that's what you had, was under the 2014 proposal that the government had to guarantee an annual return of 20%. BDO said, no, that's far too aggressive, far too much. You paused, you stopped. You moved on to a new agreement, 2015, which you've been telling the Commissioner about. But in that, the ultimate document that frames that 2015 agreement, which is the framework agreement, 20% is back in. So there's still risk there to the BVI government, isn't there?
We always recognized that there was risk in starting an airline and getting it going. But we also knew that we wanted to have this service which would help to improve the economy of the British Virgin Islands. The money that the government was putting into the airline, on our analysis, it was sufficient to get that airline off to go and get started. And then they were to continue and do whatever was necessary, get all the flight crews, everything else to make sure that we had a service.
The point is this is about value for money.
I understand.
Because it's not just about the BVI government putting in 7 million to get them started and then expect them to keep it running. It's that what the government agreed to do was to guarantee those operator parties, those investors in BVI Airways, who were not obliged under the framework agreement to bring any of their own money into it. What the government signed on the dotted line to do was to guarantee that they would get a return of at least 20%.
I mean, it's to do with risk, isn't it, Dr. Smith? I mean, everybody knows that setting up an airline is a risky business, and it's where the risks lie. And the thrust of the report is that the risks lay all on the government, none on the operators, because the government were putting in $7 million. The government were abating all of the airport authority fees, etc. The government were going to guarantee BVI Airways an annual return of at least 20%. On the BVI Airways part, they were guaranteeing no money. They were not guaranteeing getting an aircraft off the ground. Their only obligation was to use commercially reasonable efforts to launch the air service. And it's the balance of risk.
Yes, but when we say commercially reasonable efforts to launch a service, all these the government has put in contributed to the ability for them to launch a service. So we expected that all that risk on our part helped to provide the circumstance for them to be able to provide the flights that we expect.
But that's an aspiration, and I understand that. But in terms of risk, what risk did BVI Airways have? No money risk. They weren't putting any money in. They had no risk at all, and the government had substantial risk because, as I've said, everyone knows that running an airline is a risky business.
But if you were to consider the model that we were looking at initially, where all Caribbean countries engage by having seats.
Guaranteed.
Yeah, I think
yes.
guarantees. This is a situation where the government was our government should be putting forward monies to get to have a service. And the money that we were putting up here was taken it was essentially the guarantee to get the service.
Yes, thank you.
Could I take you to about the monies that the government put in? If I take you, please, to page 831. If you go to paragraph 44, what the Auditor General explains on this page is that, firstly, that under the framework agreement, the government had to establish an irrevocable transferable letter of credit for $7 million by 19th of January 2016. And there is, and we see it, the table that's at 47, a payment schedule by which sums would be paid. And this was agreed by Cabinet, it seems. The problem that arose for the government was that it could not get the 7 million letter of credit. You're nodding, Dr. Smith, but I need you to say yes or no. And then what happened was that the government paid monies in advance of the payment schedule. So it started paying monies, and ultimately I think it paid $5 million to BVI Airways. So it paid sums of money early to deal with the fact that there wasn't a letter of credit. What was then done was that an escrow account was set up so that the remaining 2 million would then sit in that escrow account for the benefit of BVI Airways. And then what then happened was that you went above the $7 million cap and gave BVI Airways an extra $200,000. And these seem to have been arrangements that were put in place to get around the difficulty around the letter of credit. Is that your recollection, Dr. Smith?
The letter of credit, which was supposed to be had, was the financial instrument that would allow the operator parties to be able to say to a bank, okay, we can borrow some money, or to say to investors, we have this arrangement with BVI, which is a solid arrangement, and you are welcome to come in and we can do that, right? So that was what the letter of credit was for. But we had difficulty getting the letter of credit, almost impossible. We took a long time, but we're not able to get it. And then, because of that, we basically established an escrow account. And this was taken back to the cabinet who approved this escrow account, and we set that up. Now, because it wasn't a letter of credit, we essentially were placed in that escrow account monies which were stipulated for various times in that escrow account so that they could be drawn at the various times to support the venture.
See. What then happened, however, was that the financial secretary terminated the escrow arrangement and authorized the release of all the monies to BVI Airways. And what the Auditor General noted was that no authorization from Cabinet was obtained for this early release. Were you aware that no authority had been obtained from Cabinet to release the sums?
When we went to Cabinet to establish the letter of credit, and that didn't happen, then we went back to Cabinet to establish the escrow account to be able to put money into the escrow account. And there were some banking charges and everything, which that's where the $200,000 came in with, without establishing that escrow account, as I understand it. The escrow account was dissolved when it was necessary to provide the rest of the money so that the operations could continue.
But were you aware that
Yes.
no authorization had been obtained from Cabinet to dissolve the escrow account?
Yes, I was.
Did you sanction that?
What I did do was sanction the giving advancing of the funds to the airline, especially the 2 million at that point. We were looking at where we were with the establishment of the airline service. They were quite a long way into getting that service up. That is, they had obtained the planes, they had obtained the crews, they had obtained the arrangements, at the BVI airport, and they were well on the way to obtaining the permissions to fly from the UK government, and they had started with the US government. So when we looked at where we were, we thought, okay, then we should be able to advance the last $2 million, and then we'd expect the flights to be up and running by the time that they were supposed to be.
And so did you authorize the financial secretary to release those funds?
I did authorize the financial secretary to release us to $2 million.
And you did that knowing that authorization from Cabinet was required?
I did that on the basis that we were at a point where we were virtually almost ready to take off. And we thought that it would be a right to get the flight going.
But as we understand it from the Auditor General's report, taking that step requires Cabinet authorization.
Yes, we did not get Cabinet authorization at that time, but we did have discussions with members, And later on, we did, that is later on after it was happened, we did take a paper to, when we took the cabinet paper to about the employing Mr. Hyman, not Mr. Hyman, Mr. Martin Kenny, then all that was put into that cabinet paper for retroactive assessment by the government and the cabinet.
By which time you had given all the money to BVI Airways, and in fact, BVI Airways had ground to a halt and ceased trading. That's when Martin Kenny got involved, wasn't it?
That was after they had gotten all the permission to fly, both from the United Kingdom and from the United States. And that's when they ground to a halt. That is when, I continued to have discussions with them about financing, because the government, we were not at that point prepared to go back to the government and say we need to give them any more monies. That was not in question at all.
Did you presumably appreciated, however, that perhaps contrary to the initial intent of the BVI government, because the framework agreement provides that BVI Airways would use all commercially reasonable efforts to have flights operating by the 31st of October 2016. The original payment schedule for the 7 million envisaged that there would be payments from the BVI government after flights had started. So the original payment schedule envisaged that monies would be paid in November 2016, May 2017, and July 2017. And in fact, all the monies were paid across before the 31st of October 2016, and all the monies were paid across before a single flight had occurred. Did you appreciate that occurred, that was the position that the government had found itself in?
All the monies, the last $2 million was paid across before the flight happened. But after we could not get the letter of credit, we then extended the time before they were supposed to fly, so that we gave enough time to have everything in place because of the time it took to get the letter of credit sorted out.
One of the points that the Auditor General makes in her report, Dr. Smith, is that there was very limited financial information provided to the BVI government about the viability of BVI Airways. BVI Airways were supposed to provide quarterly financial statements, and these were never provided according to the Auditor General. Were you aware, as Minister of Finance, that no such statements were being submitted?
I was not initially aware, but then I became aware, and we asked for these statements. And there was a director, BVI director on the board, and he asked for those statements. We did receive some statements, but they were not complete.
No, I mean, the Auditor General says one set of statements were received, which were, or what was received was unaudited and unsupported. But did you receive those statements after all of the 7 million had been paid across?
That was after, yes.
And so at the time that you paid 7 million across to BVI Airways, they were not complying with the framework agreement in giving you quarterly statements.
They were given statements. I cannot at this point remember if they were given quarterly, what the statements were like. But
well, according to the Auditor General, the one set of financial statements that were provided on the 22nd of May 2017. So that was after all of the monies had been paid across. So it would seem, wouldn't it, that at the time that you paid 7 million across to BVI Airways, the government had not been provided with any substantive financial evidence to show the financial health of BVI Airways?
There were some statements provided, not the details that we wanted, but there were some statements provided.
Could I move on to just a different topic, if I may, please? Dr. Smith, you should have on the table in front of you, you should have a loose leaf document which should be headed, it's Public Accounts Committee, final report on the cruise ship port development. It's just, if I can ask your assistance, that this is about the cruise ship port development, which the Auditor General reported on in 2013. I think this is a 2014 report. Now, one part of this is, if I take you to page 9, I just want firstly a question of dates, but to set the scene for you, the evidence that the Commissioner has heard from the Auditor General explains that when there was the port development at Wickham's Quay, it was first of all led by the Minister of Communications and Works, but there came a point, and this is why I've taken you to page 9, when the Ministry of Finance took over. Now, this was in August 2012. Were you Minister of Finance in August 2012?
I was.
If I can just take you through this, what the Public Accounts Committee said was that the committee examined the process through which the project was tendered by the Ministry of Finance after it was brought to a halt in August 2012, and the non-binding agreement with TPP terminated. Now, that TPP is Tortola Port Partners.
Correct.
And what the finding of the Public Accounts Committee is that the tendering process was lacking in transparency and fairness, and was a further usurpation of the authority's role, the authority being the Port Authority, who would have been responsible for the pier and for the land around it. And they identified 2 or 3 main areas of concern. The first was that the Ministry of Finance put out sought an expression of interest. And what the committee said was the length of time provided to tenderers to prepare this complex, high-value, long-term project was insufficient to allow for adequate investigation, technical evaluation, and preparation of the comprehensive submissions required for this project. The initial notice allowed for a 2-week period ending on 16th August 2012. 2 extensions were granted, first to 28th of August and then to 12th September 2012 for a total of 6 weeks. But the time frame still fell short of that required for a project of this magnitude. So was that taking you back to your time as Minister of Finance? This was a criticism. It was a criticism flagged up by the Auditor General, but also made by the Public Accounts Committee, that in effect, the Minister of Finance gave too short a time window on this tender process. Was that a criticism that you accepted as Minister of Finance?
It was, I would say that it at the time was a bit short, but this process was going on for a considerable time. And the persons involved, I think people knew what was going on. And it was thought then by the ministry that would have been adequate time for them to make presentations.
Now, you say the persons who were involved knew what was going on. Which persons do you have in mind?
When I say the persons involved, I mean, this process has been going on for quite some time. And many people, other companies, I can't remember the companies offhand, they knew what was going on. Some of them had expressed interest. So it was a matter of them getting ready over this period of time.
The company, and this is at B, it's the second criticism made by the Public Accounts Committee, the company that had been previously involved and up until then was Tortola Port Partners, and only them. When the tender process was put out, and this is from the Auditor General today, the tender process was put out, there were three responses to the expressions of interest, and then subsequently 2 submissions, one of which was from TPP, as they are referred to here. But what the criticism that the Public Accounts Committee makes is this: the project requirements that were put to public tender and subsequently amended by the Financial Secretary closely resembled the project details that were previously submitted by TPP and accepted by the government. Striking similarities were noted in the required design, the exit provisions, and training requirements. The committee found this to be suspect, as it would put other potential tenderers who entered the process at an immediate and severe disadvantage. Now that was, so there are 2 things that are going on. Firstly, a short time window, and secondly, that the requirements matched ones that had previously been put to government by a single company. Now that's the criticism that I've outlined to you of the Public Accounts Committee. Was that a criticism that you accepted at the time as Minister of Finance?
The ministry responsible for the operation reports, that was a kind of response that they wanted, because they had a view of what they wanted to see the development look like.
When you say the ministry responsible, Dr. Smith, which ministry do you have in mind?
That is the Ministry of Communications. They had a view of what they wanted to see development look like. Of course, they were in conversation and discussion with the ports as well. And so they had a view of what they wanted to see it look like. And that would have been represented in the expression of interest, which would have been put out.
But the conclusion that one draws from those 2 criticisms is that this wasn't a fair tendering process, because there was one company, TPP, that had an immediate advantage in making a submission under that tendering process. Would you accept that criticism?
If it is so that, no, like I said, the ministry, the minister, the ministry, the ports, they had a view of what they wanted to see. If Tortola
I think it's Port Partners, I think that.
Tortola Port Partners had put out something similar before. This did not deny the minister and the ministry and the ports what they wanted to see. They did not say, okay, because that company had put out this, it doesn't mean that we have to divert them because this is what we wanted.
The last point that's made is that the team, if I perhaps to give you some context, please, Dr. Smith, what had happened at this stage by the time the Ministry of Finance got involved is firstly that this was the responsibility of the Port Authority, but it had been taken over by the Ministry of Communication and Works. And they had taken it to a point where they had accepted a proposal from TPP. That then stopped. The Ministry of Finance took over. This is the stage at which we're talking at. Right. And so if you look at C, what had happened is that when the Ministry of Communication and Works were involved, they had used a consultant. And by the time we get to C and the Ministry of Finance being involved, that consultant is now the managing director of the BVI Ports Authority. And what the Public Accounts Committee says at C is this: the team assessing the tenders included the former consultant, now managing director, Mr. Claude Skelton-Klein, who had by that time already established a relationship with TPP and its principals, having been involved with this team and participated in the selection, promotion, and facilitation of their submittal in the prior process. This created a prima facie conflict of interest for the individual, whose motivation and decision-making could be compromised by the ongoing relationship. So you have three issues that arise when the Ministry of Finance take over and decide to put it out for expressions of interest. Firstly, a too short time window. Secondly, requirements that give an advantage, an apparent advantage to TPP. And third, a conflict of interest, because one of those now involved in considering the proposals is a person who had previously had a relationship with TPP. Now, those are three criticisms that I've summarized for you. You were Minister of Finance at the time. I suppose bringing it down to one thing, were they criticisms that you accepted at the time as Minister of Finance?
When the matter was presented by the ministry to the Ministry of Finance put out the tenders and received the tenders, what would have come back to myself and other members of the cabinet to make a decision was the results of those tenders and the analysis of them by the committee in the Ministry of Finance. And this is what we would have looked at.
Commissioner, may I have just a quick moment, please?
Certainly.
Commissioner, I've no further questions for Dr. Smith. Can I conclude by thanking him for returning to give evidence and also thanking him for the evidence that he's given today?
Again, Dr. Smith, thank you very much for coming. Thank you very much for your evidence.
Thank
It's
you.
much appreciated.
If you could quickly rise for 5 minutes and then we'll get ready for the next witness.
So, thank you. Yes, Mr. Ramos.
Thank you, Commissioner. Our next witness is Neil Smith. Could I ask that Mr. Smith be invited to either take the oath or affirm?
Thank you. Mr. Smith, would you like to swear an oath or make an affirmation?
Well, affirm, please.
Affirmation.
Yes.
Would you like to take the sheet in front of you and turn it over?
Yes, I see.
Okay. And read the words.
Okay, I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Thank you.
Pass me the Bible. Stay out of your way.
Mr. Smith, thank you for coming
Sure.
to give evidence, and I'm sorry we've had to keep you waiting a little longer than we would have wanted. Can I start off by asking you to give the Commissioner your full name, please?
My name is Neil Maynard Smith.
Thank you. I try to keep my questions short and simple, but if at any time I ask you a question that you have difficulty understanding, please do ask me to repeat or rephrase it. You'll see that there are a number of pieces of paper and also some bundles in front of you. We may not need to go to all of them, but when we do, I'll take you to the documents.
Sure.
The last thing to ask you is just to remember to keep your voice up and speak slowly, please. You'll see that there's a microphone in front of you. It doesn't amplify, it records, but if you can direct your voice towards that microphone, that will be helpful. Can I just confirm that you were the financial secretary at the time of the BVI Airways project, is that right?
Yes, I was.
Could you just give the Commissioner a short outline of your professional background before you became or you were appointed financial secretary?
Before I became financial secretary?
Yes, please.
Okay, so I'm a professional engineer, electrical engineer, registered with the Institute of Engineering and Technology in the UK. I left the BVI Electricity Corporation, I think, around about 2003. I was generation engineer, acting generation engineer at the time. Before I left the BVI Electricity Corporation, I had already obtained, due to the fact that I had to manage and do a lot of financial forecasting and stuff as part of my duties. I had, by the time I got to the Ministry of Finance, a graduate degree in business and finance. So that was before I got to the Ministry of Finance, yes.
And then did you go into the Ministry of Finance and work your way up?
Yes, so I was Deputy Financial Secretary first. While I was Deputy Financial Secretary, I spent some time in New Zealand Treasury and came back. But a lot of the work I did, the Deputy Financial Secretary was mostly responsible for the operations and, responsible to the Financial Secretary at the time.
And when were you appointed Financial Secretary?
I believe it's 2006.
And when did you leave the post?
2017, I believe, yes.
And was that the time you also left the public service, or were you
I
still?
never left I left the public service would be, I guess, 2019. I left the civil service, not a public service. I'm working with the RDA now, doing work there. Yes.
Right, thank you.
Thank you. Now, in terms of BVI Airways, it'll be something that you're familiar with, and the Commissioner has already taken quite a bit of evidence on it. So hopefully I'll be able to try and focus my questions. If you should see a bundle in front of you that's labeled Part 2, one of the bigger Lever Arch files. If you go to that and go please to page 817. That's the first page of the Auditor General's report into the government's financing of BVI Airways direct flights to Miami. If I take you through, please, to page 827.
Okay.
The evidence that the Commissioner has received is to the effect that there was an initial approach in 2013 to the Premier that led to a memorandum of understanding and reports being taken. So the reports that were taken were a jointly commissioned consulting report from 6L Consulting, and also the government ultimately taking or having BDO prepare a report in January 2015.
Okay.
And at about that time, December 2014, or the government decided not to go ahead with the proposal. There were then further discussions. If you look at page 827 at paragraph 36, by the 26th of August 2015, there was had been a meeting at which the government and the operator parties, and by operator parties, the Auditor General is referring to the various individuals who were behind BVI Airways, whose names will be familiar to you. You'd arrived at a basic position for agreement. Now, first question is, at that time, were you involved in negotiations to get to that August 2015 agreement?
Yes, I was.
And who else was involved in it?
We had Russell Harrigan, who was chairman of the tourist board, and we had Clive Smith, who was an operations manager, I believe.
Sorry, I didn't catch, your voice dropped a little bit.
Yes, Clive Smith, who was operations or duty manager at the BVI Airport Authority.
And yourself, the three of you were
Yes.
the team from the BVI government
Yes.
side, so to speak.
Yes, yes.
And what that resulted in was a decision paper being submitted to Cabinet. Who prepared that decision paper?
I would have prepared that decision paper. Yes.
Does it follow that essentially the issue with all the matter was being taken to Cabinet by the Ministry of Finance?
Yes. Hold on. It might have been the Premier's office, one of the two. We were working so close together at that time. Might have been one of the two, but I remember being the one that wrote the paper, though.
I see.
Yeah.
So whilst it might have been presented by the Premier's office,
Right.
the work behind it was
Wasn't-
from the Ministry of
Yes.
Finance and yourself,
Yes.
as the Financial Secretary. Now, if you look over leaflet 828,
Mhm.
and this is the Auditor General has set out various conditions that the Cabinet approved following the receipt of the decision paper, but she makes a point at 39 that what was not included amongst the papers sent to Cabinet was BDO's financial assessment report. Do you know why that report wasn't put before Cabinet?
No, but I doubt that it was anything deliberate. We had made changes according to what BDO had presented before. So what Cabinet was seeing was amendment, or let me put it this way. The agreement that we arrived to was based on the concerns that BDO had, and also some financial projections and stuff that I did. And so what Cabinet was seeing was, as a result of the BDO report, the concerns that they had, and also some concerns that I had.
What concerns in particular did you have at that time?
Okay, my concerns were traffic. So by the time we got to this point, we are looking to get, I think we calculated 3.5 flights a day. What that means, I guess, 2 flights in one direction and 1 in the other, right? And my concern was whether or not we could keep we would have the passenger numbers and the ticket sales to meet with what we anticipated would be the operational cost of the airline. So after some questioning and prodding and looking at independent data, we had a study done by Falco. I don't recall if I see it mentioned here. That gave us some basic idea what the operational cost of the RJ100 would be. And based on that, we use that type of information to come to the decisions, or well, give me the comfort and the rest of the members on the, I guess it's the negotiating team, the comfort that this could work.
The Falco report that you just mentioned, Mr. Smith, is at paragraph 20, which is at 825. It's the pavement condition study.
It was a little more extensive than that, actually, but that's part of it. Yes, okay.
The Auditor General's conclusion, and I can take you to it if you need it, but her conclusion was that one of the frailties of this arrangement was that there was a failure to adopt BDO's advice for a more balanced financial arrangement. You said that there were changes made because of the BDO advice, but stepping back now, do you accept that that's a valid criticism, that there was a failure to accept?
No, I don't. I think that it's incorrect. I mean, I don't have to explain too much, I guess, but that claim in the Auditor General's report is not correct.
Well, why isn't it correct?
Because the work that was done by BDO was the reasons why the changes were made in the original proposal that allowed us to accept the second proposal.
See, okay. If you go, we're sticking to page 828.
828.
One of the other points that was made, and Dr. Smith, I think, has accepted this. If you look at 37, amongst the information that was provided for Cabinet was that Castleton, which was a company owned by Bruce Bradley, so effectively one of the entities behind BVI Airways.
That's correct.
Would be investing in excess of $6 million into the venture. The point that's made in the Auditor General's report is that the framework agreement didn't refer to that investment, and that's right, isn't it?
Yes.
Why was that not written into the framework agreement? Can you remember?
I have a faint recollection of why, but I don't want to say specifically. But it would have had something to do with risk. But I don't want to say specifically why that concession was made, because I don't recall exactly why we didn't include, what didn't compel them in arrangement to do so.
And the reason is because your memory may be inaccurate.
Yes,
That's
yes,
concern
I don't
you
want
have.
to misrepresent. Yes.
What Cabinet also asked was that the Attorney General's chambers would vet the agreement prior to it being signed. And one of the points that the Auditor General makes is that her conclusion is that amendments that were sought by the Attorney General, she says there were periodic objections from the attorney when vetting the legal documents, all of which originated from the operating parties, and objections from the Accountant General who's tasked with making the payments. And what she says is several of the amendments made to the draft agreements by the Attorney General intended to protect government's interests and import balance and certainty into the agreements were reversed by the operator parties and not adopted. Is that a criticism that you would accept it, that significant amendments that would have better protected government's position did not end up in the agreement?
What I would say is, well, first of all, I don't recall periodic representation. So remember a cluster of representations around a particular time. When we presented the draft to the AG, he did have comments which both of us had extensive discussions on. Primarily, he was explaining to me what his concerns were and why. I expect to make sure that I had a sound understanding of what his concerns were as a lawyer. And the bar was set, as that is the agreement that we should get. The amendments that he made, that was the bar that we needed to get to. And I accepted that the AG is a lawyer, his duty is the law. And I listened. And the minister listened as well, I'm pretty sure. And I remember specifically a concern around, the major concern he had was around the issue about commercially reasonable efforts. I remember that specifically because he kind of gave me education, so to speak, on what it meant and what the differences were between what was expected as being commercially reasonable and what was expected as being reasonable. With his view being that reasonable was a stronger provision than commercially reasonable. However, I also had discussions with Mr. Hyman, who was a legal counsel, apparently. Well, not apparently, that's the way that we use him. He was in government before I got there, and I've worked with him before on intergovernmental agreements with FATCA and US Treasury and IRD. And he had an opinion as well. And I think that on balance, even though I would have preferred, that's the AG, tend to want to listen to them if you're working for government. I think on balance, when we came down, it was decided after a lot of discussions, not with the AG, though he insisted on it, on that provision, not to be commercially reasonable, but to be reasonable. That because it was a business venture, that we would accept on balance with the other risk mitigation measures that we had, or that we'll accept commercially reasonable, yes.
So simply put, was the advice of Mr. Hyman more persuasive than the advice of the AG?
I don't know, I wouldn't say that, no.
So it was irrespective of Mr. Hyman that you decided to go, as we can see, at 828, because that's where the framework agreement is set out. And you can see at point 2 on 828, there is the reference to commercially reasonable efforts.
What I would say is it became a legal argument. Right? It became a legal argument, and in listening to not just the Attorney General and not just to Mr. Hyman, but listening to other legal opinions, other discussions with other practitioners around the place. It was a distinction that eventually we felt that we could live with. Right?
That's right. I mean, I understand that there are legal arguments as to what these phrases mean, but at the end of the day, it was a commercial risk as to whether to use this or this.
Right.
And as I understand your evidence, in the context of your risk assessment, by your, I mean, really the minister's risk assessment, he regarded the risk overall as acceptable.
As acceptable.
Yes, no, I see that. Thank you.
If you go just stick to page 828, and can you see that at the top that you've got the phrase, the terms included?
Okay.
Have you got that? If you go down to 6, these are terms that were approved by Cabinet to pay, and that paved the way for the framework agreement. Now, one of the conditions imposed by Cabinet was the agreement would be contingent on the completion of interline agreements with major air carriers operating via Miami International Airport. Now, the Auditor General's understanding was that these were going to be in place, and that was, that had to be in place for the agreement to proceed. Was that your understanding as well?
That was our understanding. Unfortunately, when we actually tried, the airlines indicated that even though they didn't object to having an interline agreement with BVI Airways, because especially American Airlines was very interested in that route. And the BVI was a place that most of the airlines, well, a lot of the airlines wanted to be Delta, JetBlue, those type of things. Even though they were not against having an interline agreement, generally, they only actually inked these agreements after you had an airplane flying or airline in operation. So they wouldn't have an interline agreement with something that wasn't there yet, so to speak. So they had to see the airline operating. I guess they had to see, the manner operated, the standards that it met, operational policies, those type of things before it actually entered into an interline agreement. So even though that was their intent, we realized after the cabinet decision was made, essentially, and after the agreement was signed, that essentially that wouldn't be the case. That couldn't be the case. So it was a chicken and egg situation where you wouldn't get into a line agreement, interline agreement if you weren't operating, and they won't operate if you didn't have an interline agreement based on cabinet's decision.
That again increased the risk, didn't it? Because you move from a position where the agreement would only be concluded if you had interline agreements in place to a position where you would have to go ahead with this agreement without knowing whether or what interline agreements you would do.
True, but we are pretty confident that we would have the interline agreements. That wasn't you obviously can't. There were verbal contracts, and put that they would actually engage in these interline agreements. But for the purposes of this, having a verbal agreement isn't, it's just a trust between parties, I guess.
Yes, thank you.
What Cabinet also asked was that the financial model would be further vigorously scrutinized by the Ministry of Finance and consultants to verify the anticipated payouts by the government. So I take that, the reference to payouts, to be the 7 million that you were going to pay in installments.
Yes.
Now, by this stage, you'd used BDO, you'd used Sixel, you were heading towards a framework agreement. What other consultants, if any, did you bring in to assist?
I didn't bring in any other at that point. I had quite a bit of confidence in my ability to assess these things because of my background. Background meaning not just the financial acumen that I had, academic training, experience in the Ministry of Finance with these things before. Mathematics is something that we like, engineers like, and the finance acumen on top of that helps. So I had a pretty good understanding of how the models are created and how to apply sensitivity testing, to stress test the models. I've done them before. In BVI Electricity, I've done things like this, not with airplanes, but with models that you use to make financial projections, and also in that case in BVI Electricity to make projections on load and fuel and stuff like that. So I was pretty confident in the mathematics, the technical parts of it. I could consult and did with members of the BVI Airport Authority who, for the lack of a better term, are experts in the way that airplanes operate, what they need in order to operate off of the runway at TB Letsom International Airport. So I was pretty confident that with the BDO concerns that were there, using information from, like I said, Falco had some other information besides just the runway information, using the resources that I had available to me from the BVI Airport Authority, that my assessment of the model was sufficiently rigorous. And I didn't anticipate at the time that it would be necessary to incur additional costs or to tell me something that I already figured out. And that is the reason why we didn't get extra consultants.
one of the, sorry.
Okay,
please
sorry,
finish.
that's enough, I would think.
One of the pieces of evidence that Dr. Smith has just given was that you, as financial secretary, carried out due diligence on the individuals behind BVI Airways, Mr. Bradley, Mr. Wiseman, Mr. Willoughby, and that you assured yourself and assured Dr. Smith that they were appropriate individuals to undertake this venture. Did you undertake that exercise?
Yes, I did so.
And did you do that at the very beginning of this process?
At the very beginning, even before we met in the United States, Washington, DC, actually, I did that. We had access to something that we use regularly called World Check.
Sorry, say that again.
World Check.
World Check.
Something that we use in financial services. Well, in the financial services sector. Well, I should say the financial investigation sector. So I did a search with those. I didn't see any concerns against them, going concerns. I investigated via the internet, I should say, on the workings of Mr. Bradley. Was aware of his strong business acumen, the concerns that he had. When I say concerns, the enterprises that he'd engaged in. As a matter of fact, at the time of the negotiations, he actually had bought and renovated a hotel in Washington, DC, which he subsequently sold, it seemed to me, like for 100% profit. I also looked at Mr. Wiseman, who at the time was a member of the Bar Association, I believe in New York or somewhere, but he was actually a current, and he actually had some strong business acumen as an investment banker, I believe it was. So I felt that the fact that there were no existing concerns on these two main individuals, the fact that they had a demonstration of having strong business acumen, and with Mr. Wiseman's case, because it certainly appeared that he was still a current member of the bar in the United States, and coupled with the fact that our legal counsel in the United States, Mr. Hyman, had actually made representation in their favor. Him also being a member of the bar, so I know that he had to make sure that he did things properly as well. All of those things convinced me that they were decent people to work with. But mostly it had to do with there were no concerns based on my investigations on World Check, and number two, because of the demonstrated business acumen that they had.
But what none of them had. I mean, Mr. Willoughby was an aviation practitioner and had various roles in aviation. But none of them had experience of actually running a commercial airline, did they?
Yes.
That's
Agreed.
right.
Agreed, yes.
And were you not at all concerned by the fact that Mr. Hyman was the middleman? Didn't it occur to you that he had a conflict of interest?
No, that didn't occur to me, the other conflict of interest, because we had been involved with him in, as I indicated before, very sensitive work before. We had no reason to believe that he would not have been exhibiting the same level of professionalism. And yes, I agree that neither Mr. Wiseman nor Brad, what's his last name?
Bruce Bradley.
Bruce Bradley.
Or indeed Jerry Willoughby. Jerry
well,
Willoughby.
he came in, he was there, and we knew that he had extensive airline experience because he was a training captain in Delta for a long time. He was retired Air Force, General US Air Force. Not retired, but had retired, meaning he retired in good standing. And I know that they're funny about those things. And also, I knew enough about airlines based on my research, again, and using the advice of the individuals at BVI Airport Authority, that the issue with running an airline is not necessarily the airplane is the last bit of it. The major part of running an airline is a business. So if you're a good businessman, or if you have a proven track record of dealing with businesses and making investments, then you have the skills to have a successful venture. The issue about the airline business, that's another issue where you need specialized skill, which Mr. Willoughby had on the concerns that you need to address in respect to an airline business itself. So I know that the business acumen was there because that was a primary concern. And the specialized knowledge, Mr. Willoughby had enough experience and training that where he might have had deficiencies, I was confident that he knew enough to request consultation where he didn't have specific knowledge. So yes, I knew that I didn't have airline experience, but I knew that they were astute businessmen, capable businessmen, and that Mr. Willoughby had the wherewithal to know what he didn't know and to get that when he needed to get it.
Did it not concern you that these astute businessmen were not willing to sign up to a framework agreement that incorporated in writing their indication that they would put $6 million into this venture?
That was a concern.
But it wasn't a sufficient concern for the government, yourself as the financial secretary to the government, for the government to insist that it was incorporated into the framework agreement.
Well, it's all about managing risk, right? And the risk that doesn't come out in the report, the Auditor General's report too much is, and maybe I could explain, Commissioner, a little, is that before the considerations for the BVI Airways, I call it an intervention, came in, and you'll understand why I say it's an intervention. In the Ministry of Finance, we had been developing and had gone quite a ways with in developing a macrofiscal model for the government of the Virgin Islands, meaning that we were able to make fairly accurate projections. Eventually, I think by the time I left the Ministry of Finance, these projections were like within 1 or 2% of what actually happened in terms of what the funds that we collected and the income and the expenditure side of government as well. And what we had to recognize, even after, and we always stress test these models, that within a decade, and possibly within 5 years, that the government of the Virgin Islands would not have been able to meet its financial obligations to its stakeholders. The government of the Virgin Islands had embarked on a national health insurance program, which, we thought that was a good idea in the Ministry of Finance in terms of the economics of it. They had made commitments to improve the social protection and social development work that had a value, a cost attached to it. They had made some commitments to improve infrastructure. Roads, especially, were concerned. They had made commitments to improving education, which was expensive at the time on the budget. Then I think it was around about $11 million, which is about 5. It was around $11 million, if I recall. I don't want to say the percentage, I remember what the budget amount was, the total budget. And in order to meet these commitments, or projected commitments, right? There would definitely have to be a reduction in expenditure or an increase in income coming into government. A number of options were considered by the Ministry of Finance, including, but not, this is not extensive. They need to control expenditure within government. One of the options that someone threw out was shrink the size of the civil service, for example, and also the services that it offers to its stakeholders. That wasn't acceptable. So we decided to do what we call an expenditure efficiency type initiative. So you control expenditure, but you try to just be more efficient in how you spend money. We also considered raising taxes, which would have had the opposite effect, we believe, to what we're trying to achieve. And we did make proposals to the government of the day to adjust some fees. You know, for example, the government of Virgins, I think even now, cannot cover the cost of some of the services it offers with the fees that it charges. So those suggestions to that were made, only some of them were agreed to. We supported, and I myself was quite actively involved in financial services commitments. You know, strong efforts were being made to increase market share and protect market share. So I spent quite a bit of time doing that. So they had actually done that. But the most, well, in conjunction with that, the most significant thing that we believe that we had to do was to get some economic growth. So you grow the economy so you could tax more. So you might need to change the rate of taxation or the tax burden on the stakeholders. But if you have economic growth and a bigger economy, you get more tax intake. So the way to meet the income deficiency that we projected was to have economic growth. This venture, that's certainly context of how I'm going to answer this. This intervention was part of a two-pronged strategy. This was a short-term intervention and the extension of the runway in order to get the direct flights from the eastern seaboard of the United States was a medium to long-term solution, right? This was the first part of that because we knew that we would not be able to grow the economy from work that had been done by the tourist board and ourselves in the past, or that we would not be able to get the hotel plant that we were looking for. We wouldn't be able to increase the number of beds. And also the financial services itself would not be able to expand in what we had to deal with later on in economic substance, deeper work in the financial services. So we knew that unless we facilitated economic growth using both these interventions, that we'll face a problem that would lead to the government of Virginia not being able to meet its commitments later on. So in that context, the decisions that the issue that you pointed out, which we had to deal with ourselves, we said on balance, if we supervise this matter properly, and if we continue to believe or continue to have confidence in the advice that Mr. Hyman was given, that we believe on balance, that was a risk that we probably could take.
But it was only a short-term solution.
Yes.
Because the long-term solution was extending the runway.
Right, which we were in the process of doing.
That's right, and that was, I think, at one stage thought to be a sort of 3-5 year.
Yes,
a relatively short-term.
Right, so they actually getting to the point where you start construction, we anticipated it would take at a minimum of 18 months.
No, quite. But that meant that BVI Airways was a short-term solution.
Yes.
And so had probably short-term commercial value for the operator. Because once large planes can come in, Miami fades out of the picture.
Yes, and they attempted to. Yes, so yes, that's correct.
Yes, thank you.
Picking up on the context that you've given, Mr. Smith, the next question that arises, though, is that this still involves a substantial sum of public money.
Agree.
And in this case, what appears to have happened is that the government responded to essentially a sort of unsolicited approach at the beginning from Mr. Hyman. But what the government, once it embarked on this course from 2013 onwards, yes, there was a stop perhaps when the proposal was rejected after the BDO report, etc. But then it carried on again with the same parties on the other side. At no point did anyone on the government side consider alternatives. At no point was there consideration given to a tender process. At no point was there consideration given to approaching anybody else who could provide the same service. You were, whilst the terms may have changed, right from the beginning, you were locked into a relationship with these four individuals, weren't you?
I don't agree with that, unfortunately. I take your point. I think that's valid. But I didn't consider ourselves, the government of Virginia, to be locked into anything with these individuals until we signed the framework agreement. So that's one. Two, it also is not accurate that we didn't consider all the alternatives. The other alternative, for example, was the run extension. The other alternative was to try to get better arrangements with individuals coming through or competitors, which would have been US Virgin Islands, St. Martin, and Antigua and Barbuda, and to some degree, a very small extent, St. Kitts and Nevis. We had also been solicited by a local airline, one that was established before, to give them a loan of, I think, some $10 million to do that. So I don't know, it's not accurate from my point of view to say that we didn't consider other alternatives. I think I do take a point though that we were in heavy negotiations with this particular.
You're focused on these.
I mean, if you look at the framework agreement, can I just deal with two points about it? I mean, it's signed in
what page is
on the 7th. Go to page 828. That's where it's set out. It begins to be set out. But the framework agreement is 7th of December 2015. If you keep your thumb at 828, but go please to 839.
Okay.
$839 is under the heading financial assessment. The Auditor General's report refers to the BDO report. So that's a report that exists before you enter into the framework agreement.
Yes.
And the BDO report is talking about a memorandum of understanding that was set out in 2014. Mm-hmm. And it says that a 20% interest rate contemplated under the MOU is far too aggressive given the lack of risk being borne by Castleton. Mm-hmm. Castleton being a company owned by Bruce Bradley.
Yes.
So that's the position in January 2015.
Yes.
The warning that you've got from BDO is 20% is too much. If you go back to 829, please.
829. Okay.
And you go to the bottom where you've got financing provisions. Mm-hmm. What's written there at the very bottom is the government to be repaid from operating profits after the company's reserves are established, operating deficit reduced, and the operating parties are paid 20% return on investment. So it seems to be that what was carried over from the MOU, even after BDO, was this figure of 20%, and that gets embedded into the framework agreement. Have I understood that right?
It is what it is. I mean, it explains what we agreed to here. That's what you mean? Yeah. Okay, so
one of the point is that one of the things that BDO cautioned specifically against, which was avoid 20%, mm-hmm. still ends up in the framework agreement.
Not really, in a way.
Percentage 20%,
Right, so
and it's written
yes,
there.
agreed. So, agreed. The way that this was interpreted by us is that unless there was a 20% return on the arrangement by the operating parties, then government would not receive any paybacks. That was our full interpretation of what was here. So in other words, unless guaranteeing the 20, let me start before, $7 million was the ceiling. Okay, we paid no more than $7 million. That was the ceiling. If in this enterprise occurring, okay, I can't tell it a better way. We did not receive, the operating parties did not receive 20%. Then government would not receive any paybacks. If they receive over 20%, then the government of the Virgin Islands would receive paybacks. That's the way that we interpret it.
Yeah,
right?
I mean, it's a bit more than that, isn't it? You put in 7 million, you will get your 7 million back after 3 things have happened. Firstly, that the company's reserves are established,
Right.
and that's not defined.
Fair enough, yes.
Secondly, that their operating deficit has been reduced, and that's not defined. But thirdly, that they are paid 20% return on investment.
Okay, so
before the government is 4th in line, you don't get your 7 million back until those 3 things have happened. So until things have happened that benefit the operating parties, you don't start to get your 7 million back. That seems to be what that aspect of the framework agreement is saying. So once again, government is bearing the risk, whilst the operating parties are enjoying the profit.
Yeah, and like I said, I don't know if I disagree with you. But the reason why I explained the context in which decisions was made was so that you could understand that there were risks that we are managing.
And you were prepared to take.
And we are prepared to take this, right? The risk that we set, the limit of the risk that we set financially, directly financially was $7 million. We recognize in my discussions with the Attorney General at the time, is that if you're not careful, you might have some legal risks, right? You might be exposed to some legal things that may cost you some additional funds as well. But in terms of the direct risk that we had here, yes, we understand that there was $7 million there. And we realize that we are, as you say, 4th in line. But the salient point was that the government of the Virgin Islands, in consideration of the other serious issues that they had, quote unquote, continued solvency of the government of the Virgin Islands in face of the commitments that they had, that was a risk present. We knew it was present, but that was felt that was acceptable in consideration of the other things, not by any figment of imagination. And in conversations with the Minister of Finance, did I get the impression that we felt there was a little bit of money. But he also expressed to me at the time, and I agreed, that in light of the other things that needed to be done, right? That we had to, it was something that we were, if it was a risk unbalanced in consideration of the other issues they were willing to take.
Now, under the framework agreement, there was, I think it's called an official liaison from the BVI government.
Right, yes.
And you became the official liaison, didn't you?
Yes, sir.
If you go, please, to 97, it's at page 837.
837?
Yes, please. It's something I want, in fairness, to give you an opportunity to respond to.
Sure.
In the auditor's report, the auditor points to you're taking on the role as the government's contact, and that gave the operator parties ongoing high-level access and support from within the government. But what the report says is created foreseeable issues. And the issue boils down to this, Mr. Smith, that essentially it puts you in a position of a conflict of interest. Because on one side, as the government's contact, you had an interest in ensuring the success of the venture because 7 million had been put in. But that then jarred with your public duty as financial secretary to be the primary custodian of the government's finances. Would you accept that the position that you were placed in, official contact, but financial security, did give rise to a conflict of interest?
I agree with that. But I can also say that that is a conflict that financial secretaries and treasury secretaries around the world deal with all the time. Certainly is a conflict that my colleagues in the Caribbean deal with continuously. So it is something that as a financial secretary, you are aware of. And as a financial secretary, you have to be very careful to manage. So in other words, you have to be prepared to hold yourself accountable for your own actions, if that makes sense. So I agree with you. It is a difficult position to be in, but it's a position that financial secretaries in the execution of their duties have on almost a daily basis. So this wasn't anything new, and I knew that it existed. And because I knew it existed, I had to make sure that I manage it properly, because that is the duty that is expected of me was expected of me as a financial secretary, to act in the best interest of the government of the Virgin Islands and the stakeholders. And in taking on that job, it is a responsibility that I accepted. And it's a responsibility that I was duty bound to manage, not just in this instance, but like on regularly. I had to do it all the time. This was no different.
As but either financial secretary or the government's official liaison for the project, were you able to inspect BVI Airways financial records?
No.
And what was the reason that you didn't inspect their financial records?
They claimed that they were not able to send, or did not feel comfortable in sending financial records to the government of the Virgin Islands because they were concerned about the confidentiality within it. They had, unfortunately, we had around about the time was, and it was especially bad after our conversations with them, and we entered into an agreement with them, a signed agreement with them, that there was some unfortunate leaks in the government of the Virgin Islands, and they claimed that because of that, they were uncomfortable in sending what they considered to be financially sensitive records to the government of the Virgin Islands, because they feared that those financial records would end up in the public domain. And if I recall correctly, there are provisions in the framework agreement that insist that those records would remain confidential. In my position, I'm going to put this gently. I did not feel that that was a good enough reason not to send them. But they did offer for us to, when my angst, I guess, was unbearable for them, they did offer to allow us to view those records in their offices in Fort Lauderdale.
You should have a on the table. It's loose leaf, probably under the notebook that you brought with you. There should be a copy of the arbitration award.
Yes.
Do you have it?
Yes.
If you go to page 84, please, of that. if you pick it up at 83 of the award,
83.
32.10.
32.10.
Yeah, so this is Mr. Wiseman testifying and saying he frequently invited Mr. Neil Smith to look at anything he anytime he wanted. And if you go over, I'm going to just summarize, but what Mr. Wiseman said was most of the major books and records were in Fort Lauderdale. We did maintain some books and records in Tortola. And you were offered the opportunity to look anytime you wanted. And then at 32:11, there's your evidence is referred to. And it comes down to, you confirmed that Mr. Wiseman had invited you for an open book experience. You described how puzzled you were that the BVI government would not permit you to accept that invitation. And what the award then, or the transcript, the decision then says is it then sets out the transcript, and it says it reflects how dismayed Mr. Neil Smith is still at that government decision. And so does it come to this? I won't read it out, but that there was an open invitation to you to come and inspect the books.
Yes.
And a decision was made that you should not go and inspect the books. You might need to speak up, Mr. Smith.
Yes, that's correct.
And you were asked, was it your decision or their decision? And you say that wasn't my decision, it was cabinet minister's decision. So the cabinet decided that you should not go to the US to inspect the books of BVI Airways, is that right?
Okay, not cabinet, and I think that that probably came off wrong. When I was specific when I said cabinet ministers, and I didn't say cabinet.
Okay, so which cabinet ministers?
It wasn't cabinet.
Right.
It was, so in the government of the Virgin Islands, we can't travel unless we get permission. Even the financial secretary cannot travel on government business without permission. And that I had raised that with the minister and the premier, with both of them actually. And I think—
Sorry to interrupt, which minister did you raise it with?
I said the Minister of Finance and the Premier. I was making a joke a little, right? Because it's the same person. So when I discussed it with him, the impression I got is that, look, the framework agreement said that we'll send information here, and we're not prepared to give them that concession by going to Miami, right? That, I think that was just was tactics. So that is the reason why I didn't go. And incidentally, I was prepared to actually send someone besides myself, so there would be another pair of eyes supervising this matter.
But in the event, nobody looked at them.
Nobody looked at them.
Thank you.
And also, you didn't receive any statements. They were supposed to provide quarterly statements under the framework agreement, and they didn't do that, did they?
Yeah, so that is the reason why there was some, I describe it as angst between myself and Mr. Wiseman, who I chatted with. He was quite, admittedly, he was quite open to answering questions when I asked, but that was not good enough. You need paper records, right? But I did get some financials which were, they weren't good enough.
They were, according to the Auditor General, they were unaudited and unsupported, and it was one set of financial statements.
It wasn't a lot of, it wasn't.
If you could go, sorry to interrupt you, it's something you wanted to say.
It wasn't acceptable.
Right. If you go, please, to 831 in the main bundle that we've been looking at. And I'm going to summarize this, but tell me if I've misunderstood it. But under the framework agreement, the government of the BVI was going to pay 7 million in fixed installments.
Yes.
And if we look at 47 on that page, the has set out the scheduled payment dates for that 7 million. But what happened was that under the framework agreement, the government was required to get a letter of credit. That wasn't possible. And so to deal with that issue, a number of steps were taken. The first was that sums of money were paid early.
Yes.
And again, you can see that the Auditor General has set out on that page when the actual payments were made.
Yes, sir.
The second thing that was done was that an escrow account was set up so
Yes.
that the remaining 2 million, you'd paid 5 million, but the remaining 2 million was going to be put in that escrow account for the benefit of BVI Airways. And the third thing that happened was that the government essentially went above the 7 million and paid an extra $200,000 to BVI Airways. That's what it comes down to, doesn't it?
Yes, yes, yes.
Now, what then happened to the escrow funds was that, and this is on the next page if you want to look at it, was that you as Financial Secretary terminated the escrow arrangement, authorized release of the funds to the operator parties on the 11th of January 2017. And this occurred before the stipulated payment dates, even under the escrow arrangement.
That's
And
correct.
it occurred before the airline had received any authorization to fly from the US or UK authorities.
I think it was before authorization from the US authorities, but not from the British guys.
And what
All correct.
what the Auditor General notes is that no authorization from Cabinet was obtained for this early release.
That's correct.
That's correct.
Yes.
Did you obtain authorization from anyone?
Yes. The Minister of Finance has a constitutional and legal, has the constitutional legal authority to make advance payments. If I recall, in section 31A of the Public Finance Management Act, it speaks to the Minister of Finance being able to make advances. And one of the conditions on which he could make an advance payments, is in relation to an existing agreement, right? Throughout this entire saga, the Minister of Finance obviously would advise him on what he can do and what he can't do under the Act. Made or authorized. After we consulted, after approval was given, he gave instructions. He authorized these payments in advance of the schedule using that provision, with the understanding, as the Act requires, that in the opportune time, he would go back to, well, via the Cabinet, obviously, but to the House to ratify payments that were made under that part of the Act, right? Under that constitutional responsibility, so to speak, that he had. So, yes, he did authorize these payments. Yes, I did consult with him, which we should say was wide and sometimes very difficult conversations were had as to the merits of paying early or not paying early. But that is the authority that he used to actually authorize these payments. The fact that we weren't able to get a letter of credit, we did not realize we would not get a letter of credit in the beginning. But after the agreement was signed, and it has to be public, obviously, we had some noises, right? It's not my business to worry about the noises. But the banks had indicated to me that the compliance departments were having some issues with that, in addition to the general de-risking concerns that was prevalent in the region at the time. So essentially, what a lot of the banks were doing were pulling out of sovereign debt and, you know, that type of stuff due to the de-risking concerns in the financial sector at the time. They also indicated to me, because one of the banks did indicate to me that despite that, because of the long relationship that we had, the de-risking concerns that I had, because of the long relationship that we had, and our track record of actually meeting obligations, they were being prepared to do that, to give us a letter of credit. But after the concerns that were brought up by the compliance department, they felt that it would be a lot more difficult. We did continue, but the terms that they were giving me, I shouldn't say me, giving us, were definitely not, in my opinion, wouldn't serve us in the best interest. For example, if you recall, what they're requesting for us is that we deposit the entire $7 million into an account and then proceed from there, which negates the idea of a letter of credit, really. The letter of credit, the funds are transferred to the third party. The third party guarantees that these payments will be made, essentially. So when that happened, that essentially, to my mind, was an escrow account, which had some heavy charge. Well, I think eventually we decided we'd part ways because of the costs that they had concern in getting it. They would do it, but it'd be extremely expensive. So we were in a position where we are, I guess, in material breach of the agreement that we had. So I encouraged the operating parties as well to see if they could find something that I would find acceptable, or the BVI government would find acceptable. They couldn't get a letter of credit either. They eventually came to an escrow account, but that happened several months after. So in order to remedy the breach, what we did is we decided that we'll actually make the payments not according to the schedule, but in a manner that would allow the operating parties to have the cash flows that they'd anticipated had the letter of credit been done, because the letter of credit would have been a financial instrument on which they could have borrowed against or get commitments from people against. So because we were able to get a letter of credit, we actually had to come up with the cash, right? And essentially, if we had just put the $7 million in a bank, it would have been, in the Ministry of Finance, we would not have been able to utilize $7 million. In other words, we'd have front-loaded $7 million from the beginning, and I would not have been able to use funds for something else in the meanwhile before the other commitment came up. So that is the reason why that happened. The escrow the escrow account was terminated, I think, in early, would have been in January 2017. And
11th of January 2017.
Right, and that again was a very painful discussion with the Minister of Finance, and I think what we recognize that based on our assessment of where the airline was at the time, the operating parties were at the time with the progress of the venture, we knew that they had planes that were being serviced, and one at the time I think might have been in some C-check. We had the ASSI. We had the progress that we're making with ASSI, which was the BVI regulator. And we knew that the next step that it needed, which was just a matter of getting certifications, that we were convinced at that time that they were making progress, right? Adequate progress, based on the cash flow statements that I've seen from 6L before. The progress that they were making seemed to be adequate, and so after some very difficult discussions, the Minister of Finance decided that it would be in the best interest of getting the approvals to terminate the escrow account.
And so he gave you authority to take these steps.
Yes.
And decided that there was no need to take it to cabinet.
I don't know if I would say that he didn't decide there was no need to take it to cabinet. I think what he was doing, number one, well, he was using the authority that he had as Minister of Finance to make the advance payments. And number two, based on my conversations with him, I knew that his cabinet colleagues were aware. And number three, of what was happening. And number three, I would have expected, based on the 10 other conversations that we had, as I recall, that those things would have been ratified eventually. But he did have the authority to do it. And I didn't get the impression that he made these decisions on his own.
But the upshot is that all the 7 million plus 200,000 is paid by July 2016 on the Auditor General's report to I'm sorry, with the exception of 2 payments. No, they're all yes. So all of the sums, bar what went into the escrow account, are paid across. And the escrow accounts are then paid in on the 15th of July and then signed over to the parties on the 11th of January. Now that is all before you have on the 27th, before you've received any financial statements at all. So the 7 million all goes across to BVI Airways without you having received any documents that you as Financial Secretary would consider necessary to assess their financial health.
Okay, so respond now?
Yes, please.
Okay. I don't agree with the statement that the $7 million was in BVI Airways' hands by July 20, in 2016. Only 5 million was. The $2 million was in escrow. Neither of us had custody of it.
That's a fair point.
I also agree that we had transferred over the amount to the tune of $5 million by about July, right?
Yeah, by July 2016,
right.
you transferred 5 million.
Exactly, without having seen any financial statements. That's absolutely correct. And I think we get to the point, we go back to the point about my angst about not seeing these financial statements and the representations by BVI Airways, so why they're not doing it, and the offer for us to see them. However, again, we get back to the issue of risk. And we were convinced that even though we weren't seeing these financial records, based on the progress, and we're very intimately aware of what was occurring with the regulator, the work that they were doing. We knew and could verify what they were doing to the aircraft. We were reasonably assured by those means that based on the financial projections for cash flow that was done before, that they were in fact doing what they were supposed to do, albeit a little bit late. They were actually meeting our expectations of what they should have been producing. So yes, I agree, we didn't have the financial statements. We were concerned, there were representations made, but we are convinced that based on what we are seeing happening at the time, that they were doing what they're supposed to do.
But by January 2017, all $7.2 million had been paid.
Yes,
The government were determined not to pay any more.
yes,
By February 2017, the operators started to ask for more money.
yes.
I mean, not a bit. 10 million they asked for in February 2017. You had, by that stage, as I understand it, received no accounts. The accounts you received were up to March 2017. Those were incomplete. But unless there was money from somewhere, this was not going to go anywhere, and it collapsed by June.
Respond, right? Okay, so I'll address each of those individually. The terms that the terms that operating parties presented to us were unacceptable, plain and simple, for additional funds.
I'm sorry, but the fact of the matter is that you were not going to put any more funds into this.
Yes.
You didn't know what the state of BVI Airways was in financial terms, and they made it pretty clear that they wanted money from you.
Yeah.
Which suggests they hadn't got any. So it just ran into the sand, didn't it?
But we know that they had the money, right? Because we'd done our work before. And we knew that at least Calston was good for it. We knew that.
But there was no obligation for them to pay any money in.
But but then that's another issue, right? But it's not that they were unable to pay. That wasn't the issue. So we knew that they were able to pay. Whether or not they were honorable enough, I guess, when you're talking about business, I don't know if that has anything to do with it. But we knew that they were able. We knew that financially they could put funds into it, the funds are required to make it fly. We knew that. There was no doubt in our minds at all, based on the work that we'd done before. So we knew it was just that they decided that they'd play hardball and wouldn't put any more funds into it. But the government by that time had more than fulfilled its obligations. It had also demonstrated to the operating parties that it was serious about this venture accord.
But the operating parties had complied with their obligations too.
Well,
they had no obligations to put any money in.
Well, I don't know if I necessarily disagree with that point. If you understand, I don't know if I disagree with that. But to say that, but you didn't make that point. We knew that we knew that we were good for it. And if they really wanted to, and they were convinced about the investment, the goodness of the investment, so to speak, that they themselves had the funds to do it. So I don't know if we disagree. Personally.
Yes, thank you. Yes.
Commissioner, can I just move on to a different topic?
Yes, thank you.
You can put the award to one side and the bundle to one side, Mr. Smith, but you should find separately again as a loose leaf document, and it'll be just under the award, I hope, another document which is the public accounts.
This one.
Yes. Now, this is the Public Accounts Committee's final report on the cruise ship port development project.
Yes, sir.
If you go, please, to page 9.
Page 9.
Yeah.
That's
Now, the report is dated the 13th of June, 2014.
okay, so I think there's more than one page 9 in it. No. Yeah, there's more than one page 9. So conclusions.
Do you have paragraph 40, which is headed tendering by the Ministry of Finance? That's it. Okay.
That's the first page 9.
Right. Now, the first question is, were you in post as Financial Secretary in August 2012? After August 2012?
Yes, I think
right.
so. Yes.
Okay. Well, that then means I can ask you these questions.
I think I was, yes.
Just to give you some context, the Commissioner has heard evidence from the Auditor General about this, and there was then a Public Accounts Committee report on the same issue. And to try and summarize it, the process had been that although the development of Wickham's Quay was a matter for the Ports Authority. It had been taken forward by the Ministry of Communication and Works, who had got it to a point as a development where there was a agreement with the Tortola Ports partners and a proposal that had been accepted by the Ministry of Communication and Works. But if we then go to page 9, what then happened was that if you look at 40, that project, as run by the Ministry of Communication and Works, was brought to a halt in August 2012, and there was a non-binding agreement with the Tortola Port Partners, TPP, which was terminated. And the Ministry of Finance then stepped in, and the Ministry of Finance initiated a tendering process. Hopefully fairly, I will try and summarize what then happened, because in terms of the tendering process, there was a sort of request for expressions of interest. And what the Public Accounts Committee found, and at least 2 of the points they found are echoed by the Auditor General, was firstly that the length of time provided to tenderers to respond to what was a complex matter, a multi-million-pound development, that the time provided for that was too short, because initially it was a 2-week period. It was extended for a total of 6 weeks, but in the committee's view, the time frame still fell short of that required for a project of this magnitude. So that was the first criticism, length of time. The second criticism, which is also a criticism made by the Auditor General, was that the project requirements that were put out to tender, and what it says is, can you see it be subsequently amended by the Financial Secretary, closely resembled the project details that were previously submitted by TPP and accepted by the government. Striking similarities were noted in the required design, the exit provisions and training requirements. The committee found this to be suspect, as it would put other potential tenderers who entered the process at an immediate and severe disadvantage. So in effect, the argument is that there was a sort of acceptance of what TPP had put in before, which therefore gave TPP an advantage. The last criticism that is made, and it's not one that features in the Auditor General's report, is that the team assessing the tenders included a former consultant. That was a consultant who'd been engaged by the Ministry of Communication and Works, but had now become the managing director of the BVI Ports Authority, and that's Claude Skelton-Klein. He was on the team assessing the tenders, but he had already established a relationship with TPP and its principals. And the point that the Public Accounts Committee made was that there was a prima facie conflict of interest for Mr. Skelton-Klein. And I draw your attention to paragraph 41, Mr. Smith, where they cite evidence given to them by the former acting permanent secretary. I think that's in the Ministry of Communication and Works, expressing concern that Mr. Skelton-Klein, being on the tender board, because he was dealing with some of the same entities that he'd been negotiating with earlier. If I take you to the conclusion, which is on page 11, what the committee concluded was that the procurement process engaged by the Ministry of Finance for the development of the cruise pier project was flawed, as it created an unfair bias towards TPP's submittal and rendered other prospective tenderers at an immediate and severe disadvantage. And secondly, excluded the Port Authority Board, which was largely kept out of the process, notwithstanding the presence of its managing director on the Tender Assessment Committee. I should, on that last point, perhaps assist you with this. The criticism that is made is that the board has the statutory responsibility for that pier, and ministries shouldn't be stepping in. But so there are 2 criticisms that are directed at the Ministry of Finance and therefore directed at you as the Financial Secretary. One was that the tender process was flawed, and 2 was that you were usurping the role of the Ports Authority. I hope I've summarized that fairly, but those were findings made in 2014. Did you accept those findings at that time?
The way I would answer this, and I guess you could assess whether I accepted the findings or not. when I answered, is that the Ministry of Finance did have concerns in the way that the process began. It did. And that is the reason why it ended up in the Ministry of Finance's hands, because because it was my responsibility to make sure that these processes occurred in a fair manner. When my concerns were expressed, and I recall the governor might have been involved at the time, we took it over with a view to making the process fair. There was another constraint which I had to fight against, or we had to fight against, which was that there was a timeline on the back end, meaning that the cruise lines themselves were asking for things to be done by a specific date, or else there would be repercussions for the industry in the BVI. They wouldn't come, for example, right? And so when we made the initial when we did the expressions for interest, the idea was to create a situation where the rigor that would be required to submit a tender wouldn't be immediately required, because just an expression for interest, this is what we want completed. Can you do it or can you not do it? Do you have the requisite document to actually complete this, right? That was the idea for the expression of interest, because from there, then you could go into a second phase where you could have a more rigorous process. So it was expected that people, it would level a playing field, so to speak, right? Because there will be less to prove. You just need to say you have basically you had experience in this before, you have the type of people that you need to do it, something around that line, right? I agree with the fact that the time frame was too short. That was it was extended. And I might have been one of the individuals that were representing that we should make it longer, because the final decision on what the time frame was, if I recall, wasn't mine.
Who was it? Who made the final?
It would have been a discussion between the minister for the subject and the Minister of Finance, and also Mr. Klein at the Klaus Skelton Klein at the time, right? We would have been, he would be saying, well, this is what the industry is looking for, if I remember the role that he was playing, and the minister was saying, and then Ministry of Finance, and I say, Minister, that's a little short, and then we say, okay. But then it became immediately apparent that that was too short. So that was extended, I think, either once or twice. I don't recall how much times. I also agree with your point that the terms not only reflected the conditions that TPP had put out, they were taken from them. So there's no, I'm not trying to, as it were, avoid that. That is true, right? That is true, and I think that I agree with you that it could appear to constitute, and materially, I think it, on balance, I think it actually did provide an unfair advantage to TPP. But in addition, which I'm not sure the Public Accounts Committee report address, eventually we scrapped that entire process, and it's because of those concerns. So in my view, the system worked, but I don't know that I disagree what you're saying, right? But what I am happy about is that the system worked in the end, and in the end, we did not finish that process. We stopped the process and we did it correctly. If I recall, the BVI Port Authority actually moved the process forward eventually. I could be wrong on that, but that's my recollection. The issue about the ministry taking the project from the BVI Port Authority, I think, again, that's, yeah, I mean, but I don't know if it would be preferable, obviously, for the BVI Port Authority to handle a process. But as the ministry responsible for the BVI Port Authority, I'm not so sure that is wrong. I wouldn't recommend it, but I'm not so sure that was untowards. You know, I would not have recommended that approach, but I don't know if the ministry as being ultimately responsible was overstepping. That would be something I have to look at.
What about the point C on page 10 that the Public Accounts Committee drew attention to, the conflict of interest?
This is C on,
yes,
on 10?
Yes,
Okay.
so you've dealt with the short time length, you've dealt with the TPP details being used, and that creates an advantage. But an element of the advantage was the fact that Claude Skelton-Klein had a conflict of interest. Was that something that was a factor at the time that anybody was aware of?
It was something that I know we are all concerned. I was concerned with it as financial secretary, but I think by the time the discussions had finished, some reliance was placed on me to ensure that this individual did not unduly influence anything.
How did
but
you?
I do agree.
How did you discharge that duty? If there was reliance on you to make sure that there wasn't undue influence, how did you manage that?
Right. So he was on the tender committee, and I would seek to control his opinion, so to speak. Make sure that, in my view, I did not unduly influence the other members. That was what I would do. But I don't disagree, and I agree with you that was an uncomfortable position and something that we should have avoided.
But at that time, was there any mechanism in operation by which someone who had a conflict or someone who others thought had a conflict could be removed from a committee or asked to step down from a board?
Definitely.
And did that happen in this situation?
I don't think it did. And my understanding was that, and this is why I think it probably slipped through, is that this individual had worked with TPP to come up with a proposal, but wasn't a part of TPP. In other words, he was an agent of government to negotiate an initial agreement with TPP that was in the best interest of TPP. And I think that is the thing that is unbalanced. So in other words, he wasn't an agent for TPP, he was an agent for the government of the Bush. So he was involved in the process and in the negotiations with TPP from the beginning. So yes, he had intimate knowledge, but he was not in all of that. He was actually working for the government of the Bush as opposed to working for TPP. So his intimate knowledge of this particular subject would have been an opportunity for us to have intimate knowledge of what TPP was proposing, right? So I think, if I recall, that was what allowed us to go through it, with him actually being on the tender. In other words, he was like an expert. He's not, as if a government sends me to negotiate with a particular party on a topic, you would believe that, or you would expect that I would end up with more information and more intimate knowledge on that enterprise than other members in government. So it is on that premise, I think, why he was there, but it would have been, in my view, better. It would have been, at least in terms of how it looked, if he wasn't there.
Thank you. Commissioner, I've finished with my questions. Can I conclude by thanking Mr. Smith for his patience today, but also for coming to give evidence, and also finally for the way that he has given his evidence. Thank you.
Can I echo that, Mrs. Smith? Thank you very much for your time, your patience, and the clear way in which you've given your evidence. Very
Thank
much
you, sir.
appreciated. Thank you.
There is one final matter. If Mr. Smith's free to go.
No, you are.
Okay, all right,
And-
thank you.
Thank you. And just one final matter, if I can deal with that quickly, and that's the question of responding to the Solicitor General's earlier submissions.
Yes.
In terms of the publication of the draft Auditor General's report in relation to COVID-19 stimulus grants. The Solicitor General makes 2 points. The first is a concern over personal data. And the second is that the fact that these reports have yet to be laid before the House.
Yes.
In relation to the first, I would say that that as a concern is easily resolved by any personal data being redacted. We were careful during the course of the hearing not to refer to any, and so in terms of any members of the public who want to look at that documents, they will still get a sense of and an understanding of the Auditor General's conclusions and findings.
Yes.
And so that, in my submission, is not an argument against publication. The second is that is the argument that they have yet to be laid before the House. In effect, Commissioner, you are being asked to balance two competing interests. The first is that a procedural step has yet to be taken. You will recall the evidence that was given by the Auditor General in response to questions from yourself, which was to the effect that once she submits her report to the Governor, it is final. If any changes need to be made, they would need to be made by way of addendum. But these are the final reports. It's just a procedural matter that they now need to go before the House. On the other side of that, in my submission, are the following points. Firstly, that these reports were included in the hearing bundles, which were sent to all participants in advance of the hearing. And so all participants had an opportunity to consider the hearing bundle and to raise any concerns that they may have had about the content of that bundle. But it would have been obvious from the fact that the Commission included it in the bundle that there was an intention to use this at a public hearing. The second is that the reports have indeed been used at a public hearing. They have been referred to extensively, albeit carefully, in order not to refer to personal data. But the public reading the transcripts will be well aware now of the content of the reports. But third is that it is important that the public understand the work of the inquiry. There is, I'm not arguing for that the inquiry should be publishing every single document that it receives, but there is an argument that it should publish documents that assist the public, and we are here acting in the public interest, having regard to the terms of reference, but to assist the public in understanding the evidence that is being called at these hearings. And publishing these documents will do that. And in my submission, when one takes those factors together, they outweigh the procedural, or the argument that a particular procedural step has yet to be taken. I would also mention in relation to that procedural step that you will have in mind, Commissioner, that once it is before the House of Assembly, it will be debated at a public hearing, and it will then become a public document. And so the step that you are taking, if you agree with my submissions, is one that would occur in any event. Other than that, I have nothing further to say.
Yes, thank you very much. Anything in response, Solicitor
Yes,
General?
yes, Commissioner, thank you for the opportunity.
Yes.
First of all, my Lord, first of all, Commissioner, I think that what you should be drawn to is Section 20 of the Audit Act. It is not a procedural step, but it is a statutory requirement that this procedure is done. So it is not right, Commissioner, for you to be encouraged to brush over Section 20 of the Audit Act. Section 20 of the Audit Act sets out a procedure that makes these documents parliamentary privilege document, and it becomes, Commissioner, it becomes, to say it lightly, Commissioner, a discourtesy to simply not only breach the act, but to interfere with the procedure, the parliamentary procedure laid out by Section 20. Commissioner, I can only, in my best advice, guide this Commissioner of Inquiry not to breach Section 20 of the Audit Act by continuing to disclose the documents that should be given that privilege, that parliamentary privilege, by putting the documents that are before this commission in this inquiry on the website of the Commission of Inquiry. Because I say that this would not only be a discourtesy to the parliamentary privilege that was intended by the legislators of this country, but it would be a breach of Section 20. By Section 20, Commissioner, these are special reports of the auditor. They must be submitted to the governor, and then they must be submitted to the minister, and then they must be submitted to the financial secretary. It is my humble submission, my Lord, Commissioner, that in the drafters and the framers of the act took in mind that there was a procedure, there was some value in giving those steps. And if we publish these documents summarily on the website, we will be running over these steps. Maybe, and I think it was the evidence of the Auditor General, that having gone through these steps, she may wish to issue an addendum. Having gone through these steps, the privacy of persons may be considered, the security of persons listed may be considered, but the point is that the governor has up to 3 months, and he doesn't have to use the 3 months, but he has 3 months to continue these steps. I humbly guide and submit that the Commission of Inquiry should not summarily put the documents up and allow this procedure to continue. Not only because it's a parliamentary privilege, but also that the commissioner would not want to be in breach of the very section of the Audit Act that the Auditor General spoke of today so eloquently.
Section 20.
Section 20, Commissioner.
And why will it be in breach of Section 20?
Section 22 envisions that the governor shall, within 3 months of the receipt of the special reports that are being considered, cause them to be laid before the House of Assembly. But and in between there, Commissioner, the Minister of Finance and the Financial Secretary also have a duty to receive these reports. So it is tradition that once these documents are by statute to be laid before the House, they should not be made public before that procedure is continued. And I want to mention what the Auditor General said this afternoon when she spoke about the press conference that was called upon the report on the wall. She eloquently, in her own words, said that that is not something that should have been allowed. And I think that if we do the very same thing that the Auditor General recommends us not to do, we would not be in sync with what she's saying, that the purpose of the rules are. The rules are that this is what should happen. And when that press conference was given, she clearly said she did not respond until the document was publicly laid.
But the minister wasn't acting in the public interest.
No, the point is, Commissioner, she did not respond until that document was publicly laid.
But in those circumstances, the minister, when he
breached the rules, or so to speak.
When the minister published the report, he was not acting in the public interest.
Indeed, Commissioner.
I'm bound to act in the public interest. And in the current circumstances, nobody has objected to these two reports being referred to at great length in the course of an open hearing.
Yes, Commissioner, but you put the question to me.
Which has been live streamed.
Yes, Commissioner, and I think that
it would have been open to Mr. Rawat to have read out the whole of the two reports. He read out substantial parts. It would have been open to him to have read out that, and nobody objected to that.
Yes, but we are objecting now.
And they had every opportunity.
Yes, like I have an opportunity now where I'm gracious and I'm grateful for the opportunity you have given me. You have asked my opinion and I have given it.
But isn't the horse bolted long since?
Well, Commissioner, if the horse have already left the gate, I believe this is an opportune time to check. I believe that in the interest of the commission and having these proceedings continue, the commission was correct in terms of not giving out private information during these hearings. The commission was correct in terms of getting on with its work. But when it comes to actually treating a document of parliamentary privilege that was so made by the Act, I believe there is a line, and I believe the line is now. And I believe that we ought to, in respect of Section 20 of the Audit Act, and in respect of all the submissions made by the Auditor General today with regard to a culture of respecting the law and respecting rules, I believe in all the things that she so eloquently said about the report and rules, that we ought to stop at this point and allow the parliamentary procedure to work as it was envisioned by the framers of Section 20 of the Audit Act.
Just one final point, Solicitor General. In terms of the stimulus grants report, I'm not sure that there are any personal data in it. There are obviously personal data in the Farmers and Fisherfolk report. There are names of individuals, for example, but no names of individuals in the religious institutions and community groups report. Just the name of applicants and non-applicants, which are, as the title of the report suggests, religious institutions, civic groups, private schools, and daycares.
Yes, there are, and even Commissioner, for the interest of the reputation of those institutions, I believe preempting of the House's publication is significant, particularly to the liability of the government, who would wish to ensure that if information about public persons, public institutions, especially some as social as our schools and our churches, it would be my best advice that the proper procedure is gone through to protect the liability of the government, such that if those and when those names and institutions are given to the public, it's in complete corners of the law. As it stands right now, I don't believe publishing them would be in the four corners of the Act. I believe there are some places which I cannot identify at the moment, but there are some places where names are called, like on page 2817, I believe, where in the report, names may be mentioned. And if not only names are mentioned, because of the size of a territory, you could redact the name, but the information surrounding the name would allow persons to know exactly who or which institution you're speaking about. So if redactions are going to be done, and I do not say that is the only cure, I would suggest that if they're carefully done and not just a summarily redaction by names alone, giving the territory and its size. So some proper care should be done to do that. But I do see that it is not the only concern we have. I think redacting the names and institutions in a situation where the proper procedure hasn't gone through to make the names and the report public would not be correct. And I so humbly advise.
Thank you, Solicitor General. A number of reports of the Auditor General have been considered in open hearings yesterday and today. Prior to those hearings, all of the reports which were intended to be referred to were sent to all of the participants, including the elected ministers represented by the Attorney General and the other members of the House of Assembly, including the Honourable Speaker, represented by Silk Legal. Those reports included 2 reports on COVID-19 stimulus grants to farmers and fisherfolk on the one hand, and religious institutions, civic groups, private schools and daycares on the other. The usual procedure in respect of Auditor General's reports is that once she has produced a draft report, there is an opportunity for relevant ministers to have input. And once she has produced the final report, then that report is presented either to the relevant minister under section 12 of the Audit Act 2003, or to the governor under section 20 of that same act. Under section 20, and both of the COVID-19 reports were under that section, the governor shall, within 3 months of the receipt of the report, cause the report to be laid before the House of Assembly. That has not yet been done in respect of either of those reports. The House of Assembly discuss and debate any report that is so laid. The evidence of the Auditor General today is that the final report cannot be altered, but it is possible for her to insert an addendum if appropriate, although that in her recollection has never been done in the 25 or 30 years in which she has been involved with Auditor General's work. No one suggested when these reports were sent round to the participants, and no one has suggested since, that any of the reports, including the COVID reports, should be considered in evidence in private. Consequently, they have been considered in public hearings, and both of those reports have been referred to very extensively. As I indicated at the outset of these hearings, I wish all of the Auditor General's reports to be all of her reports that have been considered in an open hearing to be put on the COI website to enable the BVI public better to follow the COI's work and in pursuance of the openness with which the COI is pursuing its work. The Solicitor General, on behalf of the elected ministers, objects to the COVID reports being put on the COI website for 2 reasons. Firstly, she submits with some force that the 2 reports contain personal data. In particular, the farmers and fisherfolk report includes all of the names of the applicants. There is clearly force in that, and those personal data must be redacted from the report before any publication. Furthermore, in relation to the other COVID report concerning religious institutions, etc., although I'm not convinced that the names of the institutions are personal data, I do not see that it is necessary for those to be published. Of course, all of the figures can be published, but the names of the applicants and indeed the non-applicants who received grants need to be published, and those too can be redacted. Consequently, redaction is not a reason for not putting these reports onto our website. The second reason the Solicitor General relies upon is, she says, that neither report has yet been laid before the House of Assembly. And she put it in a number of ways. She said that it is the tradition that reports are not disclosed before they are so laid. It would be discourteous to the House of Assembly, she submits, if the COI was now to publish these reports on its website. She, in my view, rightly does not rely upon Section 16 of the Audit Act. She relies only upon Section 20, to which I've already referred. She submits that there will be a breach of that section if the reports are now put onto the web. I have to balance the public interest in and other interests that might exist in either putting the reports onto the website or alternatively not doing so. The only reason for not publishing them in full is that the procedural step under Section 20, subsection 2 of the Act has not yet taken place. I do not agree with the Solicitor General that it will be a breach of Section 22 by publishing the reports or any information in the reports now. But in any event, insofar as there is a tradition or even possibly a privilege in a parliamentary privilege in these reports before they are debated in Parliament, that is a matter which has already been given away because no one, as I've explained, has objected to these reports being fully discussed in an open hearing as they have yesterday and today. Any publication would not, in my view, show any discourtesy to any of the institutions in the BVI, either to the Governor nor to the House of Assembly. As I've indicated, no one in the House of Assembly, including the Speaker, has sought to constrain any form of publication of the reports or any information in the reports. On the other side of the balance, however, is the importance of the public being able to understand the work of the inquiry. Not to publish not to put the reports on the website now will leave the public with an incomplete picture. The complete picture can be given. A complete picture of the evidence given by the Auditor General can only be given if these two reports are made available to them. Because they have already been referred to extensively in public, it seems to me that they should now be put onto the website, and I will direct that they are published on the COI website with appropriate reductions, both in respect of all personal data and also the names of the religious institutions, etc., in the other report. Good. Anything else, Mr. Rowett?
That's our business for today. We start again tomorrow.
At
I think it's 9:30.
At 9:30. Good. Thank you very much. Thank you, Solicitor General.
Wait, Mrs.